Stopping the share now.
Good morning, all. I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow commissioners Susan Duffy and Commissioner Andrew French. I'm convening this hearing in docket number 22-EKME-254-TAR in the matter of the application of Evergy Kansas Metro Inc., Evergy Kansas South Inc., Evergy Kansas Central Inc., for approval of its demand-side management portfolio pursuant to the Kansas Energy Efficiency Investment Act, or the KEEIA, found at K.S.A. 66-1283 at SEC. We are conducting this hearing by Zoom and broadcasting to the public on YouTube, so please bear with us should we experience technical glitches. Let's turn first this morning to the entries of appearance. I'll turn first to Evergy. Your microphone is muted.
Well, I'm off to that start. Okay, good morning, commissioners. This is Glenda Kafer appearing on behalf of Evergy.
Thank you.
This is Michelle. I am off your computer, so it should be ready for you again. Okay, great.
Michelle, you need to mute your
Michelle,
line, please.
Oh, sorry, I thought I was muted. I had muted me, and I don't know if some.
There we go. All right, on we go. Atmos, Black Hills, and Kansas Gas Service.
Good morning, James G. Flaherty, Ottawa, Kansas, appearing on behalf of the interveners Atmos Energy and Black Hills Energy, and James Flaherty and Robert Vincent appearing on behalf of the intervener Kansas Gas Service.
All right, thank you. The Sierra Club and Kansas Appleseed.
Good morning, Teresa Woody appearing on behalf of Sierra Club and Kansas Appleseed, and with me is Justin Simlowski.
Thank you. Climate and Energy Project.
Morning, everybody. This is Tim Laughlin. I'm appearing on behalf of Climate and Energy Project today.
All right, thank you. NRDC.
Good morning, everyone. Robert Titus appearing on behalf of the NRDC.
Curb.
Good morning, and may it please the commission. Joseph A. Shep on behalf of the Citizens Utility Ratepayer Board, and I will be doing the majority of the hearing with cross-examination. And also entering their appearances today are Consumer Counsel David Nickel, who will be given the opening, and Attorney Todd Love. Thank you.
Thank you. KIC.
Good morning, commissioners. Good morning, everyone. Jim Zakora of the firm of Fulson Seepkin, and with me is my colleague Connor Thompson, appearing on behalf of KIC. Thank you.
Thank you. KCC Staff.
Good morning, commissioners. George Evans, Carly Massantini, and Walker Hendricks appearing on behalf of commission staff and the public generally.
All right, thank you all. Let's turn to notice. Does the staff have a recommendation regarding notice?
Yes, it does. On January 6, 2022, the presiding officer issued an order setting procedural schedule which set the evidentiary hearing for June 7th through June 9th, 2022 from 9 a.m. to 5 p.m. There, the procedural schedule was modified after a second joint motion to modify procedural schedule was filed April 15th, 2022. On April 18th, 2022, the presiding officer set the evidentiary hearing for August 9th through August 11th from 9 a.m. to 5 p.m. in the commission's presiding officer order granting joint motion to modify procedural schedule. The hearing dates were reaffirmed in the commission's revised presiding officer order granting joint motion to modify procedural schedule issued April 19th, 2022. The order was properly served upon all parties to the docket 10 days prior to the proposed hearing date, consistent with the Kansas Administrative Procedures Act. The parties have conferred at a pre-hearing conference and engaged in communications relating to hearing procedure for a hearing beginning on today's date. Staff knows the parties appear today in person online and therefore recommends a finding that notice was proper and that the commission has jurisdiction to hear this matter at this time.
Are there any objections to notice? Hearing none, I find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Pardon me. Before we turn to preliminary matters, let's review a few matters incidental to the conduct of hearings via Zoom. First, if any party encounters any technical issue today, please ask to go off the record so that we may try to resolve the technical issues off the record. Second, witnesses participating by Zoom are asked to keep their microphones muted until they are scheduled to speak. Third, if the commission needs to deliberate, we will go off the record, enter a Zoom breakout room where you cannot hear or see us, and then return. Fourth, there may be occasions during this hearing when we may consider issues that include matters which have been classified as confidential. If and when these confidential issues arise, we will move this hearing off YouTube and into a breakout room, which will only include individuals who have executed the confidentiality agreements found in the Commission's protective and discovery order. I encourage the parties and staff to notify me if and when there are issues that will fall into this category. Finally, we are anticipating the examination of 20 witnesses in this proceeding. As a result, we must collectively strive to make the most effective and efficient use of the time that's allotted for this hearing by keeping cross-examination questions relevant, germane, and as succinct as possible in fairness to all parties and in the interest of an orderly process. All right, very well. Are there any other preliminary matters that we need to address?
Chair Keen, Tim Laughlin with CEP. At the pre-hearing conference, we submitted a proposed motion to admit the evidence of Justin Schott via signed declaration. That proposed motion did not receive any objections. So at this time, I would like to ask the commission to approve that motion. And I believe I sent it to the party, the final motion, last night. I'm not sure if we can pull that up, but that's the only preliminary matter from CEP.
Is there any objection to Mr. Laughlin's motion? Hearing none, it's approved. Thank you, sir.
Thank you.
Any further preliminary matters?
Yes.
K.S.A. I'm sorry, go ahead, Ms. Kafer. Excuse me.
We have a pending motion to strike the testimony of K.I.C. witness, Mr. Meyer, that I don't believe has been ruled on unless I didn't see something.
That's Ms. Kafer, that's what I was going to raise as well.
All right.
Ms. Kafer filed her motion on Friday. We filed a response on Monday, and it's fully briefed and before the commission.
Okay. Ms. Kafer, give us the essence of your motion, please.
Yes, the commissioner's procedural schedule had direct testimony to be filed last June 17th. Cross answering was June 24th. The settlement testimony or testimony supporting or opposing the settlement was set to be filed August 3rd. KIC did not file any direct rebuttal testimony. On August 3rd, they filed the direct testimony of Mr. Meyer, which did not oppose or support the settlement. It didn't even mention the settlement. It put forth their direct case objecting to terms that were included in Evergy's initial application and responding to the direct testimony of one of the staff's witnesses, which constitutes cross-answering testimony. The commission's regulations on settlements require a party to file their objection to the S&A, and whether that's done with a formal objection or with testimony objecting, KIC didn't do that. So we've requested that the testimony of Mr. Meyer be stricken. It is not only a violation of the process that the commission's established, but it's also prejudicial to the parties when this type of thing happens, because we're not allowed to conduct discovery on the testimony or the position of one of the parties or the assertions that are made by that party. Evergy in this case has the burden of proof, but allowed to file rebuttal to this testimony. It required the parties to go through settlement negotiations without being aware of what one litigant's position was in the case. And so we've asked that.
All right, thank you. Mr. Sakura, please.
We disagree on every point, both in fact and law, with Ms. Caper. We complied precisely with the commission's ruling. The testimony is labeled direct. It could have been called something else, but it is in exactly in response to the commission's order in this case. It's also in compliance with the regulation that governs how the commission deals with settlement. We have set each of those items out in our responsive brief. We participated fully in the settlement. There's no question. They knew our position in the settlement. We have every right to file testimony under both the regulations and commission practice, which we did. The testimony is limited to the settlement. The position of Evergy that if you don't file direct, you cannot file testimony in a settlement is just wrong. It's wrong both in fact and in law. Evergy cites no legal precedent or case law precedent for their position. We cite the law for the position. We cite the facts. By its essence, a settlement is not the application. And so we believe we have every right to file the testimony. It was filed. It's not lengthy. It's a single issue testimony, and it was presented in good faith in accordance with every regulation and every directive of the commission.
Ms. Caper.
Yeah, the only thing that needs to be responded to there is the allegation that Evergy's taken the position that you can't file testimony on the settlement if you didn't file any direct or cross answering. We haven't asserted that. That isn't our position. But our position is that if you have a direct case, then you need to file it in direct testimony. You can't withhold it until the time of settlement testimony. And that's what happened here. It was not testimony directed, and as I said, didn't even mention the settlement agreement or the terms or anything like that. It was direct testimony and cross-answering testimony.
All right, thank you. Mr. Segura, I'll allow you further rebuttal if you wish.
We reassert a position which we stated in our written brief that we follow precisely the commission's regulations. It's not testimony with regard to the application at all. It's testimony with regard to the settlement, which both the KAR provision, commission precedent, and due process allows us to participate. And we filed, to the best of my knowledge, we did everything in compliance with both the law and the commission orders. And we urge the commission to allow the testimony to come into the record.
Very well. I have reviewed both the motion to strike and Mr. Sakura's response. I've tried to listen attentively to the differing views that each of you have presented. As I look at it, although captioned as or even labeled as direct, in effect, it is responsive testimony offered in opposition to the settlement agreement. In any event, the commission will ultimately be the arbiter of the relevance and weight that's going to be assigned to this testimony. Accordingly, I'm going to overrule the motion and allow the testimony. Are there any further preliminary matters for us to take up this morning?
Yes, Chairman, on behalf of Evergy again, I have an objection to the process for conducting cross-examination that's been sent to us by the hearing officer. My objection concerns the fact that the process does not allow any recross of witnesses after commissioners conduct their questioning. This is a change from the way that this has been done for many, many years at the commission, where because commissioner questions can elicit quite a bit of additional information from a witness. And so parties have been allowed to conduct additional cross that has to be limited to what the commissioners brought out through their questioning, but it prevents a witness from putting into the record testimony that can be extensive, can be very questionable, but putting that in without it being challenged or even the opportunity for a party to ask questions about it to try and clarify it if it's not clear. It's especially troublesome in this case because an applicant, in this case Evergy, has the burden of proving that the application should be approved, and that normally carries with it the right to open and close, and the commission's regulations reflect that as well, the app 82.1.230. And while I recognize that that regulation also grants flexibility, it sets the guideline as being that the applicant would open and close, having the last word. In this case, we have a couple of witnesses who are very, Mr. Rabb for the gas companies and now Mr. Meyer on behalf of KIC, who can be asked questions by the commissioners who can say anything they want. And even though Evergy has the obligation or the burden of proof, that testimony would remain a part of the record, something the commissioners could rely on in their order, and yet never be subject to any questions from the applicant, Evergy. I submitted, when this came out yesterday, I did submit 3 exhibits that could also just have administrative notice taken of them. I marked them as exhibits because I thought that would be more convenient, but just to illustrate that historically, one of the exhibits is from a number of years ago, 2011, I believe, one from 2015, and another from 2018, showing that at least up until that time, the process has allowed the parties to conduct recross on commissioner questions, limited in scope to commissioner questions. And so I don't know when or why that process changed, but I do believe that it undermines the record, and it certainly damages the applicant's ability to carry its burden. And I'm requesting that be reconsidered today if that's the process we still were intending to follow. Thank you.
Okay, very well. I was alerted by David Cohen as to the the nature of your concern, and I've tried to listen attentively as you have described that concern in some detail. I'll simply say this. I've been a member of this panel for approximately 4.5 years. I've been a part of numerous hearings on a variety of subjects. I don't recall a single instance during that time period when there was absolutely written into the record that there would be recross. But that really isn't germane to me. What is germane is what is required for us to provide a complete record. That is what is relevant. The completeness of the record is what we're about here. In my view, all parties have had the ample opportunity to review all witness pre-file testimony and prepare and propound questions for witnesses through cross-examination. At the conclusion of all cross-examination, each party proffering the witness is provided with the opportunity for redirect examination based upon all cross-examination, whether from commissioners or otherwise. And Evergy alone has 7 witnesses. We have roughly 1/3 of all the witnesses are Evergy witnesses, and there is this provision for redirect available in each of those instances. Altogether, I think within the confines of the time that's allotted for this hearing, and again, I'll restate, we are scheduled, as I did at the outset, we are scheduled to hear from 20 witnesses. So this hearing is by definition somewhat time compressed and constrained. Under all of these circumstances, and with ample opportunity for cross-examination, recross, in my opinion, would not be beneficial or necessary to afford all parties adequate opportunity to examine witnesses and provide for a complete record in these proceedings. Furthermore, at the conclusion of the hearing, all parties may file post-hearing briefs in the case of Evergy, you will have the opportunity to file 2 post-hearing briefs, an initial brief, and after all other briefs have been filed, a rebuttal brief. So ultimately, in that sense, you will certainly have the opportunity to have the last word before the record is closed prior to any commission decision. For all of these reasons, the request or the motion for recross-examination is denied. Are
If
there
I
any?
may, if
You
I
may.
may for the record, then I would just like to state that the entire purpose of my motion objection was what the chairman said, was to have a complete and accurate record. That was the only goal. That the allowing redirect does not address the problem. For example, it can only exacerbate the problem because it not only prevents Evergy, for example, from addressing any of the things that Mr. Rabb, the gas company's witness, may say during commissioner questions, but then it allows KGS to redirect to make the problem even potentially worse. And third, we are allowed to file briefs, but we are only allowed to use what's in the record. And if we haven't been allowed to put that into the record at hearing, then we cannot put it in the brief. Thank you. I appreciate the commissioner's time.
Absolutely. Your concerns noted. Are there any further preliminary matters that we need to address?
Yes, Kcc staff has a preliminary matter to address.
Please.
Last night, staff sent out exhibits 1 and 2, and we have an outstanding question regarding their confidentiality. These are two
Sorry,
staff.
Mr. Jevons, could I have you move closer to a microphone?
Can you hear me better now?
Yes, thank you.
Okay. These are staff's only 2 exhibits, and together are 4 pages in total. They are directly relevant to staff's position in this document, in this docket. As well, to my knowledge, no parties have objected to the admission of these exhibits. So we request that the commission permit their entry into the record given the IT issues we experienced in creating them. And then again, to the confidentiality issue, we want to ensure Evergy is able to either label them public or confidential. And if a confidentiality label is needed on these exhibits, then we would need to go into closed session when we introduce them during cross-examination.
Okay, so Mr. Jevons, as I understand it, an underlying reason for you doing this and requesting this admission at this time is due to some IT difficulties that you were presented with. Is that correct?
That is correct.
All right. Is there any objection? Without objection, they're admitted. Any other preliminary matters?
We can, it is fine to, those aren't confidential. You can make them public.
Okay, thanks for clearing that up.
I'm sorry. We're kind of talking over each other in here in the interest of my understanding and the reporter accurately reflecting what we were saying. I think I picked up the statement by Ms. Kafer that these documents are not to be treated as confidential. Is that correct? Mr. Jevons, I did not hear, Mr. Jevons, I did not hear your response.
I just said thank you for clarifying that confidentiality.
Very good. All right, thank you. Is there, we've already admitted them. All right. Any other preliminary matters?
Yeah, Mr. Chairman, this is Jim Flaherty on behalf of the gas utilities. We'd like to move for the admission of gas utilities exhibit number 1. That's Evergy's response dated August 1st, 2022 to KGS's 004 data request. Evergy indicated it had no objection to the exhibit being admitted, and by doing that, we will not have questions for many of the Evergy witnesses. Each party in the commission received a copy of the exhibit this past Monday before noon. So we'd ask for that admission of gas utilities exhibit number 1.
Is there objection? Hearing none, they are admitted. One thing I would request of you, Mr. Flaherty, if you would, I'm going to, in the case of each instance where at least my script provides for your cross-examination. I'm going to still recognize you, and then if you care to pass, that would be probably the best way to do it. That way we can identify those that you wish to cross and those that you don't wish to cross.
Sure, thank you.
Okay, very well. Any other preliminary matters we need to take up? Commissioner Duffy.
Yes, Mr. Flaherty's exhibit. I don't know that I received that.
I sent it to Mr. Cohen, and I'm
On
assuming
Monday?
Mr. Cohen, yes, Monday at 10:30 in the morning. I'm assuming Mr. Cohen provided that to you.
I sent it to Sally, but I'll send it along to the commissioners just to be sure.
Okay, if you would, I'd appreciate it. Thank you.
All right. Any further preliminary?
Yeah, sorry for interrupting. Tim Laughlin.
Right.
We would like to admit we have 9 exhibits.
Mr. Nelson, pardon me. Would you be closer to your microphone also? I'm having a difficult time picking you up, and I suspect the court reporter as well.
Is this any better?
Seemingly, please.
Okay. CEP would like to admit it's 9 exhibits. 7 of them are responses to discovery requests by Evergy. We received 5 of those, or 6 of those, on Monday, and in anticipation of our cross of Mr. Glass, we just want to make sure that he had reviewed them. We weren't sure if he had, so we just want to have those available just in case he hadn't. And then 2 of the exhibits, one is a report from the International Energy Agency, and the other one is a Kansas benefits of electrification report. So we would ask that those exhibits be admitted as well.
All right. Is there any objection to the admission of these exhibits? Hearing none, they are admitted. All right. Any further preliminary matters any parties wish to take up? Who's speaking?
I don't know. Yeah, this is Linda Cave with Evergy. I don't know if this is a preliminary matter. I'll bring it up now so I don't miss my opportunity instead of later when my witnesses come up. But Evergy's application included its report that was it was sponsored by a number of witnesses who were indicated in the report, and I will be asking that, or move to put that into the record at this time because there's not a specific witness that will be presented for that purpose. Additionally, within that report, there's a reference, a cite to, and a hyperlink for the 2020 ACEEE report. And I was told that I should make that an exhibit if I was going to ask questions on it. And so I did, and I submitted that as Exhibit 1, Evergy Exhibit 1. And I'd like to request that both the report with the application and then the ACEE report that we've marked as Exhibit 1 be admitted.
All right, very well. Is there any objection to the admission of these matters? Without objection, they're admitted.
Thank you.
Any further preliminary matters for us to address from any parties? All right, well, let's turn then to the procedures during the hearing. This hearing is going to address 2 non-unanimous settlement agreements. To say the very least, today, perhaps tomorrow as well, are going to be very full days. At a minimum, it is my intention to make it through the examination of all Evergy witnesses today. Each party has been previously informed of the time that's being allotted for your opening statement, so I'm asking you to please stay within your allotted time. I requested that David Cohen, Commission Counsel, provide you with an indication of the time when you approach the time limit so that you can be advised of that, and he will do that accordingly. Mr. Zakura, did you have a... It's difficult with the screen to try to kind of figure out all the different movements here on the screen. I understand that the parties believe that we can conclude this hearing through the close of business tomorrow. Be assured that it is our goal that we strive to achieve that objective. Let's turn now to the opening statements. First, Evergy, Ms. Kafer.
Thank you and good morning, commissioners. We're here before you today with another proposal from Evergy requesting approval of, well, I'm sorry. Can I get my PowerPoint put up so that I can start with that?
Yes, Michelle, could you do that? Or Denise?
Good morning, this is Denise. I'm sorry, Glenda, could you repeat that? What is it you need?
Yes, my PowerPoint that I submitted to put on the screen during my opening statement.
Oh, I apologize. I do not have your PowerPoint presentation.
I gave it to Michelle. I'll send it to Denise as well.
Yes, please send it to me and I can get that up. Thank you.
Glenda, I thought you were just going to be sharing your screen. But
Okay, so you'll hand it
Just
over
a
to me.
second, I'll have that up for you.
all right, it's been sent.
There it is. Okay, good. And then I have control here.
Glenda, it appears to be up.
Okay, and
Just let me know when you're ready to advance slide.
okay. Oh, so I need to tell you to change the slides?
Yes, because you won't have control of it because it's running on my computer.
Okay, well, let's start again then. We're here before you today with another proposed DSM application from Evergy that's requesting approval of a portfolio of DSM programs for Kansas. And just out of curiosity, I went back and looked at how many times I have presented DSM related dockets to the commission to try and get energy efficiency moving forward in Kansas in the past, beginning with 2004 and KCP&L's comprehensive energy plan. There have been quite a few of them. I think it's around 10, and my record of success on those is dismal, to say the least. But the world has changed a lot in this last 18 years, and especially in the last 10 years. And programs and technology have evolved in that time. We have gathered massive amounts of information and data that's been used to develop very reliable data on energy savings. There's been experiences in other states that moved ahead of Kansas with energy efficient, and that experience is abundant and has been used to help inform the proposals that we presented to the commissioners in this application. And importantly, the country's understanding and perception of DSM has gone from reluctance initially to acceptance now, and with many customers who are even insisting on having these programs as an option available to them. So we're here trying again, and Evergy has proposed a portfolio of programs for approval. There's 9 programs. 4 of them are residential, 4 of them are business programs. One of them applies to both. It's called the Pilot Incubator Program. And like previous DSM applications, Evergy's proposed a financial recovery mechanism that includes a component for recovery of program cost and a throughput disincentive component to recover revenues that are lost as a direct result of implementing these DSM programs, and an earnings opportunity component that allows the company to earn on its DSM investment the same as how it would earn on a similar investment in supply side resources. And these 3 financial components, which are what Mr. Darren Ives with the company commonly refers to as the 3 legs of the stool, the DSM stool, they're necessary for Evergy to go forward to voluntarily implement this DSM proposal. Because what is while the proposed programs are beneficial to all of Evergy's Kansas customers, they're not in the interest of the company's shareholders unless recovery on all three components is provided for. And when that recovery is provided for, the programs are still beneficial to all of Evergy's Kansas customers. So Evergy's filing last December included an application, the direct testimony from Mr. Chuck K.S.A, and then the report that we've had admitted into the record already during preliminary matters. It was called the Evergy KEEIA 2023 to 2026 Demand Side Management Portfolio Filing, and I will just refer to it as the Evergy KEEIA report or the report. And that report described in detail the development of the proposed programs and their terms and their goals and the financial recovery mechanisms that have been proposed. Appendix H of that report identifies the Evergy witnesses who support each section of the report. And then you have also been provided pre-filed rebuttal testimony from Evergy's witnesses, Kim Winslow, Brian File, Natalie Gray, Tim Nelson, Mark Foltz, Darren Ives, and Chuck K.S.A. Slide 2, please. So I want to summarize the DSM proposal as it was filed in the application, and then I'll review how the settlement modified it. Slide 3. First, the programs. As stated before, there were 9 programs. 4 of them are residential with a proposed budget of $52 million. 4 of them are business programs with a proposed budget of $75.7 million. And then there's the pilot incubator that's both, that had a budget proposed at $7.1 million. Next slide. As you can see, in each of the 4 residential programs, there are multiple ways for customers to engage in these programs. While there's a lot on this slide to absorb, I just want to hit on a few key highlights from each area to give you a sense of how these offerings work. The whole house is split into 3 components, with the easy kits and assessments to get customers engaged, which, you know, think in terms of the free power strip and the weather stripping. The home energy education, education, that is the foundation for helping customers to be informed about their energy cost and find the right solution for their situations. Demand response, this proposal is today's version of Evergy's former Watt Saver or their optimizer programs. It helps the grid and the community by managing energy demand on the peak or on high price days. The homes hard to reach. There's been a considerable amount of attention targeted in these proposals to income eligible customers through education, energy efficiency measures, and financial incentives. Next slide, please. There has been some strong stakeholder interest in on-bill financing options. And so the on-bill financing model, it helps customers overcome the barrier of the initial cost of investing in energy efficiency, where Evergy finances the purchase of the more efficient equipment that's installed, and then the customer pays that back over 5 to 12 years via a charge on their utility bill. And this model is structured so that the savings from the more efficient equipment that was installed covers the cost of the investment. This is a program that's open to renters as well as homeowners, and no credit check is required. So it overcomes that barrier as well for customers. As you'll see later when I go through the summary of the settlement provisions, the on-bill financing model, the parties agreed that we would use the PAYS program for this, which is the program that's been in effect and is used in Missouri. Next slide. Evergy's program set includes a dedicated focus on customers who are underserved. These offerings take new steps to engage at a community level with local trade allies, existing organizations through Lily's and Evergy locations. Weatherization would be expanded, and Evergy will continue its bill pay assistance work. Next slide, please. Now, here are the business energy efficiency programs that were proposed in the application. The goals and the terms of these programs are very similar to the residential counterparts that I just went over. The business hard to reach programs is designed for small businesses and nonprofits. Next slide. The pilot incubator program is the one that covers both business and residential. It's available for customers to submit, or customers or other interested parties or stakeholders to submit programs to Evergy, DSM programs, to be considered and studied for potential adoption. This is a program that's been available in Missouri for a number of years, and it has led to some positive results there. Next slide. So Kansans are interested in DSM. This is evidenced by the active interest and participation that we've had in this docket by interveners CURB, CEP, Sierra Club, Kansas Appleseed, and the Natural Resource Defense Council, or NRDC, as well as the many public comments that were submitted in writing and in person at the public hearing that the commission held, a great majority of which were supportive of the application, and many that said that even more needed to be done than what was proposed at this time. So the parties to the case, we spent 3 days in settlement negotiations, and it was worth it because it resulted in 2 separate partial non-unanimous settlement agreements, one for the programs that would be available, and then one addressing the financial recovery terms. Evergy, CURB, CEP, Sierra Club, Kansas Appleseed, and the NRDC are signatories to both of those settlements, while staff is a signatory to only the program S&A. Compromises were made by all the parties in both of the settlement agreements. Nobody got what they really wanted. Even so, staff was ultimately unable to accept the financial recovery terms that the other parties reached agreement on. The agreements are not perfect, but they are solid and a fair way to get started here. And both of the settlements have to be approved for the DSM programs to be implemented. Next slide. So under the settlement, I'd like to highlight just some of the differences from what was initially proposed. First, the overall budgets and the saving targets were changed. The DSM portfolio still has a 4-year budget with the same 9 programs, but the budgets are only 72% of the filed budgets. There are provisions that the budgets for certain programs can be increased up to 90% of the filed budget if they meet certain metrics in years 3 and 4. The savings targets are aligned with the new settlement budgets, and it was agreed that if Evergy changes the portfolio budget by more than 10% on an annual basis, then it needs to file that with the commission and get commission approval. Importantly, the portfolio program design continues to pass the total resource cost test with the S&A budget and savings incorporated into the analysis. Next slide. On residential programs, the hard to reach homes program, the budget was set at 10% of the total portfolio, with 5% of that directed to weatherization. This is one that the budget can be increased in years 3 and 4 if effectiveness is demonstrated. We have a collaborative process that we've agreed to where we're going to establish and define effectiveness for these programs and the criteria that we'll use to determine an appropriate budget in the future. Work together with the parties to establish the hard to reach reporting requirements, and the impact and performance to the metrics will be evaluated at the 18th month mark for this. Next slide. We talked before about the on-bill financing. We agreed to use the PACE program that's being used in Missouri. A number of the stakeholders were familiar with that program because they're involved in Missouri, and they preferred it. And so we agreed to go with that program. We also incorporated some additional protections for customers adopted into the PACE program that will institute in Kansas. They can they were focused on notice to like subsequent owners or renters, treatment of bad debt, and disconnect issues. Next slide. Other modifications to the residential programs on the whole home efficiency. We removed the residential retail screw-in LEDs from that program. On home demand response, we kept that proposed budget and targets. The residential energy education, Evergy agreed to develop a marketing plan within 6 months with budget detail consistent with the previous docket, in terms of the previous docket on how we would do that. And we also agreed that the residential and business education budgets would not exceed 5% of the total portfolio cost. Next slide. On the business program modifications, we reduced that budget by 33%. And again, Evergy agreed on this to develop a marketing plan within 6 months with budget detail. We can unlock remaining marketing budgets for some of the programs in here in years 3 and 4 if those programs meet certain metrics. And again, as I said before, the budgets for education won't exceed 5% for business, combined business and residential education budgets. Next slide. On business demand response, we kept that proposed budget and the targets as proposed. Under the whole business efficiency, we removed the business new construction component. Next slide. The hard to reach business program, we removed the business comfort component. We agreed to hold in reserve business comfort, enhanced business comfort components for years 1 and 2, pending redesign by Evergy, and then Evergy can request that request these for years 3 and 4. We agreed that we'll evaluate the impact and performance to metrics at the 18-month mark again and get commission approval on that, and that Evergy will conduct business customer research within 12 months to gauge interest on these programs. Next slide. On the pilot incubator, we reduced that budget in the agreement by 80% in years 1 and 2, but we can unlock the additional amount of that budget in years 3 and 4 if certain metrics are met on that program. Evergy agreed that it would provide funding within the program to train workforce development specific to multifamily properties and to do research to analyze customer energy efficiency and disconnection data to better evaluate the impact there. And Evergy agreed to target for participation in the hard to reach programs customers who have a history of delinquent payments or disconnects. Next slide. The program S&A also had provisions for evaluations and approvals. We had agreements on the staff's auditor, commission approval of the EKME methodology, and on retroactive application of the TRM savings values and true up based on the year one evaluation results. Evergy will provide stakeholders access to the program tracking databases as part of the agreement, and we agree the commission review of the PAYS tariff would be under an expedited process, which we've defined as 90 days. Next slide. The collaborative process in the programs agreement, this was a very important part of the agreement to many of the stakeholders in allowing us to be able to reach agreement on everything in both of the settlement agreements. We developed a collaborative process for working with everyone on KEEIA issues once this filing is approved, and will be geared towards providing the commission with a recommendation on those issues 12 months before the next phase of KEEIA is presented. We'll be looking at such things as decoupling, rate design, modifications, accelerated depreciation as part of that process. Next slide. This slide hopes to illustrate for you the differences in the filed budgets and the application and megawatt savings there compared to the settlement budgets and the energy savings. So provided that, hopefully that'll be a helpful summary for you. Next slide.
Linda, you got 30 seconds.
Okay, well, the financial recovery provisions, as I said, the program carrying costs, the throughput disincentive, and bringing opportunities were proposed by Evergy in the application. We did make compromises in program carrying cost by using the short-term, long-term hybrid approach for carrying costs. Staff have recommended short-term debt costs, but the compromise reflects that both the short-term and the long-term financing is used for obligations that are greater than 12 months, which is what the case is here on the 18-month lag in the DSM program cost recovery. The throughput disincentive will recover the revenues lost as a result of DSM programs. And we did agree to a sunset of kilowatt hours lost revenue 4 years after the measure is installed.
Your time has expired.
On earnings opportunity, we accepted staff's earnings opportunity matrix structure with a minimum, maximum 75, 125 percentage target. Earnings opportunity dollar amount is based on 18% of the net benefits, and Evergy agreed that the earnings opportunities for the hard to reach programs will be based on first year cumulative incremental kilowatt target. So with my time up, I guess I just need to present my PowerPoint for the commissioners. And thank you for your time and attention.
Thank you. Thank you for your excellent overview there, Glenda. We appreciate it very much. Next opening statement will be on behalf of Black Hills, KGS, and Atmos. Mr. Flaherty.
Yes, good morning, Mr. Chairman, and good morning, commissioners. And let me apologize for my voice. Woke up this morning and I started sounding like this, so I apologize for that. So hopefully it's not too annoying. But the gas utilities in this case, Atmos Energy, Black Hills Energy, and Kansas Gas Service, object to just one section of the settlement relating to the programs, which I'll refer to the program settlement. And if you're keeping track, that one section is section 2, paragraph 4, B, A, double I. Specifically, the gas utilities object to that portion of the referenced paragraph that allows Evergy to implement the business comfort measure of its business comfort HVAC without restricting the implementation of that measure to a like-for-like replacement. In other words, an electric appliance replaced with a more efficient electric appliance, or as stated by Evergy in its residential tariff, incentives for efficient heating systems will be only for the same as existing technology. Under the KEEIA statute as implemented by this commission, demand side program covered by the statute and conducted by the electric utility must result in a reduction of the net consumption of electricity by the participating retail customer. DSM programs should not be used to grow load. Because Evergy's Business Comfort HVAC program allows for Evergy to offer a ratepayer-backed heat pump rebate to an Evergy business customer who has a natural gas furnace heating system, the program will, in that case, increase and not reduce the net consumption of electricity by that customer, and therefore the program does not conform with Kansas law. Whether a settlement conforms with Kansas law, as this commission knows, is one of the factors the commission must find in determining whether to approve a settlement. The program settlement can be easily fixed, so it conforms to Kansas law. The gas utilities request that the commission require Evergy to include a like-for-like program restriction for Evergy's proposed whole business efficiency and hard-to-reach business program measures before approving the program S&A in using the identical language that Evergy used for its residential energy efficiency tariff. The gas utilities are submitting the testimony of Paul Robb, including his direct, his cross, and his testimony in opposition to the program to support its position in this matter. The gas utilities request that the commission grant their objection to the portion of the program as set forth in the objection it filed with the commission and in the testimony submitted by Mr. Robb. Thank you.
Thank you, Jim. Next will be Sierra Club and Kansas Appleseed. Ms. Woody, please.
Thank you, and good morning to the commissioners and everybody here. The Sierra Club and Kansas Appleseed support both the program and financial settlements that are before the commission today. These settlements, we believe, taken together, are in the public interest because they bring at last an energy efficiency program to Kansas. That this is a program that's long overdue and to a state that it's one of the very few that hasn't implemented such a program to date. We support these settlements because they have the dual, from our perspective, they have the dual effect of both lessening the energy burden on lower income consumers, as well as providing environmental benefits by, at the end of the day, reducing the reliance on energy. Sierra Club and Kansas Appleseed are particularly interested in the Hard to Reach Homes program. And that is a program that's designed to assist lower income customers. With respect to the percent of total portfolio, it's 10% in the first 2 years, with the opportunity to grow beyond that 10% in years 3 and 4 if Evergy can show additional effectiveness. That 10% is split between weatherization and non-weatherization programs. Those non-weatherization programs include such things as improving HVAC systems, also improving appliances, things of that nature that will reduce in the long run energy cost to lower income consumers. Another portion of this settlement agreement that we're particularly interested in the hard to reach homes is the fact that there will be a specific income eligible multifamily component, which means that these energy savings will be available to tenants, not just to homeowners. And we think that's a very important element of the settlement and will help these benefits reach many more people, and especially those who are at the lower end of the income levels. Initially, the eligibility for the programs will be up to for households earning up to 200% of the federal poverty level. And going forward, as part of the collaborative process, the parties are going to consider including additional households at percentages above 200% of poverty level, allowing it to reach even more consumers. The other thing, the other element of the settlement agreements that Sierra Club and Kansas Appleseed are particularly supportive of is the collaborative process. This will institute reporting requirements, and it will also allow the parties to consider additional programs, the effectiveness of the programs, and make recommendations to improve those programs. We've seen this on the Missouri side. These programs have become very robust and very effective. And so it's our hope that through this process, these programs will become even more robust and address even more consumers. And another important part of that collaborative process is that within the 12 months prior to the next portfolio cycle, there will be a collaboration among the stakeholders with respect to such things as decoupling, alternative methods to support energy efficiency, and so forth. So with respect to all of these, with both of these settlements taken together, we believe that this is something that's needed for Kansans, and that is a great opportunity for this commission to finally implement these programs. And we urge the approval of both the program settlement and the financial recovery settlement. Thank you.
Thank you, Ms. Woody. Next opening statement will be for the Climate and Energy Project, Mr. Laughlin.
Yeah, good morning, commissioners, stakeholders, and all those viewing on YouTube. Climate and Energy Project supports both the settlement agreements for the energy efficiency programs and the financial recovery. So over 15 years ago, Climate and Energy Project began advocating for cleaner energy. To reach this goal, part of CEP's initiative has been to advocate for energy efficiency measures in the state of Kansas. Energy efficiency is generally regarded as a least cost resource, provides a vast array of benefits to the utilities and their customers, as well as to program participants and society as a whole. As customer Robert Rutkowski of Topeka stated, I quote, "Energy efficiency is literally the most affordable, safest, and cleanest way to meet energy demand," end quote. CEP would agree with Robert's sentiment. So just to give you a little history on our neighboring state, Missouri, back in 2013, Missouri started its own cost-effective DSM energy efficiency program. During that year, the American Council for Energy Efficient Economy, otherwise known as ACE, ranked Missouri as 44th in the nation for energy efficiency policies. Today, after almost a decade of implementing its energy efficiency program, Missouri now ranks at 33rd. And like I said, it's much to the credit of the progress and innovations created by MEA. So that's the equivalent of KEEIA here in Kansas. Today, MEA has helped save Missouri customers millions of dollars in energy costs. As the testimony of CEP's retained expert James Owen stated, Evergy's Missouri energy efficiency portfolio resulted in 900 million kilowatt hours saved between the years 2013 and 2019 alone. That's the equivalent of taking 142,000 cars off the road and reduced emissions. Additionally, and despite Evergy implementing a financial recovery mechanism similar to the one proposed here, Evergy customers in Missouri have still seen $2 in benefits for each dollar spent by Evergy in its Missouri energy efficiency program. Finally, in Evergy's most recent EMMB for its cycle 3 in MEA, Evergy's Missouri programs resulted in over 123.2 million in energy savings, 91,010 in demand savings, and 47.3 million in customer benefits, with a 1.27 total portfolio TRC. Evergy's Missouri program has impacted over 370,000 customers, 2,200 businesses, and powered over 74,000 homes with energy saved between 2013 and 2019. So clearly, on a large scale, Evergy's DSM and energy efficiency programs in Missouri have made a drastic and positive impact on its customers. As we all know, moving over to Kansas, in 2014, KEEIA was codified, It was passed by the Kansas State Legislature. However, when we look at comparison between Missouri and Kansas, the results that followed the passing of KEEIA couldn't be more different. In 2014, ACE ranked Kansas 40th in the nation for energy efficiency policies. Today, Kansas has dropped to 47th place, mostly because it's being outpaced by states who are improving the way they save through DSM energy efficiency policies. Despite the legislative framework of KEEIA being placed for almost a decade, there's been little to no movement on implementing energy efficiency programs in Kansas. Energy efficiency programs like the one proposed here by Evergy will make an impact on individual customers, such as Maddie Bell. Maddie submitted a public comment, and she resides in Lawrence, and she has memories of winters where coming inside didn't feel like much of a change. She had to cover all of her windows with blankets just to increase the temperature in her house from 60 to 63 degrees during the winter freeze of 2021. Like many public comments stated, this docket is about helping people increase energy efficiency and decrease the potential of having to choose between buying food for their family or paying a utility bill that could be lessened but for the lack of energy efficiency upgrades and assistance. Never has there been a moment like there is today where stakeholders nearly agree on almost every single term in the settlement agreement for programming. Of significance, if Evergy's energy efficiency portfolio is approved, it will provide a collaborative mechanism for improving both the programs offered in Kansas and the financial recovery utilized in future cycles. Taking this first step will provide stakeholders in the commission with valuable data that will help paint the picture of the impact and effectiveness of these programs in Kansas. The results from Missouri's program incite incitement and optimism that a similar program in Kansas will produce the same or similar results in energy savings and emissions reductions. Information gathered from this collaborative process and Kansas portfolio in general will help alleviate some of the concerns raised by stakeholders related to the unknown and lack of data or information currently available, which is none because we do not have an energy efficiency program in Kansas. However, if energy efficiency portfolio is not approved, data and information will continue to be unknown. The same concerns will be raised during the next KEEIA docket, and we'll find ourselves in the same place we find ourselves today. Only next time, it will be over a decade since KEEIA was codified into law. CEP, and in conclusion, this docket is about whether taking the first step of implementing a DSM energy efficiency program in Kansas can take priority over the cost incentives that will incentivize Evergy to implement the program. Again, looking to Missouri as an example, Evergy customers in Missouri have seen $2 in benefits for each dollar spent by Evergy, despite Evergy using the same financial recovery method proposed in this docket. Without a DSM program, customers like Maddie Bell and others will continue to face issues with home efficiency and high energy burdens. Additionally, Kansas will continue relying on fuel sources that contribute to emissions and will continue to be outperformed by other states. Now more than ever, it is time to implement energy efficiency in Kansas. It's time to take that initial step. CEP thanks the Commission for its time, and we hope that this proceeding goes on great, and we will yield back our time. Thank you very much.
Thank you very much, Mr. Laughlin. Next up to present will be for the NRDC, Mr. Titus, please.
Good morning, Chairman, and good morning, Commissioners. Robert Titus on behalf of the Natural Resources Defense Council. NRDC supports the proposed settlement agreement that was filed on August 1st, 2022, including the use of the Lost Revenue Adjustment Mechanism as a financial recovery mechanism. The use of LRAM at this time is a way to move necessary energy efficiency programs forward in Kansas. In NRDC's view, all the parties work together to develop a consensus on the energy efficiency portfolio proposed in the August 1st, 2022 settlement. This settlement will ensure that energy efficiency will be able to provide Kansas ratepayers with the economic, environmental, and utility system benefits experienced by states with energy efficiency for decades to come. NRDC is supportive of the LRAM as a financial recovery mechanism since decoupling is not currently in place. NRDC supports utilizing the LRAM as a transitional tool until decoupling is explored in a future docket as a way to bring the benefits of energy efficiency programs to Kansas. NRDC recommends that the Commission approve the proposed August 1st, 2022 settlement pertaining to the programs and allow for LRAM to be used as a financial recovery mechanism while decoupling is being considered by the parties. To be a little bit more specific, energy efficiency is the cheapest energy resource to invest in and provides quantifiable benefits well beyond the cost. On average, energy efficiency provides a return of $2 for every dollar that is invested in the programs. Energy efficiency can reduce demand for overall energy usage, which can translate into deferred investment in the new electric generation and infrastructure at both the distribution and transmission level. Impacting overall load and energy demand can provide increased reliability, even more so if dispatchable demand response is included in the portfolio. Improved energy efficiency provides economic benefits such as lower utility bills and also through direct participation for non-participants through the stability of energy prices. Essentially, it is NRDC's view that this plan presented lowers peak demand and it will help with reliability. As such, NRDC approves the August 8th, 2022 settlement agreement, and we yield the rest of our time. Thank you.
Thank you, Mr. Titus. Next opening statement will be on behalf of CURB, Mr. Astrom.
Good morning, Commissioner. This is David Nickel. I am Consumer Counsel for the Citizens Utility Ratepayer Board, or CURB. Thank you for the opportunity to address energy efficiency in this docket. Kansas is on the cusp of having utility-offered energy efficiency programs. It has taken a long time to get here. In 2008, the Commission investigated energy efficiency in depth, issuing several orders outlining Commission policy and preferences on energy efficiency programs. The Commission's enthusiasm for energy efficiency is manifest in these orders, noting that in 2008, Kansas enjoyed low energy rates that would inevitably rise in the future. The Commission stated, quote, "The Commission believes it is important that at least the basis and framework to enable a ramp up of energy efficiency programs be developed now before energy costs reach high levels," end quote. Yet since 2008, virtually no utility energy efficiency programs have been offered in Kansas. Energy prices have risen substantially, while utility offered energy efficiency remains dormant. The world has taken notice. As Mr. Colton testifies on behalf of Sierra Club, quote, "According to the ACEEE, Kansas ranks 47th amongst the 50 states and the District of Columbia in the delivery of energy efficiency efforts. In 2019, Kansas utilities only spent 11 cents per capita on electric efficiency programs, less than every other state except Alaska at 3 cents per capita," end quote. That low ranking tells us we need to stop being high-centered on this issue. Moreover, since cost-effective energy efficiency is a least cost resource, one could reasonably surmise that the lack of energy efficiency programs in Kansas has contributed to its high energy prices. Kansas has not been in a good place. We have high energy prices and no least cost resources to reduce them. That is until now. Evergy has proposed 9 energy efficiency programs. No stakeholder claims that these programs are perfect. Indeed, CURB retained Synapse Energy Economics, Inc., or Synapse, to evaluate where Evergy's programs could improve. Through Synapse, CURB proposed a number of modifications that CURB believes are improvements to the DSM programs proposed by Evergy. These modifications taken together present Synapse's opinion as to the optimum DSM program that is consistent with KEEIA and is attainable going forward. CURB's witnesses Alice Napoleon and Danielle Goldberg, both from Synapse, testify as to these potential improvements. However, these witnesses fully understood that most of their suggestions could not be implemented before Evergy's energy efficiency programs would begin. Rather, their suggestions were intended to provide benchmarks for improvement of energy efficiency programs over time. Thus, these witnesses took Evergy's application as a starting place, not an ending place, And through settlement negotiations, Evergy has improved its energy efficiency programs so substantially that they've received broad support from the Kcc staff, KEEIA, and other parties. Moreover, Evergy has committed to collaborating with stakeholders over several important modifications to further improve its energy efficiency offerings in Kansas going forward. Thus, KEEIA's consultant Synapse recommends that overall, Evergy's energy efficiency programs are in the public interest. KEEIA asks you to earnestly consider Synapse recommendations in this docket. Synapse has been extensively involved in energy efficiency dockets in over 1/4 of all states. Synapse is highly reputed, and its principals frequently provide analysis of energy efficiency and other utility issues at conferences throughout the U.S., including National Association of State Utility Consumer Advocate meetings. Indeed, Synapse's recommendation in this docket are partially based upon comparison of Kansas to other states. Significantly, in view of her experience, Ms. Napoleon recommends that the Commission approve the settlement agreements, both of them, especially in view of improvements that will come through collaborative meetings among stakeholders. The author Robert Schuller once said, "It is better to do something imperfectly than do nothing perfectly." This saying is apt towards utility regulation. For example, there is no rate design that assigns rates among rate classes in a perfectly fair manner. But should we not set rates until we can find that perfect rate design? I hope not. Similarly, I hope nobody seriously believes that we should reject energy efficiency programs until they are perfect. To wait is to deny energy savings to Kansans. KEEIA states, quote, "It is the goal of the state to promote the implementation of cost-effective demand-side programs in Kansas," end quote. The 2014 Kansas legislature set that goal in KEEIA for good reason. Indeed, the Alliance to Save Energy reports, quote, "Without the energy efficiency investments made since 1980, energy consumption and emissions today would be 60% higher, and consumers would be paying nearly $800 billion more per year in energy cost," end quote. Yet since 2014, no energy efficiency programs have been implemented to meet KEEIA's goal. In contrast, Missouri has had a slate of robust energy efficiency programs for approximately the last 10 years under similar legislation. Given the potential savings to Kansans, can we continue to sit idle on the basis that Evergy's energy efficiency programs are not optimal, while the vast remainder of states continue to invest in and improve their energy efficiency programs? KEEIA views the settlement agreements as a whole to present good energy efficiency programs with benefits that exceed cost. Although there is room for improvement, the collaborative provides a good means to address and implement those improvements. Many of KEEIA's suggestions will be topics in those collaborative sessions. Therefore, KEEIA views the settlement agreements as a whole to be in the public interest. There are several programs that will help ratepayers, particularly low-income ratepayers. It is also important to note that the EMV will be audited by an independent source. The data that will be obtained from running a Kansas-specific program is highly valuable. Overall, Synapse's opinion is that even though Evergy's energy efficiency programs are not optimal, they are reasonable such that program benefits outweigh program cost. Evergy's energy efficiency programs are not outliers among the states. KEEIA understands that Evergy's programs does not meet all of the Kcc staff's suggestion, even though Evergy moves substantially to reduce ratepayer cost and improve benefits. Thus, although the Kcc staff supports the program's SA, it rejects the financial recovery SA. As a practical matter, Kcc staff's position essentially tells Evergy to start over. In these regards, I am reminded of when my oldest son got his driver's permit. As he was driving for the first time with me in the passenger seat, I told myself I would not be a side seat driver and show panic at every fault. Yet every time we approached a red light with cars stopped in front of him, he would maintain a high rate of speed until the very last moment, when he would brake hard to avoid hitting the cars in front of him. I found myself stomping on imaginary brakes on my side of the car. After 3 times, I told him, "You know, When you see the brake lights lighten on the other cars, you should start slowing down. Brake lights, he asked. Yes, I answered, those lights on the back of the car that turn bright red. Oh, he said, that's what those are. Sometimes we start things imperfectly, but we have to start and then work through imperfections. The collaborative provides the stakeholders with a very good process to improve energy efficiency programs based on real data derived from the implementation of energy efficiency programs in Kansas. We will never be able to get really good energy efficiency programs without data that can only come from implementing Kansas energy efficiency programs. More importantly, should we deprive ratepayers with an opportunity for substantial energy savings because we are afraid that Evergy's TD, Throughput Disincentive, or which is a loss recovery adjustment mechanism, or LRAM, may not precisely reflect lost revenues caused by Evergy's energy efficiency programs. To this point, the evidence does not equivocally show that staff's position in this case is right and Evergy's is wrong. Evergy earnestly contends that its LRAM will accurately recover revenues lost due to its implementation of energy efficiency programs, and Evergy has evidence in the record showing so. Staff, on the other hand, states to compensate for possible overcollection of revenues due to rebounding free ridership and other reasons, lost revenues should be capped at Evergy's revenue requirement set at its last rate case. That approach is austere. Due to probable revenue growth, it may fail to meet the intended purpose of lost revenue recovery mechanisms to replace revenues that are truly lost due to energy efficiency programs. Moreover, it bears noting that while staff believes that Evergy's TD may lead to overcollection of revenues, Missouri has used that mechanism for approximately 10 years. One would think that if Evergy's TD was overcollecting, by now, the Missouri Commission would have made a correction. Staff does not believe that an LRAM is always bad. Frankly, the literature shows that some states prefer it. Ms. Napoleon's testimony simply is that LRAMs can lead to disputes and costly litigation, which is avoided by decoupling mechanisms. Thus, CURB sets a decoupling as a best practice, but only going forward. Importantly, the parties have agreed to work towards a possible decoupling mechanism through the collaborative contemplated by the settlement agreement. This would be a win for Kansas. It meets the Kansas Commission's preference as stated in its 2008 investigation. Without approval of the settlement agreements, however, decoupling may never occur. The other major concern that some parties have with the financial recovery settlement agreement is Evergy's proposed earnings opportunity, or EO. In CURB's initial testimony, Alice Napoleon stated that Evergy's EO was high, but it was never CURB's intention to walk away from energy efficiency solely on that issue. Indeed, it is common for parties in KCC dockets to establish an initial position through testimony, but to compromise on that position for favorable settlement of other issues. CURB settles on a much higher ROE than it posits in testimony in virtually all rate case settlements, and the KCC staff recommends that the Commission approve the same. But is it in the public interest to throw out energy efficiency completely on the basis of the EO proposed by Evergy? CURB believes the answer is no. First, through settlement negotiations, Evergy reduced the overall cost of its EO, LRAM, and carrying cost by approximately 35% by reducing its carrying cost and otherwise. Second, Evergy notes that KEEIA contemplates valuing demand-side resources with supply-side resources, which arguably supports a higher EO. Third, even if Evergy were to cut its EO in half, the impact upon ratepayers is less than a 5% reduction towards the cost of the entire program. In short, the EO does not have a significant impact on ratepayers. However, cutting the EO will likely have an existential impact upon Kansas energy efficiency programs. Importantly, Ms. Napoleon testifies that the impact of overall cost to ratepayers is substantially outweighed by the benefits they will derive from implementation of energy efficiency programs in Kansas. Ms. Napoleon believes approval of Evergy's DSM portfolio is in the public interest. In closing, I should note that my oldest son has now been driving for nearly 20 years and has a great driving record, albeit not perfect. He would not have obtained his license, however, if we had taken the keys away from him until he could drive perfectly. We are on the cusp of having energy efficiency in Kansas. This commission provides Kansans with the most hope they have had in years for energy efficiency. KEEIA believes that Evergy's DSM portfolio, albeit not perfect, will result in tremendous energy savings over time, but only if we begin. KEEIA asked the commission to approve both of the settlement agreements in this matter. Thank you for your prompt attention.
Thank you for your opening statement, David. Next opening statement will be on behalf of KIC, Mr. Sakura, please.
Thank you, Commissioners. I am Jim Sakura, and I am appearing in this docket on behalf of Kansas Industrial Consumers Group. KIC is sponsoring one witness in this case on a single issue: the recovery of lost revenues as a result of reduced energy sales. The testimony of Mr. Greg Meyer will demonstrate that the categories and calculations for recovery of lost revenue are not properly calculated and do not appropriately quantify energy savings, and therefore are not in the best interest of Kansas ratepayers. Thank you. That concludes my opening statement.
Thank you, Mr. Sakura. The final opening statement will be for the KCC staff, and presenting will be Jared Jevons.
Thank you, Chair. One of the matters before the commission today is whether energy efficiency programs should be implemented in the state of Kansas. Staff's view is that the commission should approve the energy efficiency programs contained in the program settlement. Staff believes it represents a reasonable resolution of the issues concerning program design and budget. The settlement was crafted by taking into consideration the views of all 11 parties in this docket, representing a variety of interests. The fact that these varied interests were able to collaborate and present a resolution of the issues, in this case, strongly indicates the program settlement furthers the public interest. That is why staff has signed the program settlement. Unfortunately, staff's full-throated support of the program settlement does not extend to the financial recovery settlement. Staff's opposition to the financial settlement is based on one undeniable fact: the programs are not free. Evergy customers have to pay for them. That is why staff's analysis continues beyond the question of, are these energy efficiency programs worthy? Staff's analysis continues to the question of, at what cost? Evergy, KEEIA, and the other signatories have presented a financial settlement that staff considers energy efficiency at any cost. Staff considers the financial settlement to be energy efficiency at any cost because Evergy is seeking $63.7 million in additional revenue on energy efficiency programs that cost $121 million. In other words, staff is saying, Evergy is saying it must receive an additional 52% in incentives on top of program costs for it not to pool the entire energy efficiency portfolio. Staff's exhibits 1 and 2, based on Evergy's own calculations, will show that Evergy's energy efficiency portfolio at Evergy's requested financial recovery levels will increase residential customers' bills on a net present value basis over 30 years. Residential customer bills also increase in total over the first 10 years and the first 15 years. I say again, customer bills will increase. Simply put, throughput disincentive and earning opportunities matter for these reasons, and energy efficiency at any cost is not a good idea. The signatories of the financial settlement, who are committing Evergy customers to this steep price tag, is both surprising and not surprising given who they represent. KEEIA's signature is surprising. KEEIA represents the interests of residential ratepayers and small commercials, but in this docket, staff believes KEEIA is prioritizing energy efficiency programs above costs placed on their constituents. Evergy and the environmental group's signature is not surprising. Evergy represents the interests of its management and shareholders. The environmental groups represent their members' climate, environmental, and energy goals. The parties who oppose the financial settlement are not surprising. The two parties who oppose the financial settlement are KIC and staff. KIC represents industrial customers. Staff represents ratepayers too, because it represents the public generally by balancing all of the above named interests. Admittedly, the financial recovery mechanism in this docket is complicated. but understanding financial recovery mechanisms is what the KCC staff is trained and tasked to do. Because the financial recovery mechanisms are complicated and energy efficiency programs are a priority of many Kansans, I will break down the charge that will be on all Evergy customers' bills, regardless of their participation in the programs. Evergy's customers should be aware of these complexities, given only 18% of Evergy customers will be able to participate in these programs, but they will all be billed. Evergy's financial recovery is broken down into 4 components, all authorized by Kansas statute. First, program costs. Program costs are the direct costs associated with energy efficiency program administration, implementation, education, marketing, and program participant incentives. Staff agrees Evergy should cover this amount as indicated by our approval of the program budget and the program settlement. If Evergy is able to demonstrate the programs are effective in years 1 and 2, then the program costs for all 4 years will be $121 million. Second, carrying costs. Carrying costs are the costs associated with Evergy not being immediately compensated for the program costs, and items 3 and 4, which I will discuss next. Staff agrees Evergy should recover carrying costs and that the financial settlement is a reasonable result for these carrying costs. Carrying costs total $5.4 million. Third, throughput disincentive. This is a term with nuance, so I will explain. The throughput disincentive allows Evergy to recover the reduced sales as a result of the energy efficiency programs. On the surface, this makes logical sense. Energy efficiency programs theoretically reduce the demand for energy. If demand for energy is less, then Evergy sells less energy. If Evergy sells less energy, then Evergy makes less money. Evergy doesn't want to sell less energy. It wants to sell more energy so that it can recover its costs and make more money for its shareholders. Therefore, the theory goes that utilities won't implement energy efficiency programs if they are not incentivized to do so. To incentivize Evergy to implement energy efficiency programs, Kansas law permits Evergy to earn a throughput disincentive, which makes Evergy whole for the reduced sales from energy efficiency programs. Staff agrees Evergy should receive the throughput disincentive because it's authorized by KEEIA and because some Evergy customers would not implement energy efficiency without these programs. Staff and Evergy just have a $40 million difference of opinion regarding the throughput disincentive. I'll discuss staff's issues more in a moment. The fourth financial recovery mechanism is what's called an earnings opportunity. In the existing regulatory framework, Evergy is allowed to earn a return of and return on capital investments. Traditionally, the majority of a utility's capital investments are on the supply side. Electrical generating plants, wind farms, and transmission lines are all examples of supply side investments. The return of and return on these investments allows Evergy to pay for these capital investments and sufficiently compensate shareholders so utilities can attract investment. Energy efficiency programs reduce load. As a result, energy efficiency programs theoretically mean Evergy will spend less money on supply side investments like generating plants, wind farms, and transmission lines because they are less needed. If Evergy spends less on supply side investments, then there is less for Evergy shareholders to earn a return on. Therefore, Evergy shareholders get compensated less. Again, Evergy shareholders want more compensation, not less. Earnings opportunity remedies this situation by compensating Evergy shareholders for the decrease in supply side investments they no longer need. Like the throughput disincentive, the earnings opportunity is designed to incentivize Evergy shareholders to implement energy efficiency programs because they wouldn't do so otherwise. Staff agrees Evergy should receive an earnings opportunity because it is authorized by KEEIA and because some Evergy customers would not implement energy efficiency without these programs. Staff and Evergy just have a $10 million difference of opinion regarding the earnings opportunity. I'll discuss staff's issues more in a moment. Before moving on, let's do a quick review of the numbers. The program costs were $121 million. Evergy is seeking to recover $58.3 million in additional revenue over and above the cost of the programs themselves through the throughput disincentive and earnings opportunity. Staff believes Evergy customers should pay about $40 million less than what Evergy says their customers should pay. Put another way, Evergy is saying it must receive a full 47% of program costs in additional revenue for it not to pull the entire energy efficiency portfolio. But another way, Evergy is saying its customers must pay an additional 47% on top of the program costs for Evergy to not pull the entire energy efficiency portfolio. Staff and Evergy are so far apart because of the numerous issues staff sees with the financial settlements, throughput disincentive, and earnings opportunity. First, I'll discuss the throughput disincentives, then I'll discuss the earnings opportunity issues. The method used to calculate the throughput disincentive is known as the lost revenue adjustment mechanism, or lost revenue for short. The lost revenue mechanism estimates the amount of revenue attributable to subcomponents of energy efficiency programs based on the number of participants and values taken from the Technical Resource Manual, or TRM for short. For example, the lost revenue mechanism will estimate the monthly difference in energy consumption when replacing an incandescent light bulb with an LED equivalent. The lost revenue method does this by referencing the TRM, which provides a list of annual kilowatt hour and kilowatt savings, as well as incremental cost per measure. The Commission has previously identified multiple issues with the lost revenue mechanism. For example, it places a high premium on accurate estimations of savings. It relies on third parties to evaluate whether the TRM is accurate. It overcompensates the utility when TRM values are inaccurately estimated. It permits the utility to over-recover the revenue requirement between rate cases, and it fails to accurately adjust for free riders. Notably, the Commission's prior concerns were echoed by signatories of the financial settlement and sworn testimony filed before this Commission until they capitulated to Evergy's demands and signed the agreement. For example, KERB, who originally recommended a decoupling method, a far more ratepayer-friendly method than staff's, twice criticized in its testimony in this docket the lost revenue mechanism it now supports. KERB's criticisms of lost revenue were its inaccurate estimations of energy savings in an environment of increased electric vehicle home charging, its failure to incentivize utilities to make more efficient buildings, instead incentivizing utilities to offer programs that generate the most revenue, and it causing snowballing rates as more distributed generation sources are implemented. To provide one example of the inaccurate estimations of energy savings as it pertains to the lost revenue mechanism, one of the programs offered in this docket is for no-cost shade tree distributions. The TRM estimates 30 kilowatt hour annual energy savings for each shade tree, beginning with the first year. But the report Evergy relies on to justify this program states that shade trees don't provide energy savings until the tree is 20 feet tall, which, as many homeowners know, can take 5 to 7 years at least. The trees Evergy will be delivering at no cost are 4 to 5 feet tall. Yet Evergy's TRM requests to count these savings as lost revenue immediately. Furthermore, no matter how much estimating savings has advanced in the last decade with the use of interval data, the TRM won't be able to measure the changes in customer behavior that can come from implementing energy efficiency, such as the increased energy usage of a customer now running their new HVAC system at 73 degrees instead of 78 degrees in August. It also won't count non-energy efficiency effects, such as increased electrical vehicle usage, economic development, or even a warmer than average summer. Because of these serious issues, Commission precedent on lost revenue is clear and repeated. It disfavors lost revenue mechanisms and prefers decoupling. Notably, a full decoupling mechanism was recommended by KERB and several of the other financial settlement signatories in this docket in their testimony as an alternative to the lost revenue method. Many of those same signatories would have the Commission believe that the lost revenue mechanism is just a 4-year transition to decoupling, but the record will show that there is no commitment by Evergy or guarantee that they will shift to decoupling after the Commission agrees with Evergy's preferred approach to TDE. Since the Commission last considered lost revenue mechanisms, the issues have not changed. However, staff proposes a financial recovery mechanism that mitigates these concerns, incentivizes Evergy to offer energy efficiency, and will make Evergy whole in the event that energy efficiency is the reason for Evergy under recovering its revenue requirement. Staff recommends the Commission approve the recovery mechanism in staff's opposition testimony, and which I will describe now. The commission can think of staff's recommendation as a hybrid between lost revenue and decoupling, and that it compensates Evergy for lost energy sales that are attributable to energy efficiency, but only if other rising energy sales, for example, electric vehicle adoption or an extremely warm summer, aren't already allowing Evergy to recover its revenue requirement. Specifically, staff's recommendation permits Evergy to use the lost revenue method, but it places a cap on Evergy's lost revenue at the level of the last commission-approved base revenue requirement. This makes practical sense. In the existing cost of service regulatory framework, without energy efficiency programs, Evergy should not expect to be able to explicitly charge customers more if it is earning more than its authorized revenue requirement. Offering energy efficiency programs shouldn't change that dynamic. But staff believes Evergy should at least be able to earn its base revenue requirement if the reason for it not earning that revenue requirement is energy efficiency programs. Therefore, staff recommends a cap on Evergy's lost revenue recovery at the level of Evergy's last approved revenue requirement. This guarantees Evergy receives at least its revenue requirement if the reason for that shortfall is energy efficiency. This is a guarantee that does not exist in Evergy's existing regulatory framework. Notably, staff's recommendation would not require Evergy to give back any earnings above its revenue requirement, like the decoupling method favored by the commission in previous rulings and recommended by KEEIA twice in this docket. Our method simply would not allow Evergy to charge customers more for supposed lost revenue if they're already recovering their costs. Staff's proposal also takes into consideration the future of energy in Kansas. In the coming years, Evergy sales are expected to increase despite energy efficiency programs due to electrification of the grid, growth in electric vehicles, economic development, and growth in customer base. Staff's proposal accounts for this by permitting a cap at the last commission-approved revenue requirement, adjustable based upon directly identifiable increases associated with electrical vehicle penetration, customer growth, or economic development. Staff's proposal is eminently fair and is a reasonable compromise between the company's position of full loss recovery, regardless of its earnings level, and the intervener's preferred method of decoupling. Next, I'll discuss staff's issues with the earnings opportunity. Staff's issue is simple. The level of incentive for Evergy's shareholders is unreasonably high. Regionally and nationally, Evergy's requested earnings opportunity is an outlier. According to information compiled by Evergy's consultants in this docket, provided in response to KEEIA data request number 30, Evergy's proposed target incentive level of 18% of net benefits would be higher than any other target EO in the entire country. This morning, you heard a lot about Kansas's 47th ranking in the ACEEE scoreboard. But making Evergy number one in the country in earnings opportunity doesn't make Evergy number one in energy efficiency programs, and it won't make Kansas number one in energy efficiency efforts. Staff's recommendation regarding the earnings opportunity is simply to follow the KEEIA statute. KEEIA says demand-side programs like Evergy's energy efficiency programs should be valued equal to traditional supply-side investments. Staff recommends an earnings opportunity of approximately 6%, which is equal to the level of earnings that Evergy would earn if it had invested the energy efficiency program costs and supply-side investments. This level of earnings is also in line with other earnings opportunities in the Midwest. Staff contends its financial recovery proposal regarding the throughput disincentive and earnings opportunity results in just and reasonable rates for Evergy customers. The financial settlement before the commission cannot make that same claim. So why are we here? Evergy has made it clear that it will pull its programs if the commission approves a financial recovery mechanism other than the one in the financial settlement. This is not a baseless threat. Evergy pulled its energy efficiency programs in 2016 when it didn't get its way. But that does not mean staff will not fulfill its duty to ensure rates are just and reasonable. The financial signatories fear Evergy withdrawing its programs, and that is stated in their testimony supporting the financial settlement. They either fear Evergy will pull the programs or that implementing energy efficiency is more urgent than concerns about costs. In fact, one signatory of the financial settlement actually states in testimony that these programs are needed irrespective of Evergy's recovery mechanism. Proof the signatories, the financial settlement, want energy efficiency at any cost. The signatories of the financial settlement have also convinced themselves they'll be able to persuade Evergy to adopt a less costly, more ratepayer protective option in the future. They cite this settlement's collaborative process. Staff views the collaborative process as aspirational at best. The collaborative process doesn't place any obligations or requirements on Evergy to actually implement a different recovery mechanism in the future. All that the settlement agreements require is Evergy to consider and evaluate alternative methods. That is a far cry from a commitment or requirement to actually change course. Evergy's actions in Missouri are proof of that. Evergy witness Ives testifies that Evergy has 10 years of experience with lost revenue mechanisms in Missouri. When Missouri approved a lost revenue mechanism that set the stage for years and years of a lost revenue mechanism, it did not set the stage for decoupling. The truth of the matter is, Evergy has no incentive to switch. Why would Evergy's executive officers choose an option that puts less money in shareholder pockets? Once lost revenue is authorized, staff fears there's no going back. At the end of the day, someone has to pay for these programs. How can staff, in good conscience, allow Evergy customers to pay approximately $50 million more than we think they should? No proposed policy, especially one which will lead to only a small minority of customers actually participating, can evade staff or the Commission's statutory duty to ensure that rates are just and reasonable. The Commission should not reward Evergy for its aggressive take it or leave it approach. Staff urges the Commission to modify the settlement to include staff's proposal for throughput disincentive and earnings opportunity. We understand making this choice could mean Evergy pulls this program, but we reiterate that is Evergy's choice. KEEIA gives the Commission choice among several financial recovery options. Staff urges the Commission to exercise this authority instead of just bending to Evergy's unwavering demands. It is Evergy who is requesting $58.3 million in revenue recovery for programs that cost $121 million. This is excessive and unjustifiable. If Evergy pulls its programs because it is not getting the amount it demands, that is squarely Evergy's decision, and they can face the public consequences of it. Evergy's take it or leave it attitude has pushed other parties to their side, but those parties don't have the same broad responsibility to all Kansas ratepayers like staff and the Commission does. Staff's proposal caps the amount Evergy may recover, but allows adjustments for expected growth. Staff's proposal is a reasonable compromise between the file positions of KERB and Evergy. Finally, staff's proposal is balanced and just and reasonable. The financial settlement before you today is not. It is energy efficiency at any cost. While staff supports energy efficiency and energy efficiency programs, our statutory duty is not to approve them irrespective of cost. Our duty is to ensure that rates are just and reasonable. I yield my further time.
Thank you very much, Mr. Jevons. Well, this now concludes the opening statements, and by my reckoning, it's also about an hour and 51 minutes into this hearing. It's definitely time for a break. We need to give ourselves and our court reporter a chance to take a break, and I'm suggesting that we do so for about 15 minutes. So why don't we return at, it's now 10:51. Let's return at approximately 10:06. We're in recess until 10:06. Thank you.
11:06.
Make that 11:06 Central Time. Thank you. Michelle, can you bring us back on? Denise, are we good to go?
I'm ready. Yes, thank you.
Thank you. It's now 11:06 and we are back on the record. We will now turn to the examination of witnesses, and I would turn to you, Ms. Kafer, and ask that you call your first witness.
Yeah, Evergy calls Mr. Chuck K.S.A.
Please raise your right hand, sir. You do solemnly swear the testimony you're about to give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning, Mr. K.S.A. Will you state your name and your place of employment for the record, please?
Yep, my name is Charles K.S.A. and I am employed by Evergy.
And are you the same Charles K.S.A. who caused to be filed in this docket direct testimony and rebuttal testimony?
I am.
And do you have any corrections that you need to make to either of those pieces of testimony?
I don't believe so.
Today, as are contained in your direct and rebuttal testimony, would your answers be the same?
Yes.
What? I guess I cut out or something. I'd like to move for the admission of the direct and rebuttal testimony of Mr. Charles K.S.A., please.
Is there any objection? Without objection, it's admitted.
Thank you. I'll tender the.
All right. Glenda, you are, for the record, cutting out for some reason. I did hear you, the first part of that last sentence, but you might check your audio. You were cutting out just a bit.
I'll do that.
Okay. Let's turn to cross-examination. We'll begin first with either Mr. Flaherty, it appears, or Mr. Vincent. If you would, please cross-examine.
Yeah, no questions. Thank you.
All right, very good. The Kcc staff, Ms. Mazantine, any cross-examination?
Staff has no questions.
All right, thank you. Let's see if the commission has any questions. I'll turn first to Commissioner Duffy.
Thank you. I have no questions.
Thank you. Commissioner French.
I have no questions for Mr. K.S.A. either. Thank you.
All right, thank you. And nor do I. I have no questions for Mr. K.S.A. either. That basically concludes the cross-examination. Mr. K.S.A., as brief as it was, we appreciate your appearance this morning. You're off the hook, I guess we could say. So if you would, please step down virtually. Thank you.
Thank you, Mr. Chairman.
Ms. Kaver, if you would, please call your next witness.
Evergy calls Ms. Kim Winslow.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Okay, Ms. Winslow, we state your, we're getting some feedback.
Little.
Will you state your name and place of employment for the record, please?
Yes, Kimberly Winslow, Evergy.
And are you the same Kimberly H. Winslow who caused to be filed in this docket rebuttal testimony on July 18th, 2022?
Yes, I am.
And are you also one of the witnesses who support various portions of the KEEIA report that was filed with the application?
Yes.
Do you have any corrections that you need to make to the rebuttal testimony file?
No, I do not.
If I were to ask you the same questions today as are contained in your testimony, would your answers be the same?
Yes, they would be.
Like to move for the admission of the rebuttal testimony of Kimberly Winslow, please?
Thank you. If I may just ask, Denise, did you catch all of that?
Yes, I believe I did. Thank you.
All right, thank you. Is there any objection? Without objection, they're admitted.
I'll tender Ms. Winslow for cross-examination.
All right, thank you. Good morning, Ms. Winslow.
Good morning.
Let's see if there is any cross-examination. I'll begin first with Mr. Flaherty.
No questions. Thank you.
Thank you. Ms. Maznantine.
We have no questions, Chair Team.
Thank you. See if the commission have any questions. I'll begin first this time with Commissioner French.
No questions. Thank you.
Thank you. Commissioner Duffy.
Thank you, Chair. Ms. Winslow, I just have a request. As I read all the testimony from the Evergy folks, I'm a little confused. So you lead Evergy's Energy Solutions team within the Community and Customer Solutions Division. And it says that you are responsible for developing and executing on Evergy's customer products and service strategy for demand-side management programs, distributed energy resources, customer renewable program, beneficial electrification, and home protection services and retail solar program. So I guess what I'm really needing is, I don't understand the organizational chart, the hierarchy of all you folks who are working on the demand side management. It appears that most of you are working the Missouri side of things and will add Kansas or have Kansas as part of your responsibility as well. Is there an org chart or a hierarchy that you can provide me so I see how all these folks fit in?
Yeah, sure. I can try and walk you through that, Commissioner Duffy. So yes, I lead energy solutions within Evergy. And so I am a direct report to Charles Kcc, who is our Senior Vice President of Customer and Community Solutions. Mr. Kcc has responsibility for different areas as it relates to the customer. So his responsibility includes marketing, energy solutions, government relations, regulatory, corporate communications. I'm sure I'm missing, and also with respect to the operations around the customer area, as well as, for example, anything that's meter to cash operations. So it includes, go ahead.
And if I can interrupt, is this on the Missouri and Kansas side?
Yes, ma'am.
Okay,
Yes.
all right. Yeah, please continue. I'm sorry.
Yeah.
Just wanted to
No,
understand.
that's fine. Yeah, so he has also responsibility for what we, have historically called meter to cash operations, which includes our customer call centers, as well as, billing, meter reading, that type of thing. So as a direct report to Mr. Kcc, I'm responsible for the development, implementation, the overall strategy related to customer products and services. And so, as you mentioned, there's several different areas within my responsibility that I have a team of about 28 persons that work on my team that deliver these programs. And some of them, yes, are more Missouri related type employees. But as I began this job nearly, I think, 10 years ago, working with Mr. Kcc or under that organization. And while in the beginning, majority of our area was focused on Missouri energy efficiency initiatives, we've continued to see this area only continue to grow, mostly because we see customers are utilizing our product, electricity, very differently than what they did, 10, 15, 20 years ago. So as our customers are interacting with us, perhaps it could be through net metering. So as they're considering solar, for example, I have a couple folks that are responsible for those net metering interconnection processes, as well as thinking about how we can engage with customers around their sustainability initiatives. So that could be through development of community solar projects or solar programs, community solar programs. It could also be around our direct renewable programs, where our largest customers are wanting that 100% renewable energy. So we have developed programs and have those offered both in Missouri and Kansas around what we call our renewable energy program. And as well as, we do have a team that is focused on our delivery of our energy efficiency programs. So that's both energy efficient, our demand side management, which is energy efficiency, and demand response.
And does that team report to you?
So you will be speaking with Mr. Brian File later today, and Mr. File leads the demand side management organization, which has both energy efficiency and demand response under his area.
Okay, and is this for residential, small business, and large business all?
Yeah, all
together?
all across the gamut. Yes.
Okay.
Yeah. And, we have been in front of the commission most recently as well around electrification programs. So last year, myself and my team were here in front of the commission to talk to you about electrification programs and how those programs can benefit both the grid, benefit the customer, and benefit Evergy. So there were some programs that the Kcc approved that allowed for rebates for both residential and business customers. So that's another piece of my organization, as well as we also work very closely with our regulatory team to develop rates for our customers. So we also have time of use rates in Kansas, and thinking about those, transit rates or fleet electrification rates. So we're, a lot of my team is thinking about today as well as the future, and how Evergy is engaging with our customers to ensure that we're meeting their needs and meeting our needs as well. Is that helpful?
Yes, it is. And if I can turn, Mr. Chairman, I do think it would be helpful that the company provide an organizational chart as it relates to the subject we are discussing today, with names and titles. So kind of see how this all fits together.
Yeah, and I would add, Commissioner Duffy, is that yes, as part of, if the commission does approve these programs, we will be adding staff to my team, what we call product managers. So there are there's 9 programs that are included within our filing, and we will be adding product managers, a few. Fortunately, we're able to leverage some of the work that we're doing in Missouri as well. And so we'll be able to hire folks on the product side, as well as a couple on the marketing side, to help offer these programs to our customers.
Okay, thank you very much, Ms. Winslow. I do appreciate your comments. That's very helpful for me.
Great, thank you.
And that's all I have, Mr. Chairman. Thank you.
Thank you. So as I understand it, Ms. Winslow, it's your intention to provide the org chart and the other information that to which Commissioner Dovey made reference, which she's requested. Am I understanding that correctly?
Yes, we can do that. Yeah.
All right.
So it'd be an organization within, Chuck Hazley's area. Yes.
Yes, that's correct.
Yeah.
Okay. Ms. Winslow, I have no questions for you. I turn to Ms. Kafer. Do you have any redirect as a result of the line of questions from Commissioner Duffy?
I do not.
Right. Thank
Very
you.
well. Ms. Winslow, thank you so much for thank you for your appearance here this morning. We're grateful for that. And this concludes your testimony, and you may virtually step down.
Great, thank you.
Thank you. Ms. Kafer, if you would, please call your next witness.
FG calls Mr. Brian File.
Please raise your right hand, sir. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Ms. Hess, if you would administer the bill.
Oh, I just did, Mr. Chairman. If it was not heard, I can do it again.
No, if it's on the record, we're there. My apologies. Okay. Good afternoon, Mr. File.
Hello, how are you guys?
All right.
Good.
Very good. Let's again begin with Mr. Flaherty. Do you have any questions of the witness?
I haven't entered his testimony into, can you, when I talk, you're going to have to, I haven't entered his testimony into the record yet. Would you like
All
to
right.
go ahead and do that?
Let's go back and do that, Glenda. You are still cutting out. So whenever we have a break, you might work on that one.
Okay. Mr. File, are you the same Brian File who caused to be filed rebuttal testimony in this docket?
I am.
And were you also one of the individuals who sponsored or supported portions of the Evergy report filed with the application?
Yes, I did.
On your rebuttal testimony, do you have any corrections you need to make to that today?
No.
So if I were to ask you the same questions today as are contained in your rebuttal testimony, would your answers be the same?
Yes. Thanks.
And I would like to move for the admission of the rebuttal testimony of Brian File into the record.
Certainly. Is there any objection? Without objection, submitted.
And I will tender Mr. File for cross.
Very well. Glenda, we have an added feature just for your information. Now, periodically, your screen is freezing as well. We did hear you tendering, Mr. File, however. Once again, good morning, Mr. File.
Good morning.
Can you hear me?
I can. Thanks.
Okay.
Thanks, Chair.
All right. Very good. Let's see where we head with cross-examination. I'll turn first to Mr. Flaherty.
No questions, thank you.
Thank you. On behalf of KCC staff, Ms. Mazantine.
Staff has no questions.
All right. Let's see if we have any commission questions. I'll begin first with Commissioner Duffy.
Thank you. Yes, Mr. File, good morning. I do have a question on your rebuttal testimony that you filed, and I'm on page 5. And we're talking about the participant cost test. And in the second line and the first full paragraph, the PCT is one of the typical 5 California benefit cost tests that are used to evaluate cost effectiveness of demand side programs. My understanding is you're the lead on demand side management. Is that correct for Evergy?
Yeah, good morning, Commissioner Duffy. Yes, as Ms. Winslow stated, I am the director of our demand side management programs, which includes energy efficiency and demand response.
Okay, so the typical 5 California benefit cost tests, can you kind of run through those for me?
Yeah, yes, I'd be happy to. So the most quoted and used specifically in Kansas is a total resource cost test. So we hear TRC talked about quite a bit. Additionally, the utility cost test, sometimes referred to as UCT or program administrator's cost test, a little bit of that, looking from the utilities vantage point. The RIM test, rate impact measure test, you'll hear that from time to time and see those in the results. Participant cost test, the one you've described that was at issue in my rebuttal testimony, specifically related to the business programs. and then a fifth test that is typically reviewed from the California test is a societal cost test, which is more all-encompassing.
So let me ask you, those 5 cost tests, those are routinely and typically used by other states in their analysis. Is that correct?
We typically see that the different states put different weight to different tests according to their interests, and sometimes there's some variations on exactly the test inputs, but generally those are the 5 that are used across the U.S. Yes.
Okay, so they're used in Missouri, and you've used them in Missouri, but can you identify other states where these are being used?
So in my work, I also get involved in some Midwest energy efficiency coalitions. And so the Midwest states is about 13 different states, and all of them use some variation of either the total resource cost test or societal cost test for general approval. That includes Minnesota, Illinois, Wisconsin. Those are 3 big states here. Michigan also has a significant amount of energy efficiency. From time to time, you'll see the utility cost test used as the utility investment is weighed for positive, positive being over 1.
I'm sorry, Mr. File, your volume just went way down.
Okay, sorry about that. I just was going to say, from time to time, people will use the utility cost test as a check to see as a utility investment makes sense. And then in some occasions, like in I think on the record here, the staff has used a 0.7 ratio as something that they're considering as a threshold there for that test.
Okay, and so do we differ substantially from Missouri and or other states in our weight of these 5 tests?
My direct experience in Missouri is the TRC test and the UCT test are typically the most weighed test, and when looking at the investment. The RIM test is very rarely discussed. So that is a difference between Missouri and Kansas and how they view those. There's a lot of debate amongst the industry on the value of what the RIM test is meant to do and what it's meant to measure. And so that has tended to keep people to push back towards the TRC and the utility cost test. Other than that, I'd say pretty much in line with TRC being the primary weight in most places.
Okay, so as you look at the state of Missouri, where you've had experience and you're very familiar, and the state of Kansas, as we look at the customer base, whether it's residential or whether it's business, are we very similar or are we somewhat similar in the nature of our customer base?
If you don't mind, I might ask a clarifying question. Do you mean similar in terms of energy use, customer type, similar in which specific things, or all the above?
Yes, all of
Yes.
the above, yeah. And where we're dissimilar, if you believe there's something that really stands out that we're dissimilar, then what would that be?
Sure. So as a couple things when we think about energy efficiency, the things that drive energy use are customer type and in the C&I space, industry type, and then geography, right? So weather impacts on energy with a lot of weather sensitive type of energy equipment. So obviously with Missouri and Kansas, that's really very similar. Although, Kansas, our service territory gets a little further south. So you'll see a slight variation in Wichita area, but generally very similar. From a customer base type, I would say on the whole, similar types of customers, but it becomes somewhat more sub-regional, I guess I'll use that term, from jurisdiction to jurisdiction. So for example, in Kansas, the ratio of business customers to residential customers is different in the Kansas Metro territory versus the Kansas Central territory, former Westar. Former Westar has a significant amount of industrial, large C&I customers there. And so those drive a lot of the kilowatt hour and kilowatt saving or energy and ultimately savings that we're trying to drive. Whereas in Kansas Metro, there's still a significant amount of commercial space, but more residential as a ratio of that group. On the whole, residential customers are fairly similar across Kansas Metro and Kansas Central, although the housing stock is maybe a little bit different size and a little bit different of age, but I would say generally similar. Across from Missouri, that would be similar. The customer base in Kansas City proper is a little bit different than our more rural area in Missouri, from in terms of that industrial versus metro or industrial versus residential trend, but the types of customers and types of businesses are similar.
All right. Thank you. I appreciate your response. Thank you, Mr. Chair.
Absolutely. Thank you. Commissioner French.
I have no questions for Mr. File. Thank you.
Thank you. I likewise have no questions for Mr. File. Ms. Kafer, do you have any redirect you would care to engage in as a result of Commissioner Duffy's questions?
I do not.
All right, thank you. Mr. File, I believe this concludes your testimony for today. We appreciate and thank you for your attendance here. You are excused and you may virtually stand down.
Welcome. Thanks for having me.
Ms. Kafer, would you please call your next witness?
Evergy calls Natalie Gray.
Hello, I'm here. Please raise your right hand, ma'am. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Will you state your name and your place of employment for the record, Ms. Gray?
Natalie Gray and Evergy.
And are you the same Natalie Gray who caused to be filed in this docket rebuttal testimony on July 18th, 2022?
I am.
And were you also one of the individuals who sponsored or supports certain sections of the Evergy report filed with the application?
Yes.
As to your rebuttal testimony, do you have any corrections that you need to make to that?
I do not.
If I were to ask you the same questions today as are contained in your rebuttal testimony, would your answers be the same?
Yes, they would.
Like to move for the admission of the rebuttal testimony of Natalie Gray?
Is there any objection? Without objection, they're admitted.
And I'll tender Ms. Gray for a cross-examination.
Very well. Good morning, Ms. Gray.
Good morning.
We'll turn first to Mr. Flaherty. Any cross-examination?
No questions, thank you.
Thank you. Ms. Mazantine, on behalf of the KCC staff. Any cross?
We have no questions.
All right, thank you. Carla, you did have a bit of an echo there at the end of your statement too, just as a heads up to your audio. See if there are any questions. I'm sorry. Yes, to see if there are any commission questions. Turn first to Commissioner Duffy.
Thank you, Mr. Chair. Yes, I have a couple of questions. Good morning, Ms. Gray. Can you tell me how long has MIA been in operation?
So MIA is in its current third cycle. It has been in operation since 2013.
Okay, and by third cycle, so how many years are in a cycle again?
So we typically file those cycles to be 3-year terms.
Okay.
During the second cycle, we did have one extension year that was approved. So it essentially was a 4-year cycle term. And then in our current third cycle, we're in our 3rd year in this 2022 program year. We have recently filed and received approval for an extension year to bring us into essentially another 4-year cycle term to bring us through 2023.
Okay. And I'm sorry, I should have asked this. I was reading your capacity and the capacity in which you're employed at Evergy. So are you specifically products and services for demand side management, or all products and services?
My role is specifically managing a team that oversee the energy efficiency portion of demand side management.
Okay, again, it would be so helpful for an org chart. I'm not sure. How big is your team?
Well, we're a team of 3, looking to grow by a couple here soon. And then as Brian File, who is my manager, alluded to, as well as Kim Winslow, that we are looking to grow the team once we can get the approval for KEEIA in place to be able to increase our capacity to be able to well manage the programs.
Okay. So you mentioned in your testimony, it is your rebuttal testimony on page 12, you talk about school kits. Could you, I don't remember in all the discussion on school kits actually seeing what's in a school kit?
Well, actually, we don't have any school kit type of programs in our Missouri program under MIA. This is something new that we were looking to have in place for KEEIA based on some of the other experiences, other peer utilities and other utilities across the country have experienced in that space. And also given what we heard of your high interest in education and engagement in the community, we thought that that would be a great addition to what we were proposing for our KEEIA. So to be quite frank, I don't have all of the details about the different measures that would be included and what those exactly might look like. I can say that some school kits that we have seen offered through other utilities can include things like low flow faucet aerators, smart power strips, LEDs, in addition to a great wealth of information that we like to provide and education around different other ways that customers can increase the efficiency and other tools that they can utilize to increase their awareness.
So this is kind of, and I will date myself going back to like 2001, when our energy office put together big, large baggies full of weatherization strips, a couple of LED light bulbs, some plastic to cover the windows, and we handed those out to essentially any public group. If our folks were at a school, every kid in the 5th grade, we would have these lunch sessions. They were supposed to take them home to mom and dad and talk about the benefit of energy efficiency. So you're talking about a kit that a student would take home to their parents, high school, junior high, or middle school, or grade school. Where are you focusing your efforts, or have you really kind of thought that through?
I feel like there's a variety of different pivotal moments in which have been, at least from what I've heard from others that have had this similar types of programs in place, that really are best to engage with these students. I have heard as young as 4th grade, clear up into, high school age kids, but I feel like there's probably a different approach that you would take with different levels of ages within those that were engaging through these school kits. I know that we've also historically engaged even with Kansas schools and coming in and talking about energy efficiency and just electricity safety and things like that. in the past. And I think that that has proven to be a very effective, and the kids really found it entertaining and educational. And so, I think that there's a variety of different ways that you can engage. I know that there's also been concerns about if customers actually would install these kits. Once these kids take these homes, what are the parents actually going to do with them, and are they going to be engaged in door care? There's other methods in which we can provide these kits. Maybe it's not sending them home to tote in their backpacks. Maybe it's providing them with all the information and having a fun little learning series or sessions in which we can engage with these kids, and their parents can get online, or they can call in if they're interested in a kit, right? So we're still exploring what those opportunities might look like, but we certainly recognize that there's great value in getting the family involved and talking about energy efficiency.
So you aren't thinking about going to the Kansas School Board Association or to the Department of Education School Board and talk to them about introducing something into the curriculum on energy efficiency? You're really talking about a little goodie bag that potentially goes in the backpack and goes home, right?
I think that it could be either or both. I think that taking it up to the higher to show that this is something we're really dedicated to at the board level would be something that we certainly are interested in and would appreciate that opportunity to present.
But you're not doing this in Missouri, right?
Not currently.
Okay, all right. Let me turn to another. In your rebuttal on page 13, down at the bottom of the page, line 21, you talk about 64% data point indicates that there is a fairly high tree mortality rate. Again, you go on to say, we plan to conduct further research to understand why this occurs and how Evergy can mitigate this from happening going forward. Are you an arborist, or do you have a background in tree biology?
I do not.
So do you anticipate you're going to hire arborists or consult with them to find out why this tree death is occurring?
So although I am not an arborist or by no means a tree expert, we do utilize individuals through our partnership with our trees, in which they do have that level of education and understanding. Specifically for our Missouri programs, we partner with Bridging the Gap and the Arbor Day Foundation. And the Arbor Day Foundation is ultimately kind of the higher oversight entity in which we partner with, that they provide a really great platform in which customers can see the tree, check out the trees, pick the ideal location based on where their house is located and how their house is located directionally. Bridging the Gap do have arborists on staff in which support the program and help with the EM&V process that follows the distribution of the trees. And so whenever I mentioned that we would conduct further research, that was what I was alluding to, is working with our Bridging the Gap arborists to help us understand how we can mitigate any sort of trees dying within the term in which we're looking to claim energy savings.
So who actually provides the trees in Missouri that you're talking about? Is that expense a Evergy expense, or when you say partners, is that also a shared financial expense with your partners?
So the Arbor Day Foundation actually procures the trees on our behalf, ensuring that they're all native trees in which will grow and thrive well in our environment here in Missouri and Kansas. And we utilize a local nursery located in St. Louis to procure those, in which Evergy does help offset the cost of those trees through our pilot program.
Okay, so it's a pilot program right now in Missouri, correct?
That's correct.
Okay. On several occasions in our neighborhood, we've called the city forester out to take a look, especially as the ash tree disease was, apparently it's in Lawrence, and whether it's come to Topeka, they're looking. Are you working with the city forester? Are you working with the state forester? And seeing what monies or programs they have that you could avail their staff and perhaps any financial resources they might have?
So in Missouri, we do work through and partner with the city on some tree support. We do have what's called the Green Team that's in place. It was a legacy Westar team initiative that was in place that's now an Evergy initiative today. And they do partner with the city. I know that we do have tree programs of planning in right-of-way and easement areas. What we do specifically through MEA is a little bit different in that it's on private property. And so we're working directly with the landowners and in non-easement areas. I do feel like there might be additional opportunity there to potentially partner with them. However, this is a bit of a different structure in which we're providing the trees.
Okay, so when you say it's in a pilot phase, how long has it been a pilot?
We're actually going into the year 3.
Okay, all right. And maybe that was in the testimony and I just don't recall it. Okay, thank you very much. I appreciate it, Ms. Gray. Thank you, Mr. Chair.
Thank you, Commissioner Duffy.
Cross-examination of Commissioner French.
I have no questions for Ms. Gray. Thank you.
All right, thank you. And I have no questions for you either, Ms. Gray. Ms. Kafer, do you have any redirect?
No, I don't. Thank you.
All right, thank you. Ms. Gray, thank you for your appearance here this morning. I think this concludes your testimony. You're excused and you may virtually stand down.
Thank you.
Ms. Kafer, if you would call your next witness.
Yes. Evergy calls Mr. Tim Nelson.
I'm here. Can you hear me?
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter non hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Mr. Nelson, will you please state your name and your place of employment for the record, please?
Tim Nelson. I work for Evergy.
And are you the same Tim Nelson who caused to be filed in this docket rebuttal testimony on July 18th, 2022?
I am.
And are you also one of the individuals who sponsors or supports certain portions of the Evergy report that was filed with the application?
Yes.
Do you have any corrections you need to make to your rebuttal testimony today?
No, I do not.
If I were to ask you the same questions today as are contained in your rebuttal testimony, would your answers be the same?
Yes, they would.
Like to move for the admission of the rebuttal testimony of Tim Nelson?
Is there any objection? Without objection, it's admitted.
And I'll tender Mr. Nelson for cross-examination now.
Very well. Good morning, Mr. Nelson.
Good morning.
We'll turn first to Mr. Flaherty. Any questions of Mr. Nelson?
No questions, thank you.
Thank you. Let's turn to the commissioners and see if there are any questions from the commission. I'll turn first this time to Commissioner French.
No questions. Thank you.
Thank you. Commissioner Duffy.
I'm sorry. I do have a couple of questions. Good morning, Mr. Nelson.
Good morning.
And again, I'm not quite sure where you fit in the organizational structure, but I think that as you have, you oversee the design and filing of customer programs, performance of cost effectiveness calculations, and it goes on. How in this application, a lot of the testimony alludes to conversations had in the community. So in your role, did you ever have the opportunity to work with the Kansas Housing Association, which has like 80 dues paying members, and they all, their whole goal is to improve the housing and structure in the state of Kansas and to make things more livable. Did you ever visit with them about data or information in your analytical review?
No, that has not been part of my role. I believe that function currently resides under Brian Files' area. If there are any interactions like that to be made, my role is supporting all of the different programs within Energy Solutions, and we do many of the calculations. And so we run the models that do the calculations of savings, the cost effectiveness testing, et cetera, for this filing.
So do you take into account, for example, with very low income folks, they're only allowed 4 heartbeats per room. And if they have children that over the age of certain age, they have to be the same sex located in a bedroom. I mean, do you take in those analytics though as part of your review, or is that in Mr. Files' responsibility?
That's likely in Mr. Files' responsibility. Mine is just purely the technical calculation of the quantity of kilowatt hour savings and the energy, the value of the energy savings or the lifetime of the measure for, the specific technology. For example, a light bulb, how many kilowatt hours does it save? What is the peak demand savings? What is the capacity value? What's the energy value and that lifetime value? It's those types of calculations that my group does.
Okay, well, along that line, the Topeka Housing Authority, they're starting their phase 2 of an energy performance contract on their high rise where it's multifamily living. So do you ever ask for information from them to try and quantify the savings that they've realized by changing out light bulbs, by replacing the HVAC air handlers, or LED light fixtures outside and their safety and security lights? Do you ever get into that sort of data where, again, they've been doing this since 2017, there's actual performance data on energy efficiency?
I have not talked with them myself, but as part of our program, we would be hiring an evaluator, and we would be doing those types of analyses through our evaluation consultants to determine what the actual savings were for the measures that were installed under our programs.
Okay, so on the Missouri side, have you ever visited with a housing association there in Kansas City to talk about the type of poverty, the type of low income person that they're trying to house, and some of the difficulties that have resulted from perhaps poor, the refrigerators are outdated, the stoves are outdated, the HVAC is outdated, and how potentially a energy performance contract might be beneficial for them?
I am not the one that has those conversations. I
Okay.
definitely talk with like Natalie Gray. She is over the energy efficiency programs and is definitely, that is definitely something that you know, is of interest to us to support customers like this.
Well, and I'm just going to say this as a comment. A lot of this application has to do with low income folks. And I believe that there are groups out there, large groups in Wichita, Topeka, Kansas City, that deal every day with housing of low income folks and the challenges that are there under the HUD rules. And HUD has not strengthened their rules on their Section 8 housing because housing stock is really at a premium. So to me, I think what was missing in this whole conversation of testimony is really some on point discussions or work with housing associations in Missouri, in Kansas City, or even in Kansas to reach some of the conclusions that are in the application. I believe that working with the housing industry for low income is key to a successful program. And yet I really struggled to find any of that identified in the testimony.
Sure, and I think we would agree that working with those folks is very important and helpful in delivering programs specifically to meet the needs of low-income customers. And like I said, that's would fit under the area of Natalie Gray's energy efficiency programs.
I would point out one other group. There's a Midwest Housing Equity Group. It's made up of about 7 states. And I believe Kansas and Missouri are part of that. And again, they have a wealth of information about what they're doing in their state. There's, you know, folks that come to the legislature from their group. So again, Kansas is a known quantity. So thank you, Mr. Chairman. Those are all my questions.
Thank you, Commissioner Duffy. Commissioner Nelson, I have no questions of you. Ask you. Ms. Kafer, redirect.
Mr. Chair, you were cutting out. I did not hear what you said.
I'm sorry. Can you hear me now?
Yes.
Can you hear me now? Okay.
Yes, I can hear you.
Okay. I have no questions for Mr. Nilsson. That's what I said. And I was turning to Ms. Kafer to ask if she wished to do any redirect.
I do have redirect. It's a little bit unusual. It is redirect on the gas companies put into the.
Glenda, you're cutting out.
I don't know what to do.
I understand that.
Okay, we're trying everything. It's just, can you hear me any better now?
Yeah, I could try it now. It's better.
Okay.
Glenda, this is David. You might save bandwidth if you turn off your video and just do audio.
I can do that. See if that helps a little bit. Okay, I do have some redirect here. It is on the exhibit that the gas companies entered into the record that concern Mr. Nelson's testimony. So the question would be on that and not on the Commissioner Duffy's questioning.
All right, proceed.
Okay, Mr. Nelson, you provided rebuttal testimony that responded to the testimony of Mr. Rabb regarding source to site ratios, correct?
Yes.
Okay. And where I am specifically is in your rebuttal testimony. It's beginning on page 17. You know, the essence of this testimony is that you were pointing out how the generation mix on the margin at SPP has transitioned to renewable sources versus coal sources and fossil fuel sources, and pointing out that Mr. Rabb's position, his testimony, his data was outdated because it didn't take that into consideration. Have I summarized that fairly?
Yes.
Now, if you would look at KGS Exhibit 1, which is the data request. I guess it's the Gas Utilities Exhibit 1. It's data request KGS 4. Do you have that?
Yes.
And in this question, this data request, they have asked you about your table on page 20 and 21 of your rebuttal testimony. Ask that you provide the megawatt hours of energy generated on the margin using the fuel types identified in that table. And can you tell us what the response was?
Yeah, to my knowledge, SPP does not provide any quantification of the megawatt hours of the fuel on margin, just what the fuel types were on margin and how for each 5-minute period in the year.
All right. And does that in any way undermine the testimony you provided in your rebuttal testimony about the transition to renewables for energy generation? I'm sorry, go ahead. Go ahead.
No, it does not change my analysis or the conclusion of my analysis, as I was just analyzing the quantity of time, the number of 5-minute intervals in the year that each fuel type or combination of fuel types were on the margin.
Okay, I have nothing further on redirect.
All right, thank you. Mr. Flaherty, you had waived cross-examination. Now that Ms. Kafer has brought up the exhibits that pertain to your clients, do you wish to cross-examine this witness at this time?
Yeah, no questions. Thank you.
Thank you. Well, Mr. Nelson, I believe now that we are at the conclusion of your testimony. We appreciate your appearance here today. You are excused and you may virtually stand down.
Thank you.
Ms. Kaver, please call your next witness.
Evergy calls Mr. Mark Foltz.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Mr. Foltz, will you state your name and your place of employment for the record?
My name is Mark Foltz. I am employed by Evergy.
And are you the same Mark Foltz who caused to be filed in this docket rebuttal testimony on July 18th, 2022?
Yes, I am.
And have you also been an individual who is supportive or sponsoring certain sections of the Evergy report filed with the application?
Yes, I am.
As to your rebuttal testimony, if I were to ask, or do you have any corrections to that?
No, I do not.
If I were to ask the same questions today as are contained in your rebuttal testimony, would your answers be the same?
Yes, they would.
Like to move for the admission of the rebuttal testimony of Mark Foltz into the record, please.
Very well. Is there any objection? They're admitted without objection.
And I will now tender Mr. Foltz for cross-examination.
Very well. Good afternoon, Mr. Foltz.
Hello.
Let's see if we have some cross-examination for you. I'll begin first with Mr. Flaherty.
No questions, thank you.
Thank you. Kcc Staff, Ms. Meslentine,
Yes, we do have a few questions, Chair King.
please.
Good morning, Mr. Foltz.
Hello.
Mr. Foltz, are you familiar generally with the spreadsheet that was sent via email to the parties on July 29th of this year, which was titled Confidential KEEIA EEDR Riders Calculator Model?
Yes, I am.
Okay, and I will just refer to that as the DR writers model from now on, if that's okay with you.
That is fine.
Okay, and you also sent that same spreadsheet very kindly as staff had IT issues to staff yesterday afternoon. Is that correct?
That is correct.
I will now go ahead and share staff exhibit 1 on my screen. Mr. Foltz, can you see that okay?
Yes, I can.
Okay, so what you are looking at right now, do you recognize the information on this screen as the same information that was contained in the dashboard annual tab of the Kansas Central portion of the DR writers model spreadsheet?
Yes, I do.
And similar graphs also exist in the Evergy DSM application that was filed in this docket, correct?
That is correct.
Could you please provide a quick overview for the commission of what the information on this graph represents?
This was intended to be a high-level analysis or representation of the anticipated impact of the DSIM recovery, or not, excuse me, not DSIM, but the EER recovery relative to the impact on customer bills resulting from the proposed recovery mechanism and proposed savings.
Okay, thank you. Now going down to page 2 of our exhibit here. Can you see this okay?
Yes, I have a copy as well.
Okay, great. Mr. Foltz, so staff did have to hide certain columns of this spreadsheet to fit it into a one-page exhibit, as I'm sure you understand, given the length of that spreadsheet.
Yes.
We have also, down here where it's highlighted, we have also made an additional we have added 2 line items. And again, those are highlighted here in yellow. Do you see that?
Yes, I do.
Okay. So aside from the modifications that I have just stated, would you agree that the rest of these values are as they appear in the Evergy DR writers model for Evergy Kansas Central?
Yes, they are.
Okay. So you can authenticate that the values contained herein are the same as those contained within the dashboard inputs annual tab of the Kansas Central portion of the DR writers model spreadsheet.
Yes, I believe they are.
And these values were Evergy's projections of both residential and non-residential net bill impacts. Is that correct?
Yes, they were the high-level representation of the expected impacts or estimated impacts.
Thank you. So I'd like to turn our attention to the column second in from the far right, which is labeled res net bill reductions. Mr. Foltz, does res stand for residential there?
Yes, it does.
So that column represents the residential net bill reductions as Evergy has projected from the EE portfolio, correct?
Yes, under the assumptions used in the model.
Okay. And those values represent the entire EE portfolio, correct? So including the financial recovery portion of the portfolio?
Yes.
There are several values within this column that are in parentheses. Do you see that?
Yes, I do.
Do the parentheses indicate negative values?
Yes, they do.
Here, do negative values indicate bill increases?
Under the, yes, using the assumptions that are in the model, they do.
Okay. So as I indicated earlier, below these values are yellow highlighted cells. Staff has taken the liberty to total the residential net bill reductions and non-residential net bill reductions for the years 1 through 10 and through 1 through 15. Do you see that?
I do see that.
Could you please read the number underneath residential net bill reduction for years 1 through 10?
It is a negative 20,393,395.
So that represents a cumulative bill increase over the years 1 through 10 of the portfolio, correct?
Yes, under that under, again, in the assumptions that are in the model.
And could you please read the number for the sum of years 1 through 15 for residential bill reductions?
It is a negative 7,954,047.
Okay, thank you. And so that represents a cumulative bill increase over years 1 through 15 of the portfolio. Is that correct?
In the model, yes.
Okay, thank you. At this time, I would like to turn to Staff Exhibit 2, which is the same documentation, but for Evergy Metro. So again, Mr. Foltz, looking at the graph on the screen before you, could you authenticate that the information is the same information contained in the dashboard annual tab of the Kansas Metro portion of the DR Riders model?
Yes, it is.
Thank you. And moving down to page 2 here, can you see that okay? I know you have a copy in front of you, but.
Yes, I can.
Okay. So again, as with Evergy Central, staff had to eliminate certain columns on this spreadsheet in order to fit it into a PDF form. However, can you authenticate that the values contained herein, aside from those, of course, highlighted in yellow, are the same as those contained within the dashboard inputs dash annual tab of the Kansas Metro portion of the DR Riders model?
Yes, I can.
Okay. Again, in the second column in from the far right, does res stand for residential there?
Yes, it does.
So this column is the residential net bill reduction of the entire EE portfolio for Evergy Kansas Metro, correct?
Yes.
As we did with Central, staff took the liberty of totaling the net bill reduction for program years 1 through 10, as well as program years 1 through 15. And that is highlighted there in yellow. Can you see that okay?
Yes, it is. Yes, I can.
Could you please read the number that is next to the years 1 through 10 calculation?
It is a negative 8,139,522.
Does this indicate a net bill increase to Kansas Metro customers over the initial years 1 through 10 of the programs?
Yes, using the amounts that are modeled and used in the assumptions used in the model.
Now, again, for the years 1 through 15, would you please read that number?
It's a negative 4,745,836.
And that indicates a net bill increase to Evergy Metro residential customers over the first years 1 through 15 of the programs. Is that correct?
Excuse me. Yes, it does. It appears that way.
Okay, and moving up to just a couple cells, it would be if you were looking at the Excel version, just a couple lines up above those where it says NPV. Does that stand for net present value?
Yes, it does.
Will you please read the number that's next to NPV?
It is negative 3,679,541.
And is that the result of Evergy's calculations on net present value over the first 30 years of the program?
Yes, it is.
And does that show a net present value bill increase over those 30 years?
Yes, and that it, as the model is currently presents it, yes.
And if you don't mind here, Mr. Foltz, I'm going to take us back to Staff Exhibit 1, which was our central discussion. Do you see down there where it says NPV again at the bottom of the 30-year calculations?
Yes.
Would you please read that number for us?
It is a negative 7,736,592.
Does that represent the net present value of bill impacts over a 30-year time?
In the model, yes, it does.
Okay, and so that shows a net present value 30-year cumulative bill increase. Is that correct? Since that number is negative or in parentheses.
That would be what the information would indicate.
Okay. Thank you, Mr. Foltz. I have no further questions.
All right, Mr. Fultz, let's see if there are any commissioner questions. I'll begin first with Commissioner Duffy.
I have no questions.
Thank you. Commissioner French.
I don't believe I have any questions. I just was wondering though, did staff offer that exhibit to be admitted into the record, or are they intending to do that later? Or was it only for purposes of examination?
I apologize, Commissioner French. I believed that we admitted those into the record during preliminary matters, but to the extent that they may have not already been admitted, we would again reiterate the request to have both Staff Exhibit 1 and Staff Exhibit 2 admitted into the record.
Is there any objection? Without objection, they're either admitted or readmitted.
I'm gonna guess staff was right and they're on top of it, but I just wanted to make sure. Thank you.
Absolutely. It was a good point. No problem in the process if it is a readmission. Mr. Fultz, I have no questions of you either. Ms. Kafer, I turn to you. Do you have any redirect?
Yes, I do. Mr. Fultz, on Staff Exhibit 1 and 2, do these numbers show any offsets for the benefits the customers receive as a result of the programs?
The model was built using values from the Kansas IRP, which used assumptions on without DSM. So I'm not familiar with that model extensively, but I'm not sure that it includes all of those estimated reductions in capacity costs in the rates that are assumed in those future periods.
Well, how does program design impact excuse me, just a minute.
Ms. Kafer, you are cutting out a bit again.
All right, we're trying here. How does program design impact the numbers that staff was going through with you here?
Well, this calculation is driven primarily by the kilowatt hour savings from the programs that were agreed to in the program stipulation. You know, the changes that occurred in that from the original filing, which did have positive values in those categories or in those amounts that were that Ms. Massentine pointed me to, were impacted with the latest reductions to remove LED lights from the home energy efficiency programs, which had substantial kilowatt hour savings. So the residential programs are currently more DR or demand response weighted or heavy, which results in a reduction in those kilowatt hour savings, but does not reduce the overall cost effectiveness based on the future capacity cost. That's my understanding.
And did staff agree with the programs in the program settlement agreement?
Yes, that is my understanding. They were a signatory.
Does the model include throughput disincentive?
Yes, it does.
Would customers be paying those costs without the programs?
I believe that the throughput disincentive is representative of the reduction in customer costs from reduction in their energy or kilowatt hour demand. So those costs would, absent energy efficiency, would have been in their rates on their older and inefficient equipment, higher usage, I guess, in their older inefficient equipment.
Any further redirect?
Can't hear me? Okay, excuse
We
me.
can.
I'm told I couldn't be heard.
You can now. You were muted before, but you're okay right now.
Okay. Because of the loss of kilowatt hour savings due to the parties' agreement to remove LED primarily.
That is my understanding. The change in the program mix was impacted by that change.
You consider throughput disincentive, LRAM, or lost revenue recovery, right?
Yes, it does include that.
Does the AC EEE report suggest on page 4 that analysts should not use LRAM in cost calculations?
I would have to look at that document.
Mr. Foltz, Mr. Foltz, you were muted in your response. I don't think the reporter could pick up your response.
Yeah, I don't have that document before me. I believe that's what the report indicates.
Okay, thank you. Nothing further.
All right, thank you, Ms. Cable. Mr. Foltz, I believe this concludes your testimony. We thank you for your appearance. We appreciate your testimony, and you are excused, and you may virtually stand down.
Thank you.
We have reached 12:22. We've been going for not quite an hour and a half. I think it's time we take a break for lunch, and that's what we will do. My proposal is that we break for 30 minutes, or we're going to round it off. We'll do a little more than 30 minutes in the interest of everyone's mental health. We'll stand in recess now for lunch until 1:00 p.m. We're in recess. Michelle, if you could bring us back online. All right, Denise, are you good to go? Okay. It's 1:00 p.m. now, and we are back on the record. At this point, we will continue with the examination of witnesses, and I would turn to you, Ms. Kafer, and ask if you would please call your next witness.
Yes. Evergy calls Mr. Darren Ives.
I'm here.
Denise, you are on mute.
Sorry about that. Please raise your right hand, Mr. Ives. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Mr. Ives, will you please state your name and the company you work for the record, please?
Yes, my name is Darren Ives. I'm the Vice President of Regulatory Affairs for Evergy.
And are you the same Darren Ives who caused to be filed in this docket direct testimony? I'm sorry, rebuttal testimony on July 18th, 2022, and testimony in support of the two settlement agreements on August 3rd, 2022?
Yes, I am.
And do you have any corrections that you need to make to that testimony today?
None that I'm aware of.
If I were to ask you the same questions as is contained in your rebuttal testimony and your testimony in support of the settlement agreements, would your answers be the same?
Yes, they would.
I'd like to move for the admission of the rebuttal and testimony of Darren Ives and his testimony in support of the settlement agreements. Move for admission into the record, please.
Is there any objection? Without objection, they're admitted.
And I'll tender Mr. Ives for cross now.
Very well. Good afternoon, Mr. Ives.
Good afternoon, Chair Keen.
Are you feeling better than the last time we saw you in this forum?
Yeah, yes, sir, I am. Thank you.
You appear to be doing much better.
That COVID is no joke.
There you go. Well, we're glad to hear you're feeling better. Let's see if there is cross-examination for you. I'll turn first to Mr. Flaherty, please.
Yes, thank you, Your Honor. Good afternoon, Mr. Ives.
Good afternoon, Mr. Flaherty.
I represent the 3 gas utilities that have intervened in this docket, and I have some questions for you regarding the non-unanimous partial settlement agreement on the KEEIA programs. And are you okay with me referring to that settlement as the program settlement?
Yes, sir.
And again, I apologize for my voice. I'll try my best to speak loud enough so you can hear me. So my co-counsel, Mr. Vincent, is going to put up on the screen a copy of the program settlement. And if we could go to the settlement, which is attached to that motion, and I want to direct your attention to page 2 of the settlement. Yeah, right there. So it's my understanding that section 2 of the program settlement that starts at the bottom of page 2 and runs through the top of page 9 sets forth the terms of the program settlement, correct?
That's correct.
And at the bottom of page 2, and it's paragraph 4 right there, it says the signatory parties agree that the DSM programs proposed by Evergy in its application should be approved consistent with the terms set forth below, correct?
That's what it says.
Okay, and then if we could go to the bottom of page 4. So, and I want to direct your attention to the whole home efficiency program. And under that section of the settlement agreement, program settlement, the provision refers to the removal of the residential retail screw and LEDs measure and the resulting reduction of the budget for that program, correct?
Yes, under section C.
Yes, is that correct?
That's correct.
So does that mean that the rest of the whole home efficiency program will be what is set forth in Evergy's application and specifically in Evergy's tariff relating to that program that's part of the Evergy application?
That's how I would interpret the settlement.
And Evergy's application contain a proposed tariff for the whole home efficiency program for both Metro and Kansas Central, correct?
Yes, it would have.
Okay, and I'm going to ask Mr. Vincent to put up on the screen the whole home efficiency tariff that was in your application, sheet 1 of 2. And if you're looking at sheet 1 of 2, that sets forth the general terms and conditions of Evergy's whole home efficiency program, correct?
That's correct.
Okay, and again, there's one for both Metro and Central, but they're virtually the same.
Yes, sir.
Okay, and there's a section on that page that's entitled Program Provisions, and the first sentence says Evergy will hire a program administrator to implement the program and provide the necessary services to effectively manage the program and strive to attain the energy and demand savings targets, correct?
That's correct.
And what type of entity is this program administrator that is going to manage Evergy's whole home efficiency program?
Yeah, that's unfortunately not my area of expertise. Probably a better question for would have been a better question for Mr. File or Ms. Winslow.
Okay, who does Evergy have managing its programs in Missouri?
I don't know who the program administrator is for that. Again, that's really in the program design, and better question for Ms. Winslow or Mr. File.
Okay, does Evergy plan to use the same manager that it has in Missouri for its Kansas program?
I cannot answer that question.
And why does Evergy use a program administrator instead of managing the program itself?
Again, would have been a better question for Mr. File or Ms. Winslow, who have that responsibility.
Okay, so you're telling the commission you don't know who the program administrator is for this similar program that you have over in Missouri.
That's what I'm saying. That is not my area of responsibility.
Okay. According to this proposed tariff, there are 3 components that make up the whole home efficiency program, correct?
I believe so. I don't have it in front of me other than the screen. So I see 2 components on the screen.
Okay. Yeah, my question really goes to component 1. So with respect to component 1, this home comfort customers will be eligible to receive incentives for installing efficient heating and cooling equipment, correct?
Yes, it says your highlighted section says it well. It says incentives for residential efficient heating systems only be for the same as existing technology.
Yeah, and I'll have some questions on that, but the first sentence of that section basically says that customers are eligible to receive incentives for installing efficient heating and cooling equipment and or increasing air sealing and insulation in the home, correct?
That's right. That's what it says. It related to the next sentence, of course.
Right. And when the tariff says incentives, what are we talking about there?
Well, I mean, there are incentives provided for customers to select cash incentives provided for customers to install more efficient heating or cooling equipment or for doing the work to increase air sealing and insulation.
And is it your understanding those incentives, those are paid in Kansas, if this is approved, would be paid for by other Kansas residential customers?
Well, they're actually program costs are actually recovered from all customers. So customers receiving the incentives or not.
Okay, and then I do have a question that the next sentence that's highlighted there. It says incentives for residential efficient heating systems will be only for the same as existing technology, correct?
That's what it says, yep.
And so does that provision mean that Evergy or its program administrator will not offer incentives for heat pumps under this whole home efficiency program component to Evergy's customers who have gas furnaces as their heating system?
Yeah, for this residential program, that's correct.
And nothing in the program settlement changes that provision in Evergy's whole home efficiency tariff, correct?
That's correct.
And Evergy agrees that if the program settlement is approved as submitted by Evergy and the other parties that sign that Evergy or its program administrator will not offer incentives for heat pumps under the whole home efficiency program component to Evergy's customers who have gas furnaces as their heating system, correct?
Yeah, correct. As we just went through.
And Evergy is not proposing to offer incentives for heat pumps to Evergy's residential customers who have gas furnaces as their heating system under any of the residential energy efficiency programs in Kansas, correct?
That's correct.
And Evergy is not proposing that an Evergy residential customer who has a gas furnace for their heating system can use Evergy's pay program to finance the purchase of a heat pump, correct?
Yes, that's correct.
So if Evergy has a program administrator running its programs in Kansas instead of Evergy running those programs, will that program administrator be aware of this like-for-like restriction in Kansas that incentives for heat pumps under the whole home efficiency program component can't be offered to Evergy's residential customers who have gas furnaces as their heating system?
Yes, that's a key component of our oversight and program management from Kim Winslow and Brian Fowle and the team that does that on behalf of Evergy.
Have you ever sat in with any meetings between Evergy people and the program administrator that you have administrating your programs in Missouri?
I have not. That's not my area of responsibility.
Hey, Robert, can we go back to the program settlement? Put that up on the screen, top of page 8. Yeah, right there. So I have some questions for Mr. Eyes regarding Roman numeral 7 or 5II. You see that?
I do see that one.
Okay.
Yes.
Yeah, it says provide stakeholders access to program tracking databases, including but not limited to documenting, and then it lists 4 items there, correct?
I'm reading.
Okay. Let me know when you're done.
Yes, that's right. 4 items listed there.
Okay, and I want to ask you a few questions regarding this provision in the program settlement. First, it says provide stakeholders access to program tracking databases. Who are the stakeholders who will have access to the program tracking databases? And are the 3 gas utilities in this docket included as stakeholders?
Well, Ms. Flaherty, I'm not positive that the term stakeholders is defined in the agreement.
Yeah, I don't think it is.
So it's probably a little open to interpretation, but certainly the intent of the agreement as you know, section B starts to talk about just a little bit further down the page is to be a collaborative process to work through things with a broad set of stakeholders. So I suspect if the gas utilities are participating to the extent that there's not anything overly competitive in there, they'll be allowed to participate in this section 7 or VII as well.
Yeah, and so that's why I asked you this question, just to see if we could clarify on the record that, and again, you fully participated in the settlement discussions that led to this agreement, correct?
I was a direct participant for the first 2 days, and I was not in person, but certainly aware of what was going on the 3rd day.
Okay, will you agree on the record here today that again, subject to your competitive caveat there, that the gas utilities will have access to the program tracking database?
Yeah, I think I can agree to that, subject to the competitive caveat as you mentioned.
Okay. What entity will be providing access? Will that be Evergy or
Well, what ultimately
administrator or somebody else?
It'd be our responsibility to provide access.
Okay. And what type of access are we contemplating into this provision? Would that be, let's say the gas utilities were interested in certain information, could they request that information as a stakeholder under this provision of the settlement?
Yeah, again, it's not defined, but I would hope that as part of our collaborative process, we can work out a mutually beneficial approach on how to address things like this. I'd prefer to not get discovery requests every other day from different stakeholders if there's a way that we can do it in a little bit more sensible approach.
Sure, and that's something that could be worked out in this collaborative process that's also included in the settlement, correct?
Yeah, that would be my hope.
Okay, let me ask you a question under item 4, which is one of the items that's going to be included in this program tracking databases. It says the technology replaced as well as its replacement. Do you see that?
I do.
Okay, and we've already discussed that under Evergy's residential programs, Evergy is not offering an incentive or heat pump rebate to an Evergy residential customer who has a natural gas furnace. So we wouldn't expect to see that item for type information for the residential programs, but we would at least be able to see under this item 4 a description of the heat pump that's being replaced and a description of the new heat pump, correct?
Yeah, so I apologize. Maybe Mr. Vincent can scroll back up to the header of the section. We kind of jump directly to 7.
Okay.
So this is just evaluation and approach generally, correct?
Yeah. So do you need me to repeat my question to you?
Yeah, I will. If you want to go back to that other section, thanks for doing that.
Sure. But let me just ask you this question. Would a stakeholder like the 3 gas utilities, would they be able to see what type of heat pump was being replaced and the type of new heat pump being installed under this program tracking database?
I think that's the, again, probably not my area of expertise, but I believe that's the intent of item 4 in this subsection 7.
So the stakeholders, the gas utilities, the staff, or anybody else that wanted to look at that, they could confirm that only heat pumps are being replaced with heat pumps under the program, correct?
Yes, in terms of the discussion we had earlier on the whole home residential program.
Yes, is that correct?
Yes, that's my understanding.
Okay. And I want to ask you some questions about the provisions in the program settlement that relate to the business programs. But while I'm on this provision about the stakeholders' access to the program tracking databases, if Evergy is allowed under one of its business program components or measures to offer an incentive for a new heating system to an Evergy business customer who currently uses a natural gas furnace as its heating system, will that information be included in the tracking information under the provision under the section 7 of the program settlement that we've just discussed?
Yes, I believe we would have all the information available to track that as well.
Okay, and that the gas utilities would have access to that information upon making reasonable requests.
Based upon our discussion here today, that's what I've agreed to.
Okay. So based upon that, the gas utilities would have access to the program tracking databases, and they could see how many Evergy business customers who use a natural gas furnace as their heating system accepted an incentive or rebate for Evergy for a heat pump as their new heating system, correct?
That's the way I read this section.
Okay. Robert, let's go back to page 3 of the program settlement. Thanks. And it's about up a little bit there. Section D under section A. Mr. Rise, I wanted to ask you some questions about that section. So if you could read it yourself.
Okay.
Okay. This indicates that if Evergy changes its budget by more than 10% on an annual basis, it agrees to file a report with the commission and serve the staff and other signatory parties, and then obtain Kcc approval of the change. Would Evergy have any problem with also providing a copy of that report to the parties in this case, even though they're not signatory parties to this agreement?
I probably can't answer that question on my own. I mean, there are a lot of signatories to this agreement that all negotiated to get this as one of the pieces of outcome. So probably not fair for me to speak on behalf of all signatories.
Okay, well, you contemplate that this report being filed with the commission for approval would be a public document?
I suspect it will have the potential to be public or at least viewed confidentially if we're seeking KCC approval.
Okay, if it's a public document, I mean, is there any reason why? Let me just ask you as Evergy, not the other signatory parties. I guess I can ask them, but why Evergy wouldn't agree to also serve a copy of that report on the 3 gas utilities?
It's an easy question in isolation, Mr. Flaherty, because that generally makes a lot of sense. Where I hesitate is, there are certainly a lot of factors that play into negotiation amongst multiple parties on a settlement like this, and this is a piece of that, right? And the parties that are not signatories made a decision for their own reasons to not be signatories to the agreement.
Right, but I mean, the gas utilities didn't disagree with all of the provisions in this agreement, just one. So based upon that, is there, again, just asking for you to speak on behalf of Evergy, is there any reason why Evergy wouldn't provide a copy of that report to the gas utilities when it filed to get approval from the KCC?
Probably not, Mr. Flaherty, and I think you probably would see it at some point in the process anyway if we were seeking to obtain KCC approval.
Okay. Right below that, section AD is the program offers, and I wanted to ask you some questions about some of the provisions in there. First one being under the whole business efficiency and hard to reach business. The first item there is remove business new construction component. You see that?
I do.
Okay, does that mean that Evergy is not seeking approval of its business new construction component?
That was the agreement with the signatories, yes.
Okay. And does that mean that Evergy is not seeking approval of its business new construction component in this docket, and that the business new construction component is being withdrawn by Evergy in this case?
I don't know if I would use the word withdrawn. I would say that the signatories have agreed that it will not be a component of the programs should the commission accept the settlement agreement advanced by the parties.
Okay, I guess what I'm trying to get at is what when this agreement says remove, does that mean something other than it's not going to be part of what's being approved by the commission?
But I don't want to parse words, but I think I think similar to our discussion above, where we were talking about adjustments to the direct filed tariffs and programs that Evergy advanced in its application. That's the same thing that's happening here with the word remove.
Okay, what's the word remove mean to you as used in this provision?
It's not going to be part of the programs that the signatories have agreed will begin should the commission adopt the settlement and approve the programs and the financial recovery.
Okay. The next item there contains a number of things, so I think it'd probably be easiest to take those one at a time. The first part of that first sentence says, remove business comfort component from whole business efficiency. You see that?
I do see that.
Okay. Does that mean that Evergy's not seeking approval of its business comfort component from its whole business efficiency program, and that the business comfort component of Evergy's whole business efficiency program is being withdrawn by Evergy?
Again, I'm not trying to be difficult and I don't want to parse words. We're not withdrawing it. It is an agreement of the signatories to not include it in the programs that would be approved under the settlement.
Okay, so if
I mean,
you wanted
it's not
to,
just an Evergy withdrawal. I mean, the distinction I'm trying to make, it's not just an Evergy withdrawal, right? It's an adjustment to the programs that Evergy offered based on a negotiated outcome with the signatories to the program settlement.
okay, fair enough. So if Evergy did want to implement that component that it's removing from the settlement, you would anticipate you'd have to come back in, file an application and go through this process again for that, to get that component approved?
Yes, sir.
Okay. So the second part of that first sentence says the enhanced business comfort budget from the hard to reach business program is being removed. So, and that's a little different than the first part of that first sentence. So does that mean that Evergy's not withdrawing the enhanced business comfort component, but instead is only removing the budget for that component?
Well, a couple things. I really hate to parse words, so maybe we could change them.
That's why we're here.
I'm not, Evergy's not withdrawing anything. We are agreeing to modifications to our filed programs based upon negotiated settlement with signatories as step. So that said, with that understanding, if we don't have a budget for the enhanced business comfort under the hard to reach business, we won't have anything to operate a program. So I think to your point, it's a different word, but I think it's the same outcome in terms of not moving forward with the enhanced business comfort from the hard to reach business.
Okay. And I agree with you on that. If you're removing the budget and you don't have a budget to implement the program, then basically that's the same effect as if you were removing the program, correct?
Yes, sir.
And then the next sentence seems straightforward. Parties have agreed to use Evergy's filed budgets for years 1 through 4 for the 3 components identified in that sentence, correct?
I think it's 4 components, but yes, the 4 components for the years 1 through 4.
Okay. And then the next sentence says that the business comfort measure of business custom HVAC will remain included in the whole business efficiency and hard to reach business programs for years 1 through 4. Is that correct?
That's correct.
And it's my understanding, or is my understanding correct that if it is under the business custom HVAC measure, which is not being withdrawn from the case, where Evergy will be allowed to offer an Evergy business customer who has a gas furnace a heat pump rebate?
That's correct.
Okay. And the money to fund the heat pump rebate under the business custom HVAC measure will be paid by Evergy's other business customers, correct?
I think it'll be paid by all business customers, including those that get the rebate. But yes.
Okay. So on this next sentence, you're gonna have to help me out because I'm not sure I understand it. It says the budget for business comfort and enhanced business comfort for years 1 and 2 can remain in reserve. So does that mean that Evergy has no budget for those programs for years 1 and 2? And without an approved budget, those programs will not be implemented in years 1 and 2?
That's correct. That's the first half of what it means. And in my opinion, that the second half, and it kind of leads into the next sentence, right? That it says, if Evergy can redesign those programs in such a way as to pass the benefit cost test for 3 and 4, that those budget dollars will be available at that point to implement those programs.
And how do you envision this part of the settlement that you just referred to working under the settlement? What is it that Evergy will have to do in order to get approval of these redesigned programs or components?
Well, I mean, simply we'll have to demonstrate initially to the stakeholders that we have completed a redesign that parties can agree will pass a benefit cost test, and then we'll likely need to submit that to the commission in order to get approval to unlock those dollars in reserve to utilize them in years 3 and 4.
And will stakeholders have the ability to raise issues relating to the redesign of these components, and how would that be done?
Yeah, I think there's probably 2 ways, right? If we're working collaboratively with stakeholders through the process outlined in the collaborative section, I hope we're having 2-way dialogue, and parties are participating and raising questions and concerns, and we're able to react to those. That's the point, right? And then secondarily, I think once we have it designed and we decide to move forward with the commission to unlock those reserve program costs, I would think parties would have the opportunity to express their agreement or their questions or concerns at that time as well.
Okay, thanks. Actually, my voice is getting better the more I talk. So
you sound fine.
I just have a few more questions for you. And one of those questions was on the financial settlement relating to the lost revenue adjustment mechanism. Under the settlement, Evergy will be allowed to recover lost revenues resulting from its energy efficiency programs from Evergy's customers, correct?
That's correct.
And is there a provision in the settlement or in the LRAM approved under the settlement that requires Evergy to credit customers for increased revenues resulting from the EE programs?
There is not, because it's looked at a portfolio level, and by the nature of implementing DSM programs, that won't occur.
Okay, so it's possible that you could actually have increased revenues resulting from these EE programs, but your customers aren't going to get credit for that, but they are going to have to pay for all the lost revenues.
No, that's not what I said. I mean, it'll be looked at a net basis on a portfolio level, and at a portfolio level, even if there was an instance or 2 of increased revenues, it would not result in a credit at a portfolio level. It would just be netted against the lost revenues at the portfolio level.
Okay, thank you, Mr. Ives. That's all I have. Thank you, Mr. Chairman.
Thank you.
All right. If we could remove the screensaver, please. Thank you very much. All right. Let's continue on for cross-examination for KIC, Mr. Sakura. Jim, you're muted.
Now am I doing okay?
You're there now.
Okay. Good afternoon, Mr. Ives. Jim Sakura on behalf of KIC.
Good afternoon, Mr. Sakura.
I have a number of questions that are along the same line as Mr. Flaherty's questions with regard to the home comfort program, but I want to give a bit of background before I get into that, if I could, please. Just on a generalized basis, Mr. Ives, the revenue recovery, as I understand it, would be basically consist of 2 parts. The recovery for the, you know, the costs of it, and then the costs of the energy efficiency programs. And then on top of that would be the what's been called a chance for earnings. Is that generally correct, or how would you explain it on a summary type basis?
From a cost recovery standpoint?
Yes, sir.
Yeah, so I would say there are three legs to the stool for recovery that are important. One, as you mentioned, is the recovery of the program cost. That's the first step. Costs that are incurred to provide the rebates and implement and execute the programs. The second one is the earnings opportunity, performance incentive, if you will, to your point. And that is intended to make the investments in DSM programs equivalent to the earnings opportunity for supply side investments that the utility and its investors could make. And then the third leg is the LRAM, or the recovery of the throughput disincentive. And that is the recovery of foregone revenues because of the successful implementation of DSM programs that the utility would have earned but for the implementation of the DSM programs. So the kilowatt hour savings that result in reduced revenues, the recovery for that is the third leg of the stool.
Okay. I think if I'm staying with you in your analogy, I think I'm on the third leg of the stool. Okay.
Okay.
And that is, let's say, for instance, any one of the programs. Let's pick the home comfort program, for instance. It would be important. Am I correct? It would be important to accurately predict and estimate the savings from that program.
Yes, absolutely. That's the that's the purpose behind the measures and the EM&V work that is done, and the third party auditor that sits over the top of the EM&V evaluator based on the settlement agreement.
Okay. And Mr. Ives, I'm going to kind of break my questions into two different parts, if I could. First of all, I think there's been some testimony earlier, both in openings, not testimony, opening statements mentioned the Missouri program, and also Mr. Flaherty had some questions about how the Missouri program operated. Let me ask you just on a theoretical question and procedural question. Let us assume that the evaluator or the third party audit occurred, and they found that some of your estimated savings were overstated, that they should not have been that much, that they should have been lower. How does the program work? Would the retail ratepayers be paying as they go? And what if there is an overestimate of savings? Do the ratepayers have the opportunity to get that back?
Yeah, so there are a couple steps to that process in the way that the settlement agreement is set forward in Kansas. The first year, the first year is all based on actual results from the EM&V. So we will go out, conduct the EM&V, and adjust the first year results for that. Then the modifications that are needed to the TRM and the deemed savings will be put in place based on those first year results, and the deemed savings will be utilized going forward and ultimately adjusted for actual values once the EM&Vs are conducted. So there's a process along the way to utilize the results of the EM&V evaluation and make appropriate adjustments to actuals.
Let me, sir, address you to what I think is the real life situation over in Missouri. And I want to direct your attention to the Missouri Public Service Docket EO 2019-0132. And in that docket, as I understand, and perhaps you can affirm this, the independent auditor has come back with an audit that suggests that the home comfort percentages be materially reduced in the program. Would that be a correct statement?
I'm actually not familiar with that specific level of detail, but I do know that there is some activity going on in that EM&V process right now that's being worked through in Missouri. Yes, I'd agree with that.
Okay, let me read from the pleading, and maybe it could help your recollection. Evergreen Economics audit listed several issues with Evergy's 2021 EM&V reports. Due to concerns about the scoring of the spillover questions, the lack of a credible link between the company's program activities and non-participant purchases, the possible double counting of LED savings, and the inclusion of non-like measures, Evergreen Economics does not recommend the non-participant spillover numbers be accepted for the 221 heating, cooling, and home comfort program. Now, does that help you recollect what the issues are in that case?
Yeah, I understand the issue as you presented. Do you have a question on it?
Yes, I do, but let me give you one more piece of background if I could. And I'm reading from the staff pleading over in Missouri. It says for the heating, cooling, and home comfort program, change the non-participant spillover rate from 14% to 2%. This reduces net savings for the program by 12%. Okay, my question is, if an audit in Kansas, the first year after the program took place with similar results to the audit in Missouri, how would that be handled if that were ultimately determined or accepted by the commission to be accurate? How would the adjustment in that case in favor of the ratepayers take place?
Yeah, so certainly there's active dialogue throughout a process of an EM&V process and auditor review of that. I would say at this point, the issues, to the best of my knowledge, are as yet unresolved in Missouri. So as you are aware, sometimes there are positions taken by a party or an auditor that don't end up being the final outcome in a proceeding. So I wouldn't want to offer that anything you read there is the final answer in Missouri EM&V. All that said, that's why you have the process, right? You have auditors, you have a EM&V, you have auditors. If adjustments are necessary, if it meets the threshold to make adjustments, and the commission so determines, then that process would be adjusted not only in actuals, but would be considered in future deemed values in the technical resource manual.
You raised a good point, Mr. Ives. I please want to fill out the record. What I read to you was the pleading dated July 22 of the staff of the Missouri Public Service Commission, and in response thereto, Evergy in a pleading dated August 8 disputes all of those findings. So you are right. The status of the case is undetermined at this point until the commission makes its decision. All I was trying to work with you on, or get testimony or record on, is if there is a material change based on an audit is there a procedure that the retail ratepayers would be able to recognize that change based on a future KCC order?
The easy answer with the with the process that's in place and the thresholds that are in the settlement agreement is there are avenues to address specifically that situation. So yes.
So it would be your testimony based on your understanding of the settlement agreement that if an audit that was ultimately confirmed by the commission as to its findings, that there is a process whereby the audit results in the commission order would be recognized in an adjustment of retail rates.
Well, I think there's an adjustment certainly for the retrospective look in year one based on the settlement, and also a threshold of adjustment that would be made to the theme savings and the TRM for the future years as well. So I think there are a couple ways that, to your point, that those adjustments get made for the benefit of customers.
I think, Mr. Ives, I only have one further question. If a change, for instance, were to be made, reducing the costs for the retail ratepayers, would there also be a change in any of the return? I think the other two legs of the stool, a return for the program, would that change flow through the other revenues, that the other revenue participation that Evergy has in the program?
Yeah, so from an EO or performance incentive basis, there certainly are a set of measures in a matrix that are considered in that calculation that are kind of laid against the programs. So as the actual results come in on those measures, that's what will be used to calculate the final earnings opportunity. So it does adjust based on actuals to your, I think, in response to your question.
And just to confirm, if I could, my understanding, if you would please, the methodology on a go-forward basis, if the commission were to approve, I think you call it the portfolio of energy efficiency programs, that there would be at the first item of review would be a report by Evergy or an evaluation by Evergy as to how the program worked for the particular program year. But then it's also envisioned that there would be an independent audit of the program.
Well, it's two phases, right? Our EM&Vs are conducted by an outside party that specializes in that work, and then the agreement calls for an auditor working for the benefit of staff to work with, be part of the development of that methodology of the EM&V and have the ability to review and audit the results. So really two layers beyond Evergy in-house personnel, if you will.
I think if I please, Mr. Ives, could have one more question. Would it be based on the findings of the home comfort program over in Missouri, which related to also to the air sealing and insulation measures? Would it be the intent of Evergy to relook at the programs in Kansas and to reaffirm that they are accurate and continue to be accurate based on the evaluation that has been put forward in Missouri?
Well, so again, we don't have an answer over there as you articulated. You know, our efforts are always to learn from the actual results of our programs and the actual savings, and continue to refine and update our programs, our measures, our technical resource manuals to reflect the best information that we have based upon our experience. So I think absolutely we'll incorporate learnings to our current and future programs.
I have no further questions. Thank you, Mr. Ives, for your testimony.
Thank you, Mr. Zakura.
All right, thank you, Jim. Next up for cross-examination, KCC staff.
Thank you, Your Honor. Mr. Ives, I was reading a case involved KCP&L, and it references that a public utility has an obligation in providing service to assure that its customers consuming electricity in an adequate, efficient, and reasonable manner. Agree with that statement?
Can council provide some background on what he's reading from?
Walker?
I'm just asking him if he agrees with that statement.
You're going to have to say it again. That's a pretty broad statement from a document that I don't have in front of me or have any familiarity
Okay,
with.
well, it's just do you agree with the statement that a public utility has an obligation in providing service to assure that the customers consume electricity in an adequate, efficient, and a reasonable manner?
Well, I agree with that, with the exception that are carved out by legislation for voluntary actions, which KEEIA would be one of those in Kansas.
If you elected not to do the program, you wouldn't fulfill the obligation. Is that correct?
No, that's not correct. If I elect to not do the program, that's statutorily it's a voluntary election by the utility.
Turning to page 20 of your rebuttal testimony, you highlight language related to lost revenue recovery and the commission's order in docket 16-446. Do you see that?
I'm sorry, you're on page 20 of my rebuttal?
Yes, please.
I'm looking, I don't see a reference to the 2016 docket on that page.
On page 20?
I'm looking at my page 20 in my rebuttal.
Excuse me, I referenced the wrong testimony. I believe that it's the testimony related to the settlement. I'm sorry. I misdirected you.
That's okay. 1 second, I'm turning there. Yeah, so are you talking about my response to the question that starts on line 10?
Yes.
I'm there.
And you highlight the commission's references with regard to lost revenue recovery, wherein the commission has said, first, it places too much weight on accurate evaluation of program impacts. Second, it increases the potential for expensive, time-consuming litigation. Third, it forces the commission to rely on outside firms to evaluate the methodology. And finally, it fails to measure free ridership in evaluating the impact of energy efficiency programs. Is that not the current precedent with respect to rulings on lost revenue?
Well, I'm not an attorney. I'm not sure about the use of the word precedent. I would say that those are the flaws that were identified in the 16 order based upon the facts and circumstances that were in front of the commission at that point. I would agree with that.
And the commission staff, basically taking that into account, has proposed an alternative method for determining lost revenue in this docket, has it not?
Well, sort of. As the commission staff said, maybe in the opening, they call it a hybrid, and they still rely upon the LRAM methodology, they've just set an asymmetrical cap. So if you're still relying on the methodology, to the extent the company doesn't hit the cap, you're basically in the same spot that we are in terms to the identified 4 flaws of the commission in the 16 order. So I'm not sure there's a distinction in the 2 methods from that side. And I would disagree that those flaws are still in place and as prevalent in this docket as maybe the commission saw in the 16 docket.
At any rate, we're about $40 million apart. Is that correct?
We absolutely have a throughput disincentive difference, right? Because the staff has been pretty clear that that they would prefer to look at it differently. We can agree on that.
Now, there's been references to the Missouri Commission and what it's doing with respect to EM and V. It is my understanding that with respect to Missouri, the EMV process, as it relates to lost revenue and earnings opportunity, has been very contentious between Evergy, the Missouri staff, and the public council. Do you agree with that statement?
I do not. We certainly have had dialogue over 10 years of history with those stakeholders and others in the state of Missouri, but we ultimately have resolved each of our prudence reviews and had very little ultimate adjustment in our reviews as a result of the M&V work. We have had dialogue, no doubt about that, but that's part of the process.
Was Evergy recently subject to a prudence review regarding its programs in Missouri, where the Office of Public Counsel and the Missouri staff took issue with the excessive level of administrative cost your company was assessing as compared to other costs related to your programs?
I don't know that I would agree with all your language, but we did have a difference of opinion on administrative cost, and we have ultimately resolved that issue, and we ultimately have addressed it on a go-forward basis, including when we just received an extension for a 4th year of cycle 3 that still has administrative costs in it, but reflects an update to methodology based on our work with those parties.
And didn't the Missouri Prudence Review question many aspects of your programs, including program costs, throughput, disincentive, and earnings opportunity?
No, I wouldn't agree with that. I mean, we had an administrative cost issue that we just talked about that we ultimately resolved, and as I mentioned, we've addressed in the 4th year of the plan. And I don't recall. I mean, we've had some disputes from time to time as we've gone through and worked through measures and EM and Vs, but you know, as we're now concluding the 3rd cycle of approvals with generally annual EM and V updates, I think the process has actually gone pretty well.
And just for the record, these were cases EO 2021-0416 and EO 2021-0417. You agree with that?
That sounds right. I don't have them in front of me.
Well, based on those prudence reviews, since they relate to both cycle 2 and cycle 3, would you agree that the EMV process in Missouri has become, you know, as you indicate, you know, a process whereby it takes upwards to several months or a year to resolve some of these issues?
I would agree with several months. I wouldn't agree with a year off the top of my head. Although I find when you go through any prudence review, including for fuel clause rider or any other measure, property tax surcharge, it can take months of discovery and work with the staff or parties before you get an outcome on a prudence review. I don't see it any differently.
Now, as I recall, in the settlement agreements for timely recovery, there's a 90-day time frame. Do you think that would be enough to have a full evaluation with respect to what you're claiming for lost revenue and earnings opportunity in the context of an EMV?
I probably need to get a copy of the settlement document in my hand if you want to refer to a specific location in 90 days.
Would you think that the EMV process should take full to allow discovery by all of the parties and a commission oversight and review?
I believe the M&V process is contemplated to have oversight and review, including by an outside auditor contracted by the staff. So I think it's contemplated to allow for that.
Okay. We have yet to have the process unfold in Kansas, so I'm trying to get an idea as to how involved that process is going to be with respect to the EMV auditor and your outside auditors. Let me ask you this, with respect to decoupling, which has been a hot topic here in this proceeding, has Evergy ever proposed a decoupling method in Kansas, in Missouri?
In Missouri?
Yes.
No, and actually Missouri has legislation in effect right now. It's called plant and service accounting legislation that has an option to elect either the plant and service accounting or to pursue decoupling. Evergy, and I believe every other utility in the state of Missouri at this point, has elected the plant and service accounting, so we would not be able to pursue decoupling while we're operating under that legislation.
Given the commission's historical preference for decoupling, in making your application in this particular docket, did you consider decoupling as a possible option for resolution of the issues related to financing?
I think it's fair to say that we would have considered decoupling, LRAM, alternative mechanisms as we were evaluating our plan to put programs forward. I've said this to parties on a number of occasions, and I guess I'll say it here. I think decoupling as a policy decision in Kansas is a much bigger issue than the parties that are in this docket can handle an attack on their own. I think there are many more parties, and it's a much broader discussion than what this docket would allow for.
Now, the settlement agreement provides for a collaborative process to evaluate decoupling. Is there anything in that particular agreement that creates a commitment on behalf of Evergy to institute decoupling in Kansas?
No, there's not. I'm not in a position to make a commitment because we haven't had any dialogue or collaboration about it yet.
Mark.
I can hear her.
Oh, tell her she's not. What's that?
Oh,
Glenda's not muted.
Is Glenda okay?
Yeah, she just wasn't.
yeah, she's technically challenged, but she's okay.
Has your company calculated the revenue effect of growing electric vehicle adoption in Kansas over the next few years?
I think generally, and I think even in our transportation electrification dockets that we moved forward in Kansas a while back, we have evaluated some studies that would consider low, medium, and high electric vehicle adoption rates over a number of years. So I think we have some information like that. I don't have it in front of me, but I think we may have presented it as evidence in our prior transportation cases.
Does the company anticipate growing revenues from the wider acceptance of electric vehicles?
Yeah, I would expect as electric vehicles become more prevalent, we will have more electric revenues to the extent that they operate in our service territory.
If the company were to grow its revenues from EV adoption in Kansas, will you use that to offset the effects of a lost revenue recovery?
No, I think that's inappropriate.
Has your company calculated the revenue effect from the implementation of the Panasonic battery factory?
No, not at a detailed level. We haven't had any substantive dialogue at this point with Panasonic, other than we know the proposed size of their facility.
So you don't know whether or not you anticipate growing revenues as a consequence of that installation?
That's not what I said. I mean, what I said is we hadn't calculated revenues because I don't know what the rate's going to be. But I suspect with the if they bring additional usage into our service territory, it will generate revenues.
And would you use that revenue to offset what the company requests in its lost revenue recovery mechanism?
Well, again, no, that's inappropriate and goes against the performance-based rate making aspects that we've advanced for these programs.
As I understand your earnings opportunity request to provide revenue for the opportunity loss in avoiding generation and other major capital investments, you have proposed collecting 18% of the net benefits associated with energy and demand savings that customers experience as a result of the energy efficiency programs. Is that correct?
That's the way it calculates out based upon the mix of the programs that are part of the settlement, yes.
And based on the ICF survey provided by Evergy in response to CURB data request number 30, is this not one of the highest levels of compensation in the country for an earnings opportunity adjustment?
Yeah, I disagree with that conclusion brought by staff.
Well, what states provide a greater level?
Well, it's impossible to tell from the ACEEE report that is attached to Mr. Grady's testimony and supports that ICF analysis. If you look at that report on page 6, I think, when it talks about that, wait a second. Yeah, I need to go to that report. Hang on, and I'll tell you why I disagree. If you go to page 6 of that ACEEE report, that is the foundation for that comparison. That the authors of that report in the second full paragraph of page 6 indicate that because of the differences in regulatory structures and true up timelines and the nuances in spending and savings data submitted, we cannot make apples to apples comparisons of dollars awarded under LRAMs. So clearly they even identify that data is pulled from surveys, but it can't be used for apples to apples. And the prime example of that is what's referenced in Witness Napoleon's testimony, also included in Mr. Grady's opposition testimony, that refers to Ameren, Missouri, and a 4.9 to 6.2% percentage of benefits. We happen to work in Missouri, so we understand those numbers well. Those numbers were based on a program mix that had a very high set of net benefits compared to today. If you would have converted Ameren's EO as a result of program spend for that cycle, it would have been 23% of program spend, which is quite a bit higher than what we've proposed here in Kansas, and higher than what currently is being run in the third cycle in Missouri for both Ameren and Evergy. So it just goes to show, unless you do the work and unless you dig into each specific circumstance and each nuance, you can draw bad conclusions from a report that clearly says it's not providing an apples to apples comparison.
Well, it's fairly safe to say that an 18% return is higher than your weighted cost of capital. Is that correct?
Those are apples and oranges. Back to the question, those don't equate at all. It's 18% of the net benefits of the programs, which is a completely different metric than a weighted average cost of capital. It is intended and calculated to be an equivalent return to a weighted average cost of capital for a supply side investment or another long-lived investment that otherwise the company and its investors have foregone by instituting DSM. I would agree with you on that.
Okay, out of the 186 million energy efficiency proposal that you've made in this docket as a result of the settlement, what percentage do you expect to gain as a result of the financial settlement for cost recovery?
Well, the gain would be the earnings opportunity. So it's I don't have that math in front of me. It's probably $18 to $20 million over the 4-year cycle. That would be the gain. I mean, otherwise we're getting recovery of program cost and we're getting treatment for the throughput disincentive that if we hadn't run the programs would have otherwise been in our revenues that we earned and in customers' rates because of the utilization of, less efficient, higher kilowatt using systems. So you can't include the throughput disincentive in an earnings comparison. You're really only stuck with the earnings opportunity.
But the lost revenue is a recovery component, is it not?
It's a piece that's required to be added back because you are otherwise not earning the revenue that was provided for based on the revenue requirements that are in place before you put the programs in. So pretty clear. If you go back to the ACEEE report again, pretty clear that the authors of that report would indicate that you shouldn't consider LRAM or throughput disincentive as a cost component of programs. That's inappropriate mixing of the recovery mechanism.
At any rate, if I add the carrying cost, lost revenue, and the earnings opportunity, I come up with a figure of $63,775,857. Is that correct?
Again, that's probably the math of the components you list, but I wouldn't consider those to be earnings from DSM programs. I would disagree with that characterization.
They're set out on attachment 1 of the financing settlement agreement, are they not?
Hang on a second. I'm flipping there. If you just give me a second. And just to make sure, I'm following you, you are simply asking to add the carrying cost, the lost revenue, and the earnings opportunity in the settlement column of attachment 1.
That's correct.
But that looks like the math of those. But again, those are not the earnings effects of the program.
And it depends on the consequence of how we compute lost revenue, whether we use decoupling or some other methodology, would change the characterization as to what the recovery is going to be in this particular docket, would it not?
I don't know that it would change the characterization of recovery specific to the programs, because the recovery for the programs should be based upon the kilowatt hour differences and the benefits. It will change the ultimate outcome of the math of the mechanism, because a decoupling or a partial decoupling with a cap would utilize revenue changes from parts of Evergy's business that have nothing to do with the DSM programs to offset those amounts.
But it might eliminate a rider that's put into effect that allows you to recover more than your revenue requirement, would it not?
I think there's a decent chance with or without a rider that I'm going to earn different than my revenue requirement that the day after it's set. That's kind of the nature of rate making. What it does is it recognizes the impact the way we've produced it, specific to the programs that are going in place, instead of netting revenue effects of different areas of Evergy's business against the impact of these, which my argument is, if you do that, then you are not treating DSM programs under KEEIA consistent with supply side investments, and you've destroyed the ability to maintain that relationship.
Okay, let's move to another subject. Now, as I understand your testimony, you've indicated that your company will not implement energy efficiency programs without the financial incentives that you've proposed. Is that correct?
You want to point me to a specific area of my testimony? I want to make sure the words are right.
Well, there's several places in your rebuttal testimony that you indicate that if you don't get what you're requesting with respect to lost revenue, carrying charges, and earnings opportunity, that you won't do the programs. Do you want me to cite those references, or do you recall them by memory?
Well, I don't recall the references by memory. If you'd like to take me to one, I'm sure that I can agree to the language that's in my testimony.
Bear with me. Let's see.
I found one in my testimony. If it would,
Well, I'm at page 6 of your rebuttals on page 6 of your rebuttal testimony.
rebuttal or the testimony in support.
It says at line 19, this would be a significant indication that once again, Evergy should not move forward with DSM programs in Kansas.
All right, I'm looking, just one second. Page 6, line.
I think it was 19.
And you said rebuttal.
Yeah. But you also make the reference in your settlement.
One second, I'm looking at my rebuttal. Yeah, when talking about my view of the deficiencies in Mr. Hall's limited decoupling proposal in his testimony, I do make the reference that if that were adopted, it would guarantee that we'd receive the cost of programs, but no assurance that we recover the cost. It would be a significant indication, once again, Evergy should not move forward with DSM. And you're correct. I make a related statement on page 10 of my testimony in support of the settlements at the top of the page. And what I say is if the recovery mechanism allowed by the commission in this case doesn't reasonably and fairly address all 3 legs of the cost recovery stool, the program expense, the throughput disincentive, and the earnings opportunity, which are necessary to make investments in DSM programs comparable to investments in supply side investments, then we wouldn't be able to move forward.
And who in your company is making the determination that you shouldn't go forward?
Well, it would ultimately be based on my review of the order of the commission and my recommendation based on that after consultation with the team that's responsible for the programs and Mr. K.S.A, who is the direct senior vice president over both regulatory and the teams that offer these programs. That level of decision would ultimately probably be recommended jointly by us and addressed by the CEO and the senior leaders of this company.
And would that be David Campbell and Kirkland Andrew?
Among the rest of the senior leadership of this team, based on the recommendation likely of myself and Mr. K.S.A.
Does your company anticipate increased transmission investment to accommodate renewable energy and the replacement of older transmission facilities during the pendency of the energy efficiency programs?
I am not aware that we have any increased transmission based upon the renewables transition specifically identified in our plan during the time period of these programs. Much of that increased transmission would likely be identified and advanced by the Southwest Power Pool. And I'm not sure that we have any of those dollars in our plan.
Is that true with respect to the local transmission?
Well, local transmission is not is generally not addressed by SPP, particularly when it's upgraded for reliability purposes, but very rarely does a rebuild or an upgrade to a local transmission facility address the needs of new renewables that come onto the system that ultimately and usually are evaluated by SPP. They're usually for reliability under the existing grid framework.
Let me ask you about this collaborative process. Do you have any idea how this process will be conducted and the schedule of various meetings to assist in trying to resolve differences among the parties?
Yeah, so a couple things. We have a process in Missouri that is called a shorthand. It's called like a Dsm process, where we have a number of stakeholders. I think we generally meet quarterly with those stakeholders in Missouri. That's kind of a broad swipe of folks that are participants and interested in our MIA programs over there. I guess my assumption would be it would operate fairly similarly to that, although ultimately I think it'll come down to kind of the stakeholders. Stakeholders will get together, agree on the collaborative process to work through things, and I would probably quibble with one piece of your question. You talked about to resolve differences. I don't know that with the settlement we have a lot of differences. I think we're working on a path forward and in refinements to plans more than starting out on the gate with a bunch of differences to resolve.
Well, decoupling would be one where we have a difference, would it not?
I don't know that yet. We're agreeing to discuss that and evaluate it. I don't know how any of us can have a difference on it until we understand where each other's at and what the details of it would really look like. We have some people that have expressed that decoupling might be an option at this stage. So if that's a difference, then that's true.
Will you let me know when the company makes a firm commitment to institute decoupling?
It'll be sometime after I have the collaborative process and decide what the real implications of decoupling are.
Do you agree that the KEEIA in section 66-1283, subparagraph C, subparagraph 2, provides for reasonable and prudent costs?
I'm sorry, I was flipping there. Which section were you citing again?
Subparagraph C2.
Sorry, I see a C1A. And then I see a C. My labeling may just be off on my 66-1283. I'm looking for it.
What section are we looking for?
Subparagraph C2, I'm just asking him to confirm that it provides for reasonable and prudent costs.
I'm trying to find it.
Look on page 2.
I'm on page 2.
Should say
I see
CD.
it. So I see a D2. Is that the one where it says the commission shall allow recovery under D2?
It's a C2, I believe. Hang on. C2, the commission shall allow recovery of reasonable and prudent costs associated with delivering commission-approved demand-side programs.
My version of the statute has that as D2, but I see that sentence in what I see as D2. And I believe that statement, and I believe what we have advances is fits within the reasonable and prudent, and certainly well aligned with what stakeholders in Missouri have accepted as reasonable and prudent for over a decade.
Let me ask you a question related to this scenario. A customer buys a 17-SEER air conditioning unit and saves a good deal of money by graduating from an 8-SEER. Based on her savings, she accepts an Evergy promotion and the rebates to install a 240-volt energy charger outlet. Would this result in electric energy savings if she traded in the gas combustion truck for an electric vehicle?
Yeah, there's a scenario there depending on what type of vehicle it is and how much they charge and where they charge. Let's assume for purposes of helping your scenario that they get a full electric vehicle and they charge at home all the time. Hopefully they'll charge off peak, which will be beneficial. I assume they would have increased energy at their location, but the effect of the SEER change would be the same. They would save energy from what they otherwise would have used had they not adopted the higher efficiency equipment.
And your company basically anticipates promoting both EVs and energy efficiency at the same time, does it not?
Yes, I think we are moving forward with electrification, and we are moving forward with energy efficiency, and both have merits to customers for Kansas, no doubt about that.
Let me ask you one final question. I appreciate you indulging me in making this, but there has been much comment about the ACEEE and its Kansas ranking. Attached to Mr. Grady's testimony regarding settlements, JTG2, he's included the ACEEE lost revenue adjustment at page 49. And I'm going to read from the following statement. As structured, Missouri DSIM provide compensation to utilities for lost revenues associated with energy savings regardless of net system demands. Other states have structured LRAMs based on net system energy sales. This raises the question of whether Missouri's mechanisms are too expensive. Have you read that?
Well, I'm looking for the specific language.
Bottom of page 49.
Bottom of page 49. Yeah, I do see that based on Missouri's programs that were in effect in cycle one almost a decade ago at this point.
Thank you. That concludes my cross-examination.
Thank you.
All right, thank you, Warren. We've now been going for another hour and a half. I think we're going to take a break in this cross-examination. Let's take a 10-minute break. Come back at, well, let's round it off, about 2:45. It's now 2:36. We're in recess for 10 minutes. Michelle, could you bring us back up again? Thank you. Denise, are you ready?
Yes, thank you.
Okay, very good. It's now 2:46 and we're back on the record. We'll now continue with the cross-examination of Darren Ives. Mr. Ives, I would remind you that you remain under oath.
Yes, sir.
We'll turn now to commissioner questions. I'll begin with Commissioner French.
Thanks. Good afternoon.
Good afternoon.
I'll be as brief as I can because I think a lot of this ground has already been trod. I guess I was a little surprised at some of the characterizations between Evergy and staff of how far apart you all were, because, you know, it does seem to me that both parties are proposing earnings opportunities. Both parties are proposing mechanisms to handle throughput disincentive. And so I guess it surprised me, you know, to see this characterization that we're, you know, $40 million apart on one and $10 million apart on the other. Let's start with the throughput disincentive mechanism. There's been a $40 million figure referenced. Is that cumulative over the 4 years of the program, or do you know that's not an annual figure? There's no way that's an annual figure, right?
No, it would be, all the numbers that were discussed would be over the 4 years of the program. And, when staff says we're $40 million apart on, throughput disincentive, if you go to that attachment 1 in the settlement document, it says the settlement of the parties on the financial recovery provides for 40 million. So that means staff views that they're providing 0 with the asymmetrical view with a cap, which is probably consistent with Mr. Grady's testimony on page 24 that says they're adamantly opposed to paying for things that may not have occurred. So that cap, the asymmetrical treatment, the organic revenue growth that you have kind of year over year, in staff's approach, it gets used to, pay for the throughput disincentive.
Well, I guess that was my other question is, as I understood Mr. Grady's settlement testimony, they have sort of relented on that, and they have said that cap should accommodate new load growth that can be identified. And I guess my question, one, is that right? And in your view, and two, does that bring that $40 million difference down materially, assuming they are willing to account for load growth?
Yeah, it's a great question. He did relent in his testimony in opposition. He mentions adjustments for identifiable load growth, identifiable electrification, and I think he mentions economic development. There's no real math, no real definition behind just the phrase. So kind of hard to evaluate how we would look at the impacts of that based on anything in the record. It doesn't fix everything, right? Revenues is one piece of the equation, but my view of the world, just to make sure that I've got it out there, is in a historic rate making construct, kind of a historic test year view, your revenue growth that you get from the time rates are set until the next time you come in for rates is generally utilized to offset investments that are being made post that same time and costs that are rising or inflationary in nature that the utility is incurring. And that's what gives you an opportunity to be out for a case. If you're just talking about the revenue piece like staff's adjustment does, and you're using it to offset the throughput disincentive from the DSM programs, well, then it's not available to offset those costs that may be incurred to operate the business otherwise. And you're probably just leading to more frequent rate cases and more frequent adjustments that are non-DSM related, whereas our view would use more of a performance-based rate making approach and specific measures and metrics on the programs to compensate for them.
Okay, I think I understand that. Then maybe one final question specific to the throughput disincentive piece is, I guess I had the same question Mr. Hendricks did as far as, what your position is on the programs moving forward, given different outcomes in the case. And I was specifically looking at page 9 of your settlement testimony. And I thought the answer you gave there was pretty stark at the bottom of the page, line 16. I think the question you asked was, if the commission accepts staff's position on financial recovery, is Evergy able to move forward with its portfolio of programs as agreed to with the other parties in the program S&A? And you just said no. and you've got an explanation there, but you start with a no. So I guess my question relating back to what we just talked about is that specifically related to staff's initial position on throughput disincentive? Or is that encompassing, or anticipating staff's maybe compromised position, or, would staff's compromised position cause you to have to at least do some more evaluation of whether that's a no?
Yeah, so it's a good question. I think back to where we were a minute ago. I don't have a calculation or an evaluation of it yet, because I've really got a phrase in opposition testimony. I don't know how to mathematically apply it and what the agreement would be on how to do that. It makes a difference, right? I mean, if you assumed our perspective was they're at 0 and we're at 40 million, there's a chance that they're not at 0 anymore with those adjustments. So we'd have to look at it, but I think, I didn't anticipate all of those components that he listed. I didn't know that move was occurring at that level. But we're a long ways apart, just to be clear. And if it's 50 million, as asserted in the opening by staff, and probably not far off from what we would agree with, we'd have to have quite a bit of movement, because we have structured our recovery for these programs on 10 years of history in Missouri, and knowing what it takes from our company's perspective to consider these investments to be equivalent to supply side investments. So big movements off of that be very difficult to say we can move forward.
Well, that's all helpful context. Just want to make sure I'm thinking about it right. The only other thing I want to ask you about is the earnings opportunity piece. And I guess I was a little surprised to hear that was a lower figure. But similar to what Mr. Hendricks walked you through, let me just give a recitation of how I understood the dialogue, and then ask you a question. I mean, the way I understood it is, Mr. Hendricks was walking you through a utility company's obligation to provide service efficiently, and I think the commission's obligation to set rates that result in efficient service. And I think you had a response very carefully pointing him to the KEEIA statute that might indicate there's a carve out there, that even if the commission thinks this is the most effective or efficient method of service, they can't actually force the utility to do it, because I think, let me just find it, in 66-1283 little b, it says public utilities shall not be required to offer, implement, or continue demand side management. So it's voluntary on the part of the utility whether they do it. So, I know I'm on a colloquy here, but what I'm hearing is, even if the commission, sees the programs, it likes the programs, it thinks they're morally the right thing to do for customers, but it thinks that the staff financing methods or rate making is most appropriate, it can't force Evergy to implement those programs under those rate conditions. Is that correct?
Yeah, so, I'll probably caveat my answer by saying I'm not an attorney, but certainly have familiarity with the KEEIA statute and the language in there, and the decision we made in the 2016 docket after we got an order out from the commission that didn't meet the needs of Evergy to move forward, or at that time Kcc Power and Light. So I think that's right. I from our perspective, it takes both. We need to have a good, solid performing portfolio programs that has the ability to reach across as many of our customers as we can touch cost effectively. I think the parties have come to a pretty good outcome on that piece and an agreement. And, I would echo what Mr. Nichols said at the start. We've got a good start on programs, and we're a lot farther than we've ever been in Kansas on agreement on programs. So I'm super excited about that. But it takes the recovery piece too. And, it has to work for customers. We heard a couple openings that said, and I agree with them, that the benefits to customers in Missouri have been about 2 to 1 over our cycles over there. And the recovery, the recovery design and the magnitude of throughput disincentive and earnings opportunity in Missouri have been consistently right in line with what we brought to Kansas. We were certainly informed by what it's taken to be equivalent to supply side in Missouri when we advanced this recovery mechanism and these programs in Missouri. And to stray too far from that will make it not feasible for our investors to think it's the best place to spend our dollar to voluntarily put those programs in Kansas.
Well, let me ask the question a little different way, because I'm a little concerned about the interplay of the KEEIA statute and our statute 66-101B that requires efficient service and rates to accommodate efficient service. Does the fact that KEEIA gives the company power to not provide these programs, does that mean that the KCC, in considering the programs, no longer has an obligation to set rates for the most efficient service possible?
No, I wouldn't say that. I mean, what I would suggest is that there's a certain level of interplay between the recovery and the design of the programs that needs to be in place for the utility to consider it equivalent to supply side investment consistent with the intent of the KEEIA statute. My interpretation of a commission decision that either alters the programs or alters the recovery significantly enough that relationship isn't maintained for equivalence to supply side investment, in my view, just means it's a policy decision by the commission that they're not ready to put energy efficiency programs in at the level of recovery that the utilities think meets the statute. I don't think it's inconsistent with the commission's direction. I just think that the commission has decided there's still a gap and things to work on and not ready to move forward under that policy.
I think the last thing I just want to lock down, because I feel like there's been a lot of crosstalk between Evergy and the staff as far as what they mean by equivalently valuing investments. It seems to me that staff interprets that to say the company's shareholders should receive the same equity return on costs, energy efficiency costs, that they would have received if those funds were directed toward steel and ground or plant. The company seems to interpret it differently. The company interprets equivalent treatment as we are foregoing building a new gas plant or a new solar farm or new transmission lines. And so we don't just want the return on the program costs. We want some extra return because our shareholders could have spent some extra money and gotten some more return. And now that's not needed. I'm saying that in jest, but is that essentially the difference of opinion in how Evergy and the staff view the earnings opportunity difference?
Yeah, I'm glad you asked that, because I don't think it came out very clear on my questions and other cross, and I want to try and share my perspective on it, because I think you're right. I think that's in essence the difference of opinion that we have. I alluded to Mr. Grady's testimony earlier. In his testimony in opposition on page 24, he kind of sums up his view on that pretty clearly. He says, staff is adamantly opposed to the idea that a regulated utility needs to be compensated for return on investments that it didn't make. And then he elaborates from there, and he has more discussion about, his calculation of an EO being on the program cost. My view is that they are three distinct steps. The program cost, we get carrying costs on for the time delay until we get the cost back, right? In the settlement, it's short-term interest for 12 months, long-term debt interest for the next 6 months, and then at that 18 months, we get the cost back. So we are fairly compensated under the settlement for the program cost, and then they come back in. The throughput disincentive we've already talked about, and then you get to the earnings opportunity. Well, the earnings opportunity is the calculation of the amount that makes the utility and its investors indifferent to whether we continued on just making supply side investments or whether we made DSM investments. And we know that DSM portfolios, when appropriately implemented, will either eventually eliminate the need for supply side investment, or at a minimum elongate the time before customers would have to start paying for a new supply side investment. And that's what you attempt to calculate with the net benefits that we apply the percentage to put it on an equivalent nature with supply side. So I see it fundamentally different than Mr. Grady and staff. I don't think the program cost has anything to do with the earnings opportunity or the incentive. I think it's the ability to keep the utility investors indifferent to having the programs or not.
I guess I understand that. I mean, that is my understanding of it. I think what I'm struggling with is back with the concept of efficient service. I mean, if as you said, we can determine that the most efficient way for Evergy to provide service to its customers is through a holistic, robust demand side management program. Maybe I'm struggling the same way Mr. Grady is as to why that's not the cost to provide a return on. I certainly understand from the shareholders' perspective, they would like to continue to replace the grid and expand the grid and build infrastructure. I mean, because that does provide increased year-over-year earnings. But from the regulator's standpoint, if we've identified the lowest cost method to serve customers, why is that not just the method that we should ask Evergy to move down, setting aside the provision that we can't require you to move down that path?
Yeah, so a couple of things, right? I mean, setting aside the legislation, right? We're talking about, go back to the opening statements of a couple of parties again that I agree with. We're talking about benefits for customers of at least 2 to 1, doing the programs as we've designed them and as we have said it takes equivalent recovery versus not doing programs at all. So clearly there's substantial benefits unlocked for customers for doing this while still providing recovery that creates an equivalency to the utility and its investors of supply side. When you look at, we've heard discussion today about 18% of net benefits to go to the earnings opportunity. That means 82% of the net benefits are going to all customers. So there's substantial value unlocked there. And then you're looking at your EO and your throughput disincentive in the window of either the program's operating or so the 4-year window, not a 20 or 30-year return on a supply side investment, but a window during the program period. And you're looking at your TD at no longer than 4 years, but it might reset every rate case, which if you had a rate case every 2 years, then your TD is going to reset at that point. So it's that there are some natural sunsets and some caps to make sure that it doesn't run on and perpetuate and create a big windfall, as some parties might suggest in testimony. And there are significant benefits to customers by running the programs without harming the utility by asking customers to use less of our product.
Well, I guess I'm going to restate what I think. I'm going to try to boil it down. I'm really trying to meet you here to understanding concept. I think what I hear is, yes, this may not be the most efficient, lowest cost method of doing this, but it provides incentives to do something that is beneficial or puts downward pressure on costs. And so in an overall sense, that's the argument that it's acceptable. I mean, am I boiling it down?
Yeah, I mean, I think if you look at the ACEEE reports and the things like that, they say this is not the natural mode of operation for traditional utility, right? To go out and spend a few dollars to have customers not use their product and not provide revenues back to the business. So there needs to be an incentive structure, and those reports talk about 3 legs of a stool and cost recovery, and whether it's decoupling or an LRAM or any other alternative mechanism, they're all trying to get to the same outcome, which is what is the right level of incentives to unlock these benefits for customers, the 82% of net benefits in this case, without putting the utility in a perverse role where they're trying to undermine success of the programs. Makes us indifferent to them versus just continuing supply side investments.
All right, I believe
that's a long-winded answer to what I think you summarized well.
Thank you.
Commissioner Duffy.
Thank you. Good afternoon, Mr. Ives.
Good afternoon, Commissioner Duffy.
Yes, and I agree. COVID is not fun. Let's follow along this discussion you've been having with Commissioner French. I kind of liken it to when, let's just say in Storm Uri, when my electricity was turned off for, I don't know, close to 4 hours. Okay, I didn't pay for it during that time, but you should reimburse me for the fact that I had to put on a couple of extra layers and there was some discomfort in our household. And by the way, there were 3 people there that day, so each one of them should be reimbursed. I mean, I kind of feel like the way you're approaching the reimbursement part is extreme. I mean, I see program costs and yep, you should be paid, But is it really in that threshold of, well, we didn't put steel in the ground? Is it really that much of a threat to your investors that they lost out on an investment? I mean, it's like, I do believe it's in degrees. And the fact that in the plan, there's reevaluation built in. I mean, it's not a forever. There's a collaborative experience that will be going on. There's a purported review after a few years. So you claim you're using your experience from Missouri, but it just seems like it's almost for a monopoly greedy to be at this other end of the spectrum.
Yeah, so I don't think that's a fair characterization. You know, we to your point have run these programs for over a decade in Missouri. We have identified and worked with stakeholders from the commission through the staff, through the consumer counsel office to third parties like those that are in this case in Kansas, to come to an outcome that produces $2 of benefit to customers for every dollar of the program. It operates under this mechanism. It wasn't developed on its own. It was developed over a decade ago, very similar to the one Ameren uses over there, based on our utilities' collective reviews of how energy efficiency is implemented and deployed in a number of states in the country. We're not an outlier. We're not asking for anything unusual. All of these entities, these ACEEEs, everybody talks about the three legs of stool for recovery, the throughput disincentive that needs to be addressed, the opportunity to address a performance incentive or an earnings opportunity, and the opportunity to get your costs recovered. That's what we're doing. We're doing it consistent with a lot of third-party help and support over a decade plus experience in Missouri, and it is unlocking benefits, as you heard in openings from CEP and NRDC, to customers in Missouri that we're not unlocking in Kansas because we're hung up on these mechanisms amongst a group of parties.
Okay, but when we look at the actual dollars of how far apart we are in the scheme of things, is that, from your standpoint, is that significant?
Absolutely. You're asking me if $50 million is a significant number over 4 years of program implementation? Significant enough that my investors would tell me that we're not very good stewards of their dollars if we spend them on something that's going to be $50 million less beneficial than just going over to Missouri or someplace else and spending them where they can get a recovery that's equivalent to a supply side investment.
And I respect that you do report to your shareholders. So what about all those people who have already made the switch to more efficient light bulbs, who, well, the other night I was going to make a cake. The other day, I waited till the end of the day, 9 o'clock, before I put it in the oven. One, I didn't want to heat up the kitchen any more than it was, and wanted to be more smart about what I'm doing. Or I left this morning and jacked up the thermostat to 80 degrees, which, yeah, do all the time, you're losing money right there because of actions I'm taking on my own. So how come you haven't come in and asked for those savings to be?
Yeah. So a couple things. You're right. We have an obligation to our shareholders. I've heard that a couple times over the course of today, including in some opening statements. I would remind the commission that we also have an unwavering obligation to serve our customers and to do it reliably and affordably. I mean, that's part of our role and what we need to do in front of this commission and demonstrate all the time. That said, to your specific question, why haven't we come in? Because some of our customers have raised their thermostat temperature or used their appliances at night. We're not incenting those customers to do that. That by definition, these programs that we have in front of you today is the commission saying that we should pay rebates and put incentives in place to ask people to use less of our product, to ask Kansans to use less electricity than they ever would have because we're paying the incentives. That's why we're asking for the full three legs of the stool, which is very different than any individual action. I mean, for a customer like you that turns their thermostat up to 80 and does the right things, there's probably a neighbor across the street that turns it down to 68 because they like to sleep in a chilled room at night. I mean, we're not incentivizing that behavior either. It is just the nature of different human behaviors, which is very different than instituting commission-approved programs to change behavior.
Okay, in Missouri, in the 10 years that you've been operating the MEA program, how much steel would you have put in the ground had that not been the case? Or a plant built or whatever? How?
Well, when you look at the IRP and the IRPs are, I mean, they change for a lot of factors, right? Energy efficiency is one of them. And Mr. Nelson probably could have given you a perspective on that when he was on the stand. But you can clearly see when you run a set of DSM portfolio programs that persist across a 10 or a 20-year time horizon of an IRP plan, you can see that the need for capital build for supply side moves out or moves completely off of the planning horizon as you start to demonstrate success in the programs. We'll get there over the long haul, right? Because you're building, in essence, with these types of programs, you're building a virtual power plant where you're trying to save enough kilowatts and kilowatt hours that you don't need to go do the next one. So you can see it in the planning horizon, but to give you a direct answer, I'd be trying to prove and value a negative because we never built it, right? I could show you the plans that say how much it moved because of what the model says we're achieving on these plans. And Mr. Nelson certainly could provide that information.
Let me refer you to your testimony and your rebuttal. It's on page 5. You talk about at the bottom, Evergy's proposed TD methodology being used in other states. So besides Missouri, where else?
Yeah, so the I'm not the expert in the cross-state studies, but the ICF study and the ACEEE reports that are in this docket, and I think reference somewhere between 16 and 17 states that use a structure of LRAM to deal with throughput disincentive. There are slightly more states listed in the report that use that use a decoupling methodology. So, and I think we might have introduced as an exhibit in today an updated ACEEE report for 2020. It also has the information in there. It says 17 states use LRAM. I think 22 or 23 use decoupling. So those are states I'm referring to, are the
Okay.
LRAM states.
All right, real good. Thank you. I will look there. On page 13, when, let me see. If this is in the, well, throughout your testimony, you've talked about the collaborative process and partner agencies. So can you put a little bit more meat on the bone about this collaborative process that's going to occur? I'm really trying to understand, or, you know, are we in a room, pillows, and we're on the floor and we're talking about what's transpired? I mean, or is this more fact-based and reviewing data? I mean, what is the collaborative process?
Yeah, so I hope it's a little bit of both. Maybe not pillows on the floor. That might be awkward. But you know, when we're having a quarterly DS Mag or a set of discussions, you know, we should be talking with stakeholders not only about what's going on with the programs that we're operating and implementing, you know, how are they being adopted? How are the results coming along? How are we progressing towards our targets that are set out for the 9 programs in our settlement that we're advancing? We should also be talking about the future, right? There's a piece, we spent a lot of time talking today about the language around decoupling, and should we be discussing the potential for decoupling or other alternative mechanisms to future resolution to throughput disincentive. But we should also be talking about what's going on in other states. What are we seeing for programs that are moving the needle and making a difference in Minnesota or Michigan or someplace like that? And how do we work towards, you know, evaluating and considering those, if not in this 4-year window, for what we might advance when we come back to the commission for cycle 2 for the next 4-year window. So I hope it's all the above, right? Some future, some data review of the current, and some, you know, kind of evolution of success of DSM in Kansas.
So I'm assuming when you come back in 4 years, it will be similar to this experience again, or what was it like in Missouri? Was it just kind of like a light, like coming back and just hitting the high points? I mean, how do you see that when you come back to the commission in 4 years?
Yeah, so in Missouri, I would say it's relatively similar. You know, we're in our 3rd cycle over there. I would say we have very active dialogue when we advance a filing, be it for cycle 2 or cycle 3. Stakeholders engage before the filing. They also engage after we make the application with the commission. You know, all of our stakeholders, not surprisingly, have certain special interests in certain programs that mean more to them than others, and they'll advocate for, you know, bigger budgets or more dollars or different programs to meet their interest. And so we'll go through a very similar process to this one. We have found, while we debate about levels of throughput disincentive or levels of earnings opportunity or how the measures are applied, the core construct has become fairly well defined in Missouri for the 3 components. It's just how do we value them and what's the right program mix to get us where we need to be from cycle to cycle. So they're not they're not rubber stamps. They don't go through without quite a bit of back and forth with stakeholders and evaluation of their proposals, and almost always result in the commission having some decisions to make in order to move forward in a new cycle.
So in Missouri, as you look at your low income folks, at what percentage are your programs geared towards either multifamily or single family low income?
Well, we've made a little bit, I don't know that percentage off the top of my head. We've made continued movement to have more programs available for multifamily and low income as we've moved from cycle 1 to cycle 3. So I don't know if it would be 15% of our programs at this stage or somewhere in that range. But each time we come in, we continue to get good feedback and dialogue from consumer advocates and Department of Energy over in Missouri and others that bring opportunities and ideas for multifamily and low income. It's one of the things we made good progress on in the program settlement here in Kansas. It's in front of the commission. Got some good feedback from Curb and others that allowed us to have a few more dollars and more of a focus in the programs than we had initially come in with. That'll be part of the collaborative as well as we move forward, is how do we continue to impact the right populations of customers with the right level of programs to benefit all, but certainly, low income and energy burden customers in Kansas as well.
I was really disappointed to learn that HUD just won't strengthen their landlord requirements so that folks who live in the homes from these landlords, sometimes it's very substandard. And the choice is with HUD, do we tighten up the requirements and make them more onerous and therefore perhaps lose some folks in being landlords and with the supply of housing so tight? So where does the company stand on understanding that the envelope that the person lives in, if it's clearly substandard, these programs that you're talking about are almost nonsensical in a way?
Yeah, I mean, it's a tough question, right? I mean, we certainly have some opportunities and some ability to make some progress with weatherization and some of the basic constructs that are going to help the general envelope of the house, right? Some of that, to your point, super necessary before you really even think about going to the next stage. But there's also some ability with the settlement that we advanced through the PACE program to reach and impact multifamily or tenants and have some ability to have the not only the tenant but the owner engaged in that process. So it's probably not a great answer, and it's not an easy answer, for all the reasons that HUD or others would identify. But there are some opportunities for sure with weatherization and other facets of the program to reach that population.
Well, do you feel that as that's part of your company's responsibility, as your folks see a lot of this every day? Do you feel any sense of responsibility of advocating for maybe more adopting guidelines, national guidelines for counties, or updating the statute requirements for housing standards. Do you see that your company has a role in any of this?
Well, so you used a couple terms there: role, responsibility. I mean, I think somewhere in that phase for sure, right? I mean, we spend a lot of time working with community agencies for the benefit of customers, be it something as simple as, putting them in touch with federal funds and relief funds that can help them pay their bills. I think we've got some testimony, and this docket or one of them that I'm actively involved in right now that says, within the last year or so, we've put customers in touch with like $67 million worth of bill relief funds from community and federal agencies. So certainly that's part of our role. We are certainly engaged with communities throughout our service territory on a host of fronts, but we're probably not the only people involved in that process for sure.
Okay. Let me ask a kind of a completely different question. On your smart meters, is the brain there completely within the smart meters in the state of Kansas? My understanding is the smart meters have been deployed, correct?
That's correct.
So are they up to the standard they should be for you to communicate, receive information, data? Are they primed at that level?
Yeah, I mean, with limited exceptions, we have a handful of customers that still don't have our smart two-way communication meters. Certainly actively continue to work on those. And then you have some large customers, large businesses that don't operate under that meter construct. They have other systems in place, right? But other than that, yeah, we have our meters installed. They're two-way active. They're tied into our meter data management systems to capture data at short intervals, tied into our billing system. Super excited to have that done in Kansas, and we'll continue to add value to customers by having that.
Okay. Let me go back to low income. It's my understanding in talking with folks who work in the housing industry for low income folks that most of the housing for these folks, the rent payment includes the utilities. Okay. So how specifically, for example, in multi-family housing units, are you going to make a difference if I'm living in and I'm paying $1,400 a month, and a lot of that's coming from HUD payments, and that includes my utilities, which is basically water, electricity, and gas. I'm cranking that puppy up, or I'm cranking it down, because that's not my problem. So have you seen, like in Missouri, your program more focused on these multi-family dwellings, trying to work with the owner / landlord?
Yeah, so I'm a little bit out over my skis. Probably would have been a great question for Mr. File. He understands our multifamily programs and their impacts really well. But that said, I think you're right. I think we found that it's important to figure out how to engage not only with a tenant, but to engage with the owner or the landlord, and make sure that if we're making a difference with an installed measure, that benefit is flowing to the tenants, not just, sitting there and being absorbed at the owner or landlord level. So that's part of what the construct of those programs and the dialogue of our program administrators and program design folks is intended to do, is try and make sure we're reaching the intended residential customer.
Okay, so I think it's going to require, when you've got folks working in Missouri, hopefully their experience will be able to translate well to Kansas. So I've got one more question for you. The pilot incubator program, who really benefits from that? I just never really, in reading all the material, I still felt it was very foggy.
Yeah, so the way it's worked in Missouri and the way we would have envisioned it here is that's where we get to explore and consider and think about some of the things that come out of the collaborative process. That's also how we can do some research, and we can do some high level pilot work to bring to the collaborative process to see that if that's going to bring forward the next program that's going to benefit low income customers in this way, or business customers in this way. So it's a focused attention on continuing to move the portfolio forward over time by having that.
You really think you guys, I mean, to me, it's almost like establishing like this research arm. And I believe it was in someone's testimony, isn't that what the labs are for? We've got 12 labs throughout the nation. We've got a whole bunch of folks who are doing work this way. Wouldn't we all be better off by using those resources first?
Yeah, so those resources are all super important, right? I mean, that's good ground level information that gets done at the labs, and good feeder. I'll call it feeder stock for what we could look at for future programs here. What the labs don't do is think about all the things that might be necessary to consider to implement that program in Kansas, based upon statutes and rules and requirements and standards that are in place in Kansas versus a lab environment, or differences that might be in place in Missouri for those same things that would affect a program that looks the same by name, but may have to be implemented and executed differently depending upon the state policies and regulations. So that's part of what we will be able to do with that too.
Okay, but that's pretty well been rejected by everybody, right?
Well, I'm gonna have to go back and look. I think there's a little bit of money in the program plan for certain aspects of the pilot, but not nearly at the level that was proposed in direct.
Okay. Well, I appreciate your answer, Mr. Ives, and I do believe in a way we're coming up to this game late for a variety of reasons over the last few years, but I still feel like maybe it's something we kind of want, and therefore you got us over a little bit of a barrel, and you're just like, let's just stick it to them. And I kind of felt that way in reading some of this, especially some of the testimony from the Evergy company. So thank you very much.
I would like to respond to that we have designed it very similar to what's been in place for 10 years in Missouri. The legislations are very similar. We've got anybody over a barrel. It's based upon success and performance in Missouri, both from construct, from magnitude, and in large part in program design. So I apologize if it felt that way, but that is not the reality of what we put in front of the commission.
Okay, well, thank you very much. And thank you, Chair Keen.
Hey, Darren, I have one question. Without any inferences, without any hint or suggestion of any motives or anything else, my review question is this, and I don't proffer it to try to be too simplistic, but doesn't one of the ultimate questions here really involve a determination of what degree of opportunity costing is Evergy willing to forego or accept? Let me state that otherwise. To assist in accomplishing certain energy efficiency goals, is Evergy willing to analyze and consider circumstances and trade-offs where its actions may not always optimize or maximize profitability at the margin of every activity? Question mark.
Yeah. So I think I understand your question.
Let me slightly rephrase it.
Yeah.
If years ago we were talking about the Coca-Cola company and Roberta Goizeta was the chairman of the board, they had opportunity costing down to the lowest level, all the low levels within the company in an effort to ferret out inefficiencies and bring about basically profit centers from the lowest levels to the more integrated levels. So actually what I'm asking you is that these trade-offs that the company is going to make, you're going to make a series of trade-offs, and where do you put investment dollars? Some are going to give you greater rates of return than others. But what I'm asking you is that with respect to energy efficiency goals, isn't the company really willing to analyze some of these trade-offs in the sense that it would not always optimize or maximize profitability at the margin of every activity? And I'm not saying that in a way where I'm trying to mousetrap you with respect to the fiduciary obligation you owed it to your investors.
Yeah. So I think that's a fair question, and I think I think every program's created a little differently, right? And I think it's developed in the design of the programs. I mean, there are some programs that are based more on education. They're based on different metrics and measures than I'll call it a full energy efficiency program. Like let's use LED lights, because we heard today that they demonstrate quite a bit of kilowatt hour savings over the life of a program. So some programs don't do that, right? And parties make a decision that it's still the right thing to do, either for low income or for residential education or whatever it is. But when you're thinking about it on a more global scale, I wouldn't call it maximizing profitability. I would suggest what we're trying to do is ensure that the policy of the state under KEEIA statute is maintained, which says it should be treated equivalently with supply side investment. That's what we think we've done with the settlements that have been proposed in this docket. Will we continue to refine programs and refine recovery metrics and measures as we move from cycle 1 to cycle 2 to cycle 3? Absolutely. I mean, we've seen that occur in Missouri as we get better data and more data and parties continue to be engaged. But the general construct is certainly in line with what we see across the country in order for states to unlock energy efficiency benefits.
Thank you for your answer. I have no further questions. Ms. Kafer, redirect.
Thank you. Mr. Ives, can I be heard okay this time?
So far.
Okay. I'd like to start here with these questions about the company's responsibility, obligation for providing service in an efficient, reliable manner. And the statute that I know you're not a lawyer, but you're familiar with, the 66101B. Is your understanding that requires you to provide service that is efficient and sufficient?
Yes, it is.
And is there only one way to do that?
No, I mean, that statute's been in effect for a lot of years probably, and programs have changed, and the way we provide service and the method that we provide supply has probably changed several times, stating that we would have to do it through a minimal cost approach probably would be some sort of stretch of that statute.
And when Evergy is making its business decisions, it's been very clear on the record today that you have to consider your stockholders' interest, and nobody questions that. When you make those decisions, do you also consider your customers' interests?
Absolutely. I mean, you can look at our strategic plans and our board discussions and our external discussions, and we talk about communities, we talk about customers, we talk about shareholders, and we talk about employees. And you have to consider and balance all four of those constituencies, in my opinion, at least, and I think in Evergy's, in order to be successful over the long haul.
So with a decision like energy efficiency, when you do that balancing and you find that these types of programs that you're proposing here, they have net benefits for your customers in Kansas, that determination is made, you still have to balance the interests, your other interests with your shareholders, correct?
Absolutely. And I would say I haven't been involved in all these, but we've been attempting to advance energy efficiency programs in Kansas since roughly 2004. At least since 2011 in my tenure. We're not doing that because it's only good for Evergy. You could read the public comments in this docket. We're doing that because it's good for Evergy. It's good for our customers. Our customers are interested in it, and it benefits over the long haul. All customers can be demonstrated, has been demonstrated in Missouri and a number of states.
So, the path you have chosen to try and bring these net benefits to your customers involve the filing of these cases over and over at the commission to try and get a path set where you could provide those benefits to the customers. Is that correct?
Yes, that's correct. And informed based on, I know I sound like a broken wheel, right? Informed based on over a decade of successful history in Missouri, both from a program standpoint and from a cost recovery mechanism standpoint, demonstrated to provide significant value to customers. And, in one more year, we'll be going in for cycle 4 over there. So hopefully we'll have continued success, but absolutely.
And did you also lead the way, in fact, maybe even provide authorship on the KEEIA statute that was adopted in 2016 in an effort to try and get these to your customers?
Yes, absolutely. I was actively involved with that legislative session, and that statute, which is built off of the foundation of the MIA statute in Missouri, based upon the success that both Ameren and Evergy had demonstrated for customers in Missouri.
So Evergy hasn't just sat back and done nothing in this area, correct? I mean, you've been very active in trying to try to get these benefits to your customers in other ways when you've been unable to get the programs and the financial recovery aspect of it approved at the Kansas Commission the way it was in the Missouri Commission. Is that correct?
I would suggest that we've been as active as anybody in the state trying to move energy efficiency forward in Kansas, be it by legislation, be it by submission of programs to the commission. We certainly have been, I think I told somebody in Kansas, I feel like I've been knocking my head on the door for a while in Kansas. And I guess the only thing else I'd say about that is I'm super excited about this docket. We're really close. We've got a program agreement, and we've got most parties with agreement in front of the commission on financial recovery. We have never been this close before.
And you were asked about the lost the TD, the LRAM, that whether or not you credit customers when there are increases in your revenue resulting from the programs. Do you remember that question?
I do remember that question.
And I just want to make sure that your answer is clear on the record, because I couldn't tell at the time, but I understood what you said is that has to be evaluated on a portfolio level, and within that evaluation, those increases are netted against the decreases. Did I understand that correctly?
Yeah, I mean, I think probably fair to say evaluated at a program level that'll roll up to a portfolio level, but yes, if there were individual customers that had a business exchange that was not like for like and had an increase in electrical usage, overall that program would deliver electricity benefits at a program level, and those things would be netted together. So it would be accounted for and factored in the analysis. I don't know if I clarified it anymore or not. I tried.
I think you did. Thanks. You were also asked about the audit process over in Missouri that's been ongoing. That's an annual process. Is that correct?
That's correct.
And the question concerned whether or not there's been a recommendation for, I think they said a 12% reduction in your savings estimates for your home comfort program.
Yep, I remember the question.
Okay. So with that having been ongoing since the MIA programs have been in place, that type of activity, is that the type of thing that Evergy has tried to explain is then rolled back in or factored back in to the savings and information and data that you have, that with every passing year and audit, that data becomes even more reliable because we gather more information in that way?
I would say that's the process. I would say specific to that question, I would just reiterate that I think we filed a response maybe yesterday indicating we don't agree with the results of that audit, that staff initial position. So we don't know yet what the final determination is going to be on that, but whatever it is, it will be factored in and considered in our TRM and our measures prospectively.
Okay, and that was my point, was the process itself, however it comes out, is then fed back into the system to help improve the reliability of the savings estimates that you use. And now Kansas is benefiting from that as a result of what's gone on in Missouri up till now.
Correct.
You were also asked about concerning the Missouri process, the level of administrative costs. Can you tell us what types of expenses are included in administrative costs?
Yeah, I think, depending on the docket over there, because definitions have continued to evolve over time, but administrative costs are, kind of the labor incurred in administering the programs and the oversight of the programs and the relationship with the implementers. It is the core fundamental costs that I would say aren't marketing and education, and they aren't the incentives costs that are being paid out. It's the administration of the labor and the system cost to keep the database in place that I had discussions about with Mr. Flaherty earlier on in the day. So more true administrative cost.
You were also asked about whether or not the 90-day time frame would be sufficient for the commission to conduct an EMB audit. Can I refer you to page 15 of your settlement testimony? You there?
I am.
Under section C there, it summarizes the evaluation and approvals aspect of the settlement agreement. Starting on the second line, it says that the EMB methodology will be submitted to the commission for expedited approval. Is the methodology for that different than the actual auditing EMB process?
Yes, it is. I appreciate you you pointed me to that. I was not tracking, not finding a reference as I was talking through that question. But yeah, the methodology and the work to kind of set out how we will address EM&V is the component that the agreement calls for expedited treatment, not the actual EM&V process or the review of the output of that EM&V.
Staff's discussion of their wanting to put a cap on your throughput disincentive, and that cap being the revenue requirement authorized in your last rate case. If that revenue requirement authorized was $200 million in your last rate case, does that mean that you're receiving $200 million in revenue every year, after the rates are set?
No, I mean, it certainly could be higher, could be lower, impacted by a lot of factors, whether it be some of the stuff that Mr. Grady referred to in terms of economic development or load growth or electrification. Could also be due to weather, could be reduced due to COVID, could be reduced due to anything in that regard. So the one thing we know when you set a revenue requirement based on a historical test year is your go forward revenue will not match your revenue requirement that you set.
And along the same lines, you were asked about the rebuttal testimony of Mr. Grady that was included with his testimony on the settlement agreement. Do you remember those questions? It concerned his compromise position that he's making.
I do.
Is that the first time you've heard of that compromise position?
At that level of detail, in terms of the components, yes.
And so I'm clear, you indicated that didn't alter the company's rejection of his concept of putting a cap based upon your last revenue requirement. Is that correct?
It does not. I told Commissioner French that I don't have a specific calculation to know how different it makes me think about the throughput disincentive with a cap, but I know that it still is moving away from performance-based rate making on these programs that I think we have the information and the specifics to do in the state of Kansas and that we've done for years in Missouri. And I think it's still, even with the adjustments, utilizes revenue changes from all the other aspects of our business, minus the carve outs that he has now included, to offset the throughput disincentive that's created by adoption of the programs. And I just don't think that's appropriate or consistent with the KEEIA statute.
And last question, but Commissioner Duffy asked you questions about the pilot incubator program. Can I refer you back to your testimony on the settlement agreement, page 15? Again, same place we were before. The budget for that was reduced by 80%. So I believe that was offered at $7.1 million in the filing. The reduction of 80%, does that take it to approximately 1.4 million, somewhere around there? Am I correct in that?
That sounds in the range to me. I know it was significantly reduced. In fact, I know that there were some parties that were concerned that it was going to become meaningless if we got it too small in terms of evaluating future potential programs. So hopefully we hit the right balance.
And then the second paragraph there under the pilot incubator, that was an additional commitment that Evergy made to use some of that $1.4 million for some actual concrete efforts that were important to some of the parties in this docket. Is that correct?
Yeah, absolutely. I mean, I think, certainly agreed to by all the signatories to it, but yeah, it's came up in discussions. It made sense. It made sense to Evergy for sure to have that as part of the agreement.
I have no further redirect. Thank you.
All right, thank you very much. Darren, I think we've reached the end of your testimony. We do appreciate so much your testimony. You've been on the stand for quite a bit. At this time, you are excused and you may stand down. Thank you.
Thank you, Chair Keen. Thank you, commissioners.
Be safe. We've been going now for about an hour and 20 minutes. Let's take a 10-minute break. We'll take a recess now. It's now 4:05. We'll take a recess until 4:15. We're in recess.
Hello. Hi. Just 1 second.
All right, Michelle, let's bring it up. We're back on the record. It's 4:16, and we're going to resume with the examination of witnesses. Our goal today is to try to conclude, I guess, the testimony we're going to take today at about 5:15, if that's possible. So we're moving right along. Mr. Flaherty, would you call your next witness?
Yes, thank you, Your Honor. The gas utilities would call Paul Robb.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Can you state your name and business address for the record?
Yeah, my name is Paul Robb, and my business address is 5313 Portsmouth, PORTSMOUTH Road, Bethesda, Maryland, 20816.
Mr. Robb, did you file direct testimony, cross testimony, and testimony in opposition to the program settlement on behalf of the gas utilities in this docket?
Yes, I did.
Do you have any changes or corrections that need to be made to that testimony?
I do not.
If I were to ask you the questions in that testimony, would your answers be the same today?
Yes.
Mr. Chairman, I'd ask that Mr. Robb's direct testimony, cross testimony, and testimony in opposition to the program settlement be referred into the record.
Are there any objections? Without objections, they're admitted.
Thank you. And I would tender Mr. Robb for cross-examination.
Very well. Good afternoon, Mr. Robb.
Good afternoon.
Let's proceed with cross-examination. We'll begin first with Evergy and Ms. Kafer.
Thank you. Good afternoon, Mr. Robb.
Good afternoon, Ms. Kafer.
I'd like to take you first to page 5 of your direct testimony.
I have that.
Okay, and up there on lines 4 and 5, you're talking about a program that the gas companies still have concerns about, and that's the inclusion of the new construction component of the whole business efficiency program, correct?
Yes.
And now if you would look at the partial settlement agreement on the DSM programs, do you have that in front of you?
I do.
Now on page 3 of that document, under section B, program offers, little a, little I, that does state that we removed the business new construction component, correct?
Yes.
And now if you would go to your direct testimony on page 24.
I have that.
And beginning there on line 2, you say that, you actually are talking about transparency here in the process. And you say that this requires all parties, including the gas utilities, to have full access to Evergy's energy efficiency database that documents at a minimum. And you talk about what it documents. Would you,
yes.
You're with me there about, okay. Then in the settlement agreement on page 8,
I'm there.
okay. Towards the top under the little VII, the Roman numerals, talks about providing, Evergy has agreed to provide access to those program tracking databases. Is that correct?
I don't see that specifically here right now, but I am aware that it's in the settlement agreement. Yes.
Okay, I'm on page 8 of the settlement agreement at the top. There's a little VII. It's the second item up there. Starts with provide stakeholders access. It's the settlement.
I'm there and I'm on page 8 and I don't see it. I certainly am aware that it is in the settlement agreement and as it was in the settlement agreement, at least prior to implementation, it's something that is certainly acceptable to the gas utilities.
All right, thank you. That's all the questions I have. Thank you, Mr. Rob.
Thank you, Ms. Carey. Next up, let's see. Yes, Ms. Woody.
No questions, thank you.
All right, thank you. Mr. Zakura.
No questions.
Thank you. Mr. Astrad.
One moment. Yes, I have a few questions. Thank you. May I proceed?
Yes, please.
Thank you. Hello, Mr. Rob. Can you hear me okay?
I can.
Hi. Thank you. Good. My name is Joseph Astrab. I'll be asking you some questions about your recommendations to the commission here, okay? First, I want to talk with you about the recommendation to include a like-for-like provision. Can you tell us briefly what you're intending that to look like in this portfolio if the commission were to approve adding that requirement?
Well, I would think that we have the model for that in the in Evergy's filing with respect to the residential programs. We're not asking for anything more than they have agreed to put in their program filings for residential programs. We think that the commission has previously ruled that that like-for-like provision applies to both residential and non-residential programs. And so all that we would request was the same language in their filing and now in the settlement agreement that restricts the payment of incentives to a like-for-like incentive payment.
Okay, thank you. So it's your understanding that the settlement agreement and the tariffs proposed there have already established an example for a like-for-like provision to be moved over into the business side, correct?
Correct.
Okay, so with this distinction between the residential and the business type programs for the like-for-like requirement already existing, you'd agree with me that the budgets and the cost benefits analysis and calculations there are considerate of the different level of, I guess, participation that may result from a like-for-like requirement in the business section?
Well, I'm not sure I would agree to that. I think the company, when we have questioned them with respect to the fuel switching aspects of the commercial program, they say they don't anticipate any. So what I would argue is that we can include that provision. It will have no impact on participation, according to the company. It will have no impact on their budgets. So I don't understand why it is such a difficult provision to put in. And it doesn't need to change anything else about the settlement agreement.
Okay, so it's your opinion today that if the commission includes a like-for-like provision on the business side of their portfolio, that there be no change in any of the cost benefit analyses that was done for those programs?
Well, it's not my opinion alone. It's what the company has told us.
Okay, thank you. I have no further questions.
All right, thank you. Ms. Messentine.
Staff has no questions. Thank you.
All right, thank you. Let's see if you have any questions from the commission. Commissioner Duffy.
I have no questions. Thank you.
Thank you. Commissioner French.
No questions. Thank you.
All right. I have no questions either. Mr. Flaherty, any redirect?
No redirect, Your Honor.
All right, very well. Mr. Robb, I believe your testimony has reached an end. We appreciate so much your appearance here today, and you are excused and you may stand down. Thank you.
Thank you, Your Honor.
Ms. Woody, if you would, please call your witness.
Commissioner Keen, we've talked about this with CEP, and because their witness has some time constraints, if he could be put on first, we would both appreciate that.
Well, let's see if that'll work out.
In other words,
I'm sorry. Wait a minute. Wait. Okay. Well, let's see if that will work out. We will try to accommodate that. Okay.
Appreciate it.
Mr. Laughlin, would you please call your witness?
Thanks, Teresa, and thanks, Chair Keen. CEP will now call Mr. James Owen.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good afternoon, Mr. Owen. Will you state your name and your employment for the record, please?
My name is James Owen. I am the Executive Director of Renew Missouri, appearing here as a witness on behalf of CEP, the Climate Energy Project.
Thank you. And are you the same James Owen that filed, or who caused to be filed on June 17th, 2020, 43 pages and 3 attachments of direct testimony in this docket?
That sounds right. Yes, I am.
Okay. And do you have any corrections to make to your direct testimony?
I do not.
Okay. And if I were to ask you the same questions contained in your direct testimony today, would your answers be the same?
They would.
Okay. Given all that, I'd like to move for the admission of direct testimony of Mr. James Owen.
Is there any objection? Without objection, it's admitted.
All right. Thank you. I'll now tender Mr. Owen for a cross-examination.
Very well. Good afternoon, Mr. Owen.
Good afternoon, Commissioner.
Let's begin with the gas companies. Mr. Flaherty, any questions?
No questions. Thank you.
All right. Mr. Zakura, any cross-examination?
No questions. Thank you.
Thank you. Ms. Mezzantine, on behalf of the Kcc staff.
We just have a few, Chair Keen.
Go ahead.
Good afternoon, Mr. Owen.
Good afternoon.
Did you believe that if CEP did not support the financial settlement as Evergy proposed it, that Evergy would pull the programs completely?
I was not asked to advise on that particular issue. I couldn't say for sure.
Are you familiar with the provision of the settlement agreement? And I believe that is in the program agreement, in which the parties have agreed to collaborate to discuss alternative recovery mechanisms in the future for energy efficiency programs?
I am aware of that provision, yes.
Do you consider that portion of the settlement to be a commitment from Evergy to shift to decoupling at some point in the future?
I understand that it's going to be considered in future discussions. I don't know if that would be a commitment to decouple or not.
Okay, thank you. I have no further questions.
Thank you.
Thank you. Let's see if we have any questions from the commission. I'll begin this time with Commissioner French.
Well, I guess this is a question. I'm curious, for all of the signatories to both agreements, for those that signed on to both agreements, I guess I'm just curious what your thoughts are on the KEEIA legislation and the fact that the utility has the ability to basically not implement the programs that I think you all are interested in, and that there's a lot of interest in for Kansas under that legislation if they don't receive the financial mechanisms they think are necessary And what do you think we should do about that legislation?
Well, Commissioner, to the extent I did not offer testimony on the financial on any of the financial issues of this, but CEP did sign off on it, knowing that that was necessary for the programs. I mean, what I can speak to is, for me, our group, Renew Missouri, that I run, and also my previous experience as the Office of Public Counsel for Missouri. I was the public counsel for Missouri. I have worked for 6.5 years with Evergy on their MIA programs. I have seen their commitment to that, their diligence to that. I believe that they have, they have worked to those statutory obligations in this state. I don't know why there would be any reason they wouldn't. I certainly know that in terms of the decoupling issue, that is, I'm aware of what decoupling, I'm aware of the statute and how that operates in Missouri. But, I can just only go off my experience in showing what this company has been able to do and believing that they would be in good faith and trying to reach an agreement on that to make sure it happens.
Okay. That's kind of an unfair question.
Oh, I don't think it's listen, I think it's a legitimate concern for the commission. All I can speak to, in addition to just my background and my knowledge, is what my experience has been on what I consider to be a very similar statute here in Missouri and how successful that's been.
Okay. I appreciate it. Thank you. That's all I have.
Thank you.
Commissioner Duffy?
So I don't think it was an unfair question at all, Commissioner French, because that is the heart of the matter. Even though you may want something so badly, if the cost of it appears to be excessive or irresponsible, then I think it does give everyone pause. And apparently your answer, Mr. Owen, is that you believe there's tremendous value in this program?
What I have seen in Missouri and what I believe can be accomplished in Kansas, I do believe there's tremendous value to it. Yes, Commissioner.
So do you believe the needle has really moved in Missouri over the last decade?
I think, and I talk a little bit about this in the testimony I provided about the number that we've seen of reduction in carbon, the equivalent of 42,000 cars off the road, the amount of investment Evergy has placed into MIA programs, hundreds of millions of dollars. I believe, and I'm sincere with this. I don't take money from Evergy. They can tell you I have been opposed to a lot of things they have asked for over here, but I do believe it has made a significant difference in Missouri. I do.
And it seems like I'm beating the bush for low income, but I am, because I believe that too often we talk a lot about it, but in the end, these people a lot of them are trying to get through the day to connect themselves from point A to point B, to get to a job and get home. And maybe it's several jobs throughout the week, and they're exhausted. So there are gradient levels of benefit, I believe. So with the knowledge that you have about the Missouri program, how do you believe it's moved the needle for those on the low income side?
Right. And no doubt, these are folks that often are left out of policy considerations. I'm very glad the Kcc is looking at that. It's certainly something that, Renew Missouri, not just as a renewable energy or energy efficiency advocate does, but we are very actively involved with almost every IOU case involving low income programs. With having said that, we have advocated for funding. We're looking at close to $60 to $65 million in funding to low income programs in Missouri in the past several years. Now, I understand throwing money at a problem is not the only solution, but those have to be implemented properly. Those have to be conducted properly. One of the criticisms I had of Evergy in my testimony was, I believe they should restructure how they're delivering these funds to people. I still maintain that. That's a challenge we're having in Missouri with Evergy. It's a challenge we have with all the companies. I mean, you look at, I would love to see more co-delivery between electric and gas companies in regards to their low-income programs. I know there's going to be an influx of money coming from the federal government now with some of these new legislation that's been passed or will be passed. And I think that's going to even be harder to implement. I mean, I certainly think it requires vigilance on the behalf of the stakeholders on this, on this call right here, right now, to continue working on this, to make sure these problems are brought to the attention of the commission. That is something constantly done in Missouri. I certainly think Evergy can speak to the fact that we are very critical of how those are done, how that's delivered, whether it's showing meaningful benefits to those customers. And I think that's just going to take a lot of effort from everyone here to make sure that the decision makers, all of you, know about this and that we are offering solutions to this. I mean, I think that what's been proposed, what we've tried to modify through the settlement discussions, those are only as good as what the people here, make happen. Everything looks good on paper. As you know, those devils are in the details, and those have really got to be tended to. So certainly, I can't, my personal experience, I can't speak to what it's like to be a low income customer. That's not my life now. It used to be when I was younger. But certainly I know that it's something I take very seriously, and I believe that everybody here is. And I think that, the conversations we've had over the course of this proceeding has shown that there's a lot of people that are concerned about that as well.
Thank you. I think your testimony was spot on. I don't think you need to apologize for anything. I do believe a one size fits all is not here in Kansas. What will work in Wichita may not work in Topeka, may not work or complement what's going on in Kansas City. Mm-hmm. And I do think that takes extra effort for everyone to really get in that collaborative process, the right people around the table who deal with this daily. And I think that was my frustration in a lot of the testimony, is that I feel there is still a disconnect, that my concern is the right people won't be around the table. The ones who live this every day with their clients and have a reason to be at the table because they understand practically what will work, as we may look at poverty as intergenerational, or as I found out, a lot of folks came into poverty because of medical bills.
Yeah.
And there was no magic to bail them out of a situation, and or through some illness, mental illness, or whatever that came about. So I appreciate your comments. I appreciate the involvement of folks who really desire to take a situation like this and make the most of it to benefit all. So thank you. That's all I have, Chair Key.
Thank you.
Mr. Owen, I have no questions. Mr. Laughlin, do you have any redirect?
Yeah, just a few questions on redirect, Chair Keen and the commissioners. Going back to staff's question regarding the collaborative process lending itself to decoupling in the future, would you agree, Mr. Owen, that decoupling or any other sort of method, such as Missouri's plant service accounting method or anything like that, is not off the table for future methods that the company may implement for cost recovery purposes?
I think that, the more encompassing those conversations are, the better. I mean, certainly I know some of those could require legislative fixes, and that's a whole different conversation. That's kind of outside the purview of what's being, what we can solve here. But yeah, I think everything should, I think that you've got a lot of talented, smart people that can sit around this table. And I think, foreclosing on any ideas would not be helpful. So yeah, I think you should consider everything.
Okay, and then my final question, thank you for that, is, how can you explain how MIA interfaces with housing advocates in Missouri? I know there were some questions about that earlier, and I'd just like to see if you could touch on that briefly.
Yeah, of course. In the past several years, an organization called the National Housing Trust has intervened in most of the energy efficiency cases in Missouri. They are an entity that works on low-income multifamily housing around the country. They've submitted expert witness testimony. They have been actively engaged with the legal arguments, with briefing, with the process. I find that perspective is helpful. We do have consumer groups that are specifically geared towards low-income customers. The Consumer Council of Missouri kind of takes that focus. But we also have, we have energy efficiency collaboratives in Missouri where we meet on a periodic timetable to talk about how energy efficiency portfolios are doing, the ones that have been approved, how they're doing. In Missouri, we have utilities who present their anticipated portfolios in advance, where these stakeholders can help, identify issues before those get filed before the commission here. And certainly I find that collaborative process, I find that transparency, and obviously it's not a public process because you have to have NDAs and that sort of thing. But for those of us who have been engaged with these cases excuse me, that was very bad, that they are engaged and making sure those things are in as good a shape as they can be before that goes through the very extensive process of, approval by regulators.
So would you, and I lied, I had one final question. So would you tend to agree that collaboration with these advocacy groups is important moving forward in Kansas as well?
I just simply cannot imagine looking at the kind of programs being proposed here and not getting that perspective, not being able to look at the realistic problems that face, not just the low income housing or, the poverty advocates that we deal with, but also talking directly to those customers. I mean, again, to the commissioner's point, they are just trying to get by day to day. They don't have time to sit in through a bunch of meetings, but, trying to get their perspective, trying to be creative in that. We've tried to have a number of, and I know that CEP has done this as well, trying to get people to come speak at times, which is convenient for them, and trying to get their real stories, to get those anecdotes that, while they don't have, empirical value, certainly do have value in trying to understand what people are, trying to go through, and what this needs to be done to make it easy. I think so many times we have so many well-intentioned, meaningful ideas that we don't ever think about, can this actually get the people that it needs to help? So yes, I absolutely think they need to be involved with that process, of course.
All right. Well, thank you, Mr. Owen, and no further questions from CEP.
All right. Thank you very much. Thank you, Mr. Owen, for your testimony. I believe this concludes your testimony. We appreciate very much your appearance here before the commission, and you are excused, and you may virtually stand down. Thank you.
Thank you, Commissioner. Everyone have a nice day.
Ms. Woody, I see that Mr. Colton is here. Is it timely for you to call him as your witness at this time?
Yes, Chair King, we'd like to go forward with that.
Please do.
Sierra Club and Kansas Appleseed call Roger Colton.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter not hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good afternoon, Mr. Colton.
Good afternoon.
Mr. Colton, could you please state your name and your employment for the record?
My name is Roger D. Colton, Colton. My employment is I'm with the firm Fisher, Fisher, Sheehan, Sheehan, and Colton Public Finance and General Economics out of Belmont, Massachusetts.
Thank you, Mr. Colton. And are you the same Roger Colton who caused to be filed direct testimony in this case on June 17th of this year that included several tables, several schedules, and 3 appendices?
I am.
And are you also the same Roger Colton who caused to be filed cross-answering testimony in this case on behalf of Sierra Club in Kansas Appleseed on June 24, 2022?
I am.
And the same Roger Colton who caused to be filed testimony in support of both the program and financial recovery settlements on August 3, 2022?
Yes.
I would move the admission into evidence of the direct testimony, cross-answering testimony, and testimony in support of the settlements, along with all attachments and appendices as evidence into the record.
Very well. Is there any objection? Without objection, they're all admitted.
Thank you. I tender Mr. Colton for cross-examination.
Thank you very much. Good afternoon, Mr. Colton.
Hello, Commissioner.
Let's begin first on cross-examination. Mr. Flaherty.
No questions, thank you.
Mr. Zakura.
No questions, thank you.
Thank you. Ms. Mezzantine.
Yes, we have a few questions for Mr. Colton. Good afternoon, Mr. Colton.
Good afternoon.
When considering whether or not to sign on to the financial settlement agreement, was there a fear by Sierra Club and Kansas Appleseed that if they did not sign on to that financial recovery agreement, that the programs would not be implemented by the utility?
If there was that fear, it was not expressed to me. The decision on whether to sign on to the 2 settlements was, of course, made at the client level, not at the witness level.
And are you familiar with the provision of the settlement agreement in the program agreement, in which the parties have agreed to engage in discussions in the future regarding decoupling or other alternative recovery methods?
Yes, a collaboration. I would say a collaboration goes beyond discussions, but yes.
So do you perceive that provision then to be a commitment by Evergy to ultimately move from lost revenue to some alternative mechanism such as decoupling?
I don't think there was a commitment by Evergy or any other party to move to any particular cost recovery. The commitment was to engage in good faith, a good faith collaboration, and we'll have to wait to see what comes out of that collaboration.
Thank you. Mr. Colton, do you have a copy of your, let's see, I want to make sure I say the right testimony. Do you have a copy of your settlement testimony in front of you today?
I do.
Okay, turning to the bottom of page 11 of that testimony, and I'll wait till you're there.
Okay, I'm there.
Okay, I am looking at a sentence that starts at the end of line 21, where you state that Evergy has agreed to make recommendations to the commission regarding decoupling mechanisms and or alternative methods to support energy efficiency at least 12 months prior to the end of the present portfolio's term. I'm stating that correctly?
I see that sentence.
Do you believe that statement is factually accurate?
Is it factually accurate? Yes.
I'd like to go ahead and pull up the program settlement agreement. I'll share my screen here for ease of reference. And where I'm looking, just so everybody can follow along, is it is section 2 of the settlement agreement, subsection B, and then going down further into subsections, it would be C, little c. Are you there, Mr. Colton, or can you see this okay?
Yes, I'm looking at it on my screen.
Okay. So it looks to me like subsection C dictates that Evergy and the stakeholders will make recommendations to the commission on elements of the benefit cost analysis. Is that correct?
That's the first thing in that first sentence, yes.
Okay, and then the next sentence says the recommendations will also be made regarding modeling transparency within cost effectiveness calculations, TRM, new construction, cost recovery, and compensation. Is that correct?
Yes.
And after that, it says the goal will be to present such recommendations at least 12 months prior to the end of the 4-year term of the present portfolio. Is that correct?
I see that.
Has anything leading up to the mandate to present recommendations thus far mentioned decoupling or alternative recovery mechanisms?
Can you repeat that question again?
Sure, I'm happy to. Has anything leading up to that mandate to present recommendations thus far mentioned decoupling or any alternative recovery mechanism?
Sure. I mean, it talks about cost recovery and compensation.
But does it specifically discuss any other type of revenue recovery? I mean, what I'm seeing it discusses cost benefit analysis, and it also discusses modeling transparency within cost effectiveness calculations and modeling transparency within compensation. But does anything specifically leading up to that mandate to present recommendations mention decoupling or alternative revenue recovery?
No, no, I believe that sentence in the middle that you just read, where the collaborative will also consider, and you go down and you see both cost recovery and compensation, is, I think that supports what I said in my testimony.
Would you agree, though, that it's only after the recommendations have been mandated that then the last sentence of this subsection appears where it specifically mentions decoupling and or alternative methods?
I'm going to object to this. This question is being asked and answered, and the document speaks for itself.
I would disagree with that. I think what he answered at the first question was that his perception is that his testimony accurately reflected what the initial 2 sentences say. My question now is whether or not decoupling is mentioned specifically only in the sentence after we talk about recommendations.
Same objection.
Oh, fair enough. Overruled. The witness may answer.
I think the word decoupling mechanism, those 2 words clearly on the face of the document first appear in the second to the last line of the paragraph we're looking at. I think it is not possible to look at the phrases cost recovery and compensation without believing that those words include decoupling.
Mr. Colton, the only time decoupling is explicitly mentioned in this subsection is in the very last sentence, in which Evergy agrees to collaborate to consider and evaluate decoupling methods or alternative mechanisms. Is that correct?
I just said that a few minutes ago. The first time those exact words appear in this paragraph are on the face of the document. You can see in the second to the last line of the paragraph we're looking at.
By second to the last line, okay, I'm sorry, I got a little confused. You're not referencing the second to last sentence, correct? That begins with the goal. You're referencing the second to last actual line, which begins with the word consider.
Yes.
Okay. And so you would agree, at the very least, perhaps we could agree with the fact that decoupling and or alternative methods to support energy efficiency are only explicitly mentioned in that last sentence.
I would agree that the words decoupling mechanisms and or alternative methods first appear and exclusively appear in that second to the last line. When you say explicitly mentioned, I think when cost recovery and compensation, I'm repeating myself here, but when cost recovery and compensation is talked about, I think that that's an explicit reference to different cost recovery and compensation mechanisms.
But it does not explicitly say that.
No.
I'm not sure what you're asking that's different from what you asked a minute ago.
Well, I understand it is your opinion that the terms cost recovery and compensation may encompass decoupling and other revenue mechanisms, but that's not explicitly listed there, is it? It's only explicitly listed in the last sentence.
I agree that the words decoupling mechanisms and or alternative methods appear only in the second to the last line of the paragraph that we've been looking at. Yes.
Okay. With that, I have finished my questioning. Thank you, Mr. Fulton.
Could you remove the screen share, please?
Yes, Chair King.
Let's see if we have any commissioner questions. I'll begin with Commissioner Duffy.
Thank you. Good afternoon, Mr. Colton. So I really enjoyed the depth of your testimony in terms of your variety of proposals for programs and how data can be used, particularly low-income data, and how that you seem to kind of quantify and put together some very interesting thought processes related to taking energy efficiency programs to their best level. So what success have you had in your work throughout the United States that you can point to that says, hey, this did work here?
Oh my, that the answer to that could take a while.
Okay, so if you had to name communities where you believe they have done it really well, your top three, where would they be and who are they?
Oh, that's a relatively easy question. New Hampshire. There's a collaborative process that includes everybody to talk about how energy efficiency could and should be delivered to low-income households. And in New Hampshire, it's electric. New Hampshire doesn't have gas utilities or doesn't have significant gas utilities. The second place would be Pennsylvania. New Hampshire, I work for the commission staff. I probably should disclose that as I go along, so I will. Pennsylvania, I work for the NSUCA office, the Office of Consumer Advocate, and Pennsylvania has what's called its LIURP program, LIURP. It's Low Income Usage Reduction program. And in Pennsylvania, we have moved beyond the question of whether utilities should fund low-income energy efficiency. Listen to me, Pennsylvania has moved to really address some of the the nuances. So this morning before I joined this hearing, I was involved with a Pennsylvania conversation about that addressed in part multifamily housing and whether, and there's a tension in serving multifamily housing because the belief is that the biggest potential for usage consumption is with high use households, but multifamily housing, because units tend to be smaller, they don't tend to be the highest use. They may be the least efficient, but they're not the highest use. And so we need to figure out how to resolve that tension. In Michigan, I think I attached two of the recent settlements with DTE and with Consumers Energy, where we are now talking about how the utilities will not only geo-target areas within their service territories based upon the highest need, but will also target low-income households based on the need as presented by payment patterns, disconnects, arrearages, both the size and the age of arrearages. And 2 years ago or 3 years ago, we wouldn't have been having those conversations. That's a big advance. And then finally, in Wisconsin, and I promised I wouldn't talk all day about this. In Wisconsin, we're going through the Quad 4, what's called the Quad 4 review at this point. The Quad 4 is where the Wisconsin Commission considers the efficiency investments that will be made. In Wisconsin, utilities provide the money to the state, and then there's an independent administrator for everybody's money. Not each utility doesn't have its own. And so the conversation I had last week in Wisconsin was whether to expand the definition of low income to 60% of state median income or 80% of area median income. And what are the pros and cons of those? So the question of whether to do low income and whether low income should be substantial isn't a question in any of those four states. We're really dealing with how do we best deliver low income efficiency.
And I think your geo-targeting example was extremely valid. And I think there's a lot of synergy to be had when you are focusing that way. And so I read with interest your testimony. And I would agree. I do believe the examples you've shared, folks have gotten beyond those initial steps of low income, and it's how do we make it work best? And it seems like there are very collaborative processes going on that involve getting a variety of people active in the community. And that's why, like with housing experts, public housing, private housing, I just believe they know their clients, they know the reality of the situation, boots on the ground, and to leave them out of the conversation, you may be missing the whole point. So can I ask you, in those states, have they made progress on ensuring that the envelope of the house is, in terms of the efficiency of the house when it's built or it's rented, meets a higher standard?
Well, there are two ways to look at that. One is if you look only at new construction and whether the utilities provide incentives at the time of new construction. And there are some utilities do that and some utilities don't. One of the other questions presented by that, and it's a question you had asked earlier today, if it's appropriate for me to refer back to that, is the extent to which utilities become involved at the administrative level to say that when you have LIHTC, low income housing tax credit properties, whether there should be higher energy efficiency standards or whether higher energy efficiency, meeting higher energy efficiency standards would push you up the list of receiving tax credits. Tax credits, of course, are very competitive, and there aren't enough tax credits to go around. And in Pennsylvania, for example, that you are more competitive. You get bonus points if you meet enhanced energy efficiency, and the utilities can be involved with that without funding it. So there are different ways to make sure that new construction is, or publicly subsidized construction addresses energy efficiency. You always have to be careful to make sure that, for example, when you're dealing with housing authorities, that the bill reductions you generate through energy efficiency don't get taken away from the residents by having the utility allowances then reduced by the housing authority. But that's a manageable issue to deal with, a manageable proposition.
Very good. Thank you, Mr. Colton. I appreciate, like I said, I appreciate your testimony.
Thank you.
Thank you, Chair Keen.
Thank you. Commissioner French?
Thanks. I just asked one question, and similarly to the last witness, it's going to be about our KEEIA statute, as we say, and you don't need to know a lot about it other than the fact that it's got this piece that we've talked about that allows the utility to basically withdraw the programs if they don't like the commission order. Let me just say, I'm looking at your testimony on the settlement, and I'm specifically at page 11, and I agree with a lot of what you're saying here, that Kansas residents need these programs. They need the benefits that they provide. There's a moral duty to provide some of these types of programs to certain low-income and disadvantaged communities. But I do want to talk about, the at what cost issue. And, you lay out here at the bottom of page 11 that there will be this collaborative process. And, I guess I'm taking away the idea is, look, this financial settlement we have, that's sort of the asking price. That's what's required to get these programs jump started. And those are the incentives that are necessary to get Evergy to, start implementing this. But we're going to have a process, and we're going to look at alternative cost recovery mechanisms over the next 3 years. With some sort of proposal being made 12 months before the end of the cycle. I guess the question I have is, as long as the legislation stays in place that lets Evergy sort of veto changes in their programs or commission orders, won't we just be back in the same position 4 years from now if all the stakeholders, absent Evergy, say, oh, here's a better or lower cost way to provide this service, and Evergy says, well, we like what was in our settlement and what we're currently using. I mean, won't we still just be back in the exact same place 4 years from now, having to choose between continuing the programs at sort of a rich price, or potentially looking at having the programs yanked away from our residents?
I need to, I don't mean to dodge your question here, but if your question is based on my experience, is there a better way to do this? I would say yes, for the reasons that you said. To the extent that the question is, does the legislation need to be changed, or does Kansas Appleseed and the Sierra Club believe the legislation needs to be changed? I would have to say that's a client decision.
I thought you might say that.
It's, I am a witness and not a spokesperson, if you will, for Kansas Appleseed and the Sierra Club.
I guess my question, I don't mean to cut you off. It's actually kind of looking at it the other way. It's assuming the legislation does not change. And under that paradigm, even though we have this collaborative process, you would agree that we could very well just end up sort of back in the same position 4 years from now, right?
I think it's possible, but I think I've been involved with any number of good faith collaborations that really do work, even though the potential that you just laid out has been maybe not this exact issue, but presents the same potential that the utility could walk away at any point, or the utility could say, could make any collaborative effort a non-starter from a practical political perspective. But the collaborations that I've been involved with in New Hampshire, Pennsylvania, Wisconsin, Michigan, have really truly been good faith collaborations.
Well, thank you. I appreciate the context, and I won't keep you any longer. I think you may be an hour ahead of us, so it's really getting into the evening for you. So thank you. I appreciate it.
Thank you, Commissioner.
Mr. Colton, I have no questions for you. So I'll turn back to Ms. Woody. Do you have any redirect?
Just a few questions. Thank you, Commissioner Keen. Mr. Colton, do you recall the language that you were looking at in the settlement agreement, the paragraph, I believe it's 2B, then little c under that?
Yes, I couldn't have told you the numbers, but yes, the one that was up on the screen earlier.
Yeah, and did you review the settlement agreement and all of its provisions?
I did, in preparing my testimony, yes.
And when you read that paragraph, was it your understanding that with that 12 months before the end of this present cycle, this portfolio cycle, there would be a recommendation made to the commission about the second cycle going forward?
Yes.
And was it your understanding that that recommendation would include some discussions of decoupling or other mechanisms and alternative methods to the LRAM that's being proposed now?
Yeah.
And in that procedure, would it be your understanding that again, this would be something that the commission would weigh in on and have the final decision on? Is that correct?
Of course.
And let me ask you sort of a little bit of an analogy here. Are you familiar with the Affordable Care Act?
The Affordable
Care Act, Obamacare.
Oh, sure.
Okay, and
yes.
And you recall that there were some folks in Congress who very much thought they wanted to repeal that after the administration changed, correct?
Yes.
But that never happened, did it?
That's correct.
And would it be your conclusion, would it be fair to say that once a popular program is in place, it's very hard to take away that program or change it in a significant manner?
Oh, I think that's a popular opinion. I don't think you can just say that across the board, but I think it is often more difficult to take away something than it is to start it.
Thank you.
And I would agree with.
Okay, thank you. I have no further questions.
All right, thank you. Mr. Colton, I believe this we are at an end with your testimony. We appreciate very much your appearance before the commission this afternoon. You are excused and you may virtually stand down.
Thank you, Your Honor.
Thank you. I believe we've reached the end of the proceedings for today. I would remind everyone that we still have 9 witnesses ahead. And toward that end, we will take up first thing in the morning at 9 a.m. The first witness up will be Mr. Titus will be your witness on behalf of the NRDC. So until 9 o'clock, we will see you. Bid you adieu. Have a good evening. We are in recess.